Adjournments, page number 12, seal number 31 to 40.
You've taken time on 3 occasions. You file it, I'll take it up in.
Page number 13, seal number 41 to 46. Page number 14, seal number 47 to 50.
That's serial number. No, 2012. Finally, don't ask for time again.
15.
But serial number 50 मिला था यहाँ पे for respondent number 3. Senior is not keeping well मिला. Your Lordship may kindly have it Monday or Tuesday मिला.
Petitioner, no objection, my lord. They have informed. My lord, in this case, interim order is there. One time it is missed out, so we filed application for extension.
Tomorrow to continue to.
15th. Seal number, page number 15, seal number 51. Page number 16. Seal number 52 and 53.
List.
15.
List.
15th. Page number 17, seal number 54 and 55. Page number 18, seal number 56 and 56 to 59. Page number 19.
Serial number. List.
15. Page number 19, seal number 60.
My lord, serial number 60. SC matter, constitution validity has been challenged.
2008.
8 matter, 2, we have filed amendment application that came to be allowed. Now the recent amendment is also challenged. That matter is been,
Post along.
please.
Page number. Page number 20, seal number 63 to 66.
List.
15th.
CP. CPN. Please wait.
Fresh matter, seal number 1, Shri A.V. Amarnathan.
What is wrong with the order of the Deputy Commissioner?
Matter should have referred back to the because before the AC judgment they remain expired.
You are the grantee. Application for resumption was granted in your favor. In the appeal, you entered appearance or did not enter appearance?
If I have they remade the documents.
The appeal was against the order, not against your documents. What is the reason given?
Against the dead person's artist part. And here the DC order is also there are 2 persons expired because they have not gotten. Even the AC being down the PTCL. The respondents remained active because one respondent died.
No, on the merits, the Deputy Commissioner has found that prior permission was granted.
Yes.
Then what remains? Deputy Commissioner has recorded a finding that prior permission was granted. How can you invoke PTCL Act?
Also is verified.
Records in month prior permission ide ashte. The prior permission is obtained and the property is alienated. You can't make an application for resumption. Some record, VN record tandro because permission is granted. It is a granted, the fact that permission was granted means it is a granted land. And for alienation, the government had no objection. It has been alienated. What is your? Whatever it is, the government, Samarnath, the government granted permission. They are NC matter. You can't invoke PTCL Act. Bad and bad. No matter what document you produce, you can't get over the fact that permission is granted. And bad. ಇಲ್ಲ ಮಂಡೇ ಅಷ್ಟೊತ್ತಿಗೆ ಪರ್ಮಿಷನ್ ಸಿಕ್ಬಿಡುತ್ತಾ ರಿವೋಕ್ ಆಗುತ್ತಾ ಮಂಡೇ
Number 2. Dhruva Reddy.
Appeal for respondent number 3. For respondent number 3.
what is the finding?
The grant was in the year 1931, according to them. Alienation, first alienation was in the year 1950. There were 7 sale transactions from 1950 to 2006. The petitioner is the purchaser in the year 2006. After 31 years, from the date of the act, the claim was made.
And R2. Interim stay of all further proceedings.
Praise times to file objections.
4 weeks time is granted to the third respondent to file
For
objections.
respondent number 3.
4 weeks to file objections. Stay till then.
See number 3, Shri Chandrasekhar.
It's purchaser's writ petition, my lord. The grant was made on 29/2/1972. The petitioner, the fifth respondent filed a petition after 21 years, 21 years before the third respondent, Assistant Commissioner, my lord.
CGP to take notice for respondents 1 to 4. Issue notice to R4. Interim stay as prayed for.
For preliminary hearing. See number 4, Shri Seshadri NS.
Your grant is in the year 1955, my lord.
For the
Grant is-
purchaser of the grantee.
My lord,
You are a purchaser grantee.
grantee, my lord,
Grantee.
grantee, my lord. Grant is in the year 1955, my lord, with the lowest Kimat, it's very, in the lowest Kimat, and the property has been alienated after the completion of 10 years. And now, since I'm the financially background, I request this honorable court, I appeared before Assistant Commissioner without findings dismiss my appeal, my lord,
Without?
petition, my lord.
Without?
Findings is not given. They were just said 10 years has been complete. After completion of 10 years, the property has been alienated. They dismissed my petition and I went appeal also dismissed. Hence I'm before this honorable court to.
What is wrong? The alienation was made after the prescribed period.
Well, but the
Made
grant
before-
is
Alienation was made before the act came into force. What remains?
grant is for
The writ petitions by the grantee challenging the refusal of the assistant commissioner in accepting his application for resuming resumption and also by the order of the deputy commissioner which confirmed the rejection of the resumption application by the assistant commissioner. The findings recorded by the assistant commissioner and deputy commissioner are that the land was granted in the year 51,
55.
55,
55 months.
with a period non-alienation for 10 years. And the grantee had alienated the land after the expiry of the said period of 10 years on 10/7/69. So the authorities have therefore taken up the view, have taken the view.
Granted for upset price, madam, 14 rupees. we have.
The authorities have therefore taken the view that the provisions of the PTCL cannot be invoked since there was no alienation made in contravention of terms of the grant. So in my view, there is no infirmity in the orders passed by the Assistant Commissioner and the confirmation of the said order by the Deputy Commissioner. Petition is therefore dismissed.
Seal number 5, Shri Raja Ramesh.
For the petitioner, my lord, during the pendency of the matter before respondent 1, my lord, the government brought an amendment to section 5 of the PTCL Act, my
You are granting a purchaser.
grantee, my lord. In that amendment, my lord, it has lifted the period of limitation, my lord.
What is the,
Annexure-
did you, what happened to the, your application?
It is rejected by the respondent 2 and 1, my lord.
Why?
During, there is gazette notification on 27/7/2023, my lord, by which amendment to section
Ah.
5,
First tell me the facts. What was the date of the grant? When did you alienate?
75, date of grant 75, my lord. Father of the petitioner sold the property on 17/3/1997, sir. Please, my lord. Then after the decease of the father of the petitioner, the petitioner filed the application before the village accountant. The same was forwarded to the Assistant Commissioner, my lord.
When,
Application, my lord, 2018 and 19.
12/11/2018, the Tahsildar sent the report to the Assistant Commissioner. And Assistant Commissioner passed the impugned order, rejected on the ground that it is delayed, my lord. Then petitioner filed appeal before the Deputy Commissioner, my lord. On 27/7/2023, my lord,
ಏನ್ ಮೇಡಮ್ ಫೈಂಡಿಂಗ್ ಏನು?
Gazette notification.
My lord, this may not be appropriate, my lord, authorities. Because
Ge-
court
ge-
permission is not.
Amendment
Sale has taken place, my lord, 17/3/1997, my lord.
70,
After act came into force.
ಇಲ್ಲ ಅದಕ್ಕೂ ಬರಲ್ವಾ?
section 5,
They wait for 25 years.
Now,
section,
latest amendment, my lord, even, my lord, this delay comes only prior to the act, my lord, here.
Necessarily.
section,
17/3/1997, my lord, act.
You also did not take any steps for 25 years, quarter of a century.
period of limitation ತೆಗೆದಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು ಅದರಲ್ಲಿ. Gazette notification period of limitation.
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ?
Challenge ಮಾಡ್ಬೇಕು sir.
ಅದರಿಂದ ಒಂದು ಸ್ಟೇ ಕೊಡ್ಬೇಕು ಸ್ವಾಮಿ ಅವರೇ.
ಏನ್ ಬರುತ್ತೆ?
ನೋಡಿ ಸ್ವಾಮಿ ಅವರೇ.
Accepts notice for respondents
I'll take it.
1 and 2. Issue notice to R3 and R4.
It may be stayed, my lord.
Your application is dismissed. What is there to be stayed?
Please, my lord.
Seal number 6, Shri Sumantel Bharatwaj.
CP seeking transfer, sir, weeks time maybe granted, will take steps.
You served notice on the council appearing for the.
Please,
respondent.
sir, I will do it.
Order ಆಗಿದೆಯಾ?
No,
And the payment of process fee. Petitioner is directed to serve the copy of the petition on the respondent. Why can't you serve?
I will serve, sir.
Counsel for the petitioner seeks a week's time to pay the process fee and also serve the counsel who appears to respond to the trial court. So the petition shall also inform the respondent to his counsel that the matter will be taken up for disposal on so and so, released on,
Interim order may kindly be.
promoted continue.
15th. Seal number 7.
My lord, I appear for petitioner in this case, my lord. After negotiation, my lord, the parties have filed 13B petition, my lord. It will be settled next week, my lord. Your lordship may have it next week, my
I'll
lord,
close
next
this
Friday.
matter. Why do you want it to be transferred now that it is settled?
Agreement is
service-
still not drafted.
Huh?
Agreement is still not drafted, my lord. It will posted next week, my lord.
No, but I'll close this petition. Why do you want to keep this pending?
Please, my lord, it can be closed.
Since the mediation report states that the dispute between the husband and wife has been settled, there would be no need to entertain this transfer petition. So petition is therefore dismissed as unnecessary, and the parties are directed to abide with the terms of the settlement.
Please.
Seal number 8, Shri Shiv Shankar K.
Appeal for the petition. It's transfer petition. That's already notice has been served on the respondent and also merits the council.
Acknowledgement ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ವಿ.
ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಅವ್ರದ್ದು.
Chandrasekhar ಅಂತ bloods, the party name has been shown, but the advocate has not filed wakalat. It's earlier minutes,
When did
the
you
one
serve on it?
petition has already been transferred to.
When did you serve on it?
It's
ಎಲ್ಲಿದೆ ಸಿಗ್ನೇಚರ್ ಇದೆ? ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ ಅದು ಲಾಯರ್ದು.
it's, I mean, served on the council, it's the
Show me the
latest
signature.
council.
ಸಿಗ್ನೇಚರ್ ಇದ್ದಂಗಿಲ್ಲ.
The party go also notes the notice has been served on the.
This acknowledgement ಇರ್ಬೇಕು ತಾನೆ?
Is
Weeks
it-
time is granted to pay the process fee and also furnish acknowledgement if any for having served the copy of the petition on the respondent or his counsel before the trial. Signature ಇಲ್ಲ.
list.
15. Seal number 9. Sumanth L. Bharadwaj.
Similar order as a serial number 6, my lords, I will serve the confusion, my lords.
6 ಎರಡು connected ಇಲ್ಲ?
No, no, my lords.
6 and 9 same order.
Obligation.
Seal number 10. Vivek Anand Brito.
Pursuant to orders of this court, my lord, I filed an impleading application, my lord, to bring on record the beneficiaries in this particular will, my lord. That application may kindly be allowed, my lord, so I can bring the beneficiaries on record.
Has notices gone on that?
Lord, not yet, my lord. The application has to be, Lord, I am impleading them. They will file, they will be come on record themselves, my lord. I will bring them on record. If this application may be allowed,
There
sir,
are a few objections
please,
in the application that you have filed.
my lord, that is the powers of attorney have not been filed, my lord. When they come on, when I file wakalat for them, I will file the powers of attorney along with that, because all of them reside outside the jurisdiction of this court. So they'll be represented by a power of attorney holder.
No, on what basis you are saying that they have a power of attorney holder? I think you are claiming to be a power of attorney holder, isn't it? Of the,
Please, my lord, the petitioner will be the power of attorney holder of all these beneficiaries. They're all his nephews and nieces.
you are the power of attorney holder of the petitioner here.
Yes, my lord, and I will be the power of attorney holder also of all the beneficiaries.
No, but until you produce the power of attorney holder, how can we entertain the application? The affidavit is not by the petitioner.
The affidavit by the petitioner, my lord. Petitioner wants to implead these people. That's a,
The affidavit
that's a
is
mis-
filed by the GP holder of the petitioner.
Please, my lord.
If you produce a GP holder, we can accept you.
No, that GPA has been produced. The office objection is I have not produced the GPA of the people I want to implead. That is my error, my lord. That's my mistake.
It only says power of for attorney copy to be furnished and original the same is furnished for verification.
My lord, on my application, my lord, on the last page of my application, I have written all represented by the power of attorney holder. That power of attorney has not been submitted.
Where have you produced the power of attorney that you have in favor of this?
No, that's
Paul,
not been,
my-
that's not been submitted. If this application may be allowed, my lord, when filing.
How can I entertain an application by a person who is not the GPA holder? Until you produce a GPA, how can I hold?
My lord, this application is being filed by the petitioner to bring these people on record, my lord. When they come on record, if I
Who
may
is the
be,
petitioner?
the executor of the will,
What is his name?
George Michael Dennis. He's the, Paul is the executor. He's been represented by George Michael Sequeira.
For us to accept that he is represented, do you think we require the GPA?
Now that has been filed. That when I filed the suit initially, my lord, when I filed the petition. At the time of filing the petition itself, I had filed that GPA, my lord. It's document number 1 to my petition.
Document number?
1, my lord, to my main petition. Just after the affidavit of assets, my lord. Page 17.
It is noticed that the petitioner, that the deponent in the application for impleading has filed the affidavit, has filed the GPA executed by the petitioner at the time of filing of the petition itself. Hence, office objection regarding the requirement of producing the power of attorney would not be necessary at this stage. And you're saying Wakala to be filed with the proposed petitioner.
Please,
You
my
want to
lord.
treat them as the petitioners.
Please, my lord. By this honorable court had passed an order on 2nd of February, my lord, saying bring the beneficiaries on record.
Until you have the GPA or the Wakala to those petitioners, how can I implead you as the petitioner?
My lord, if the application may be allowed, so I can file a
How?
wakalat.
You tell me how. You don't hold Wakalat for the applicants, come on record as the petitioner. You don't have the GPA.
Please, I'll file it, my lord. 2 weeks time, maybe on 22nd, I'll file everything, my lord. All the 8 powers of attorney. There are 8 beneficiaries.
Remaining of subjection, the complaint.
On 22nd, my lord.
22nd.
Much obliged.
Seal number 11.
For the petitioner, that's IA 1 of 21 and IA 2 of 21 is filed for recalling the order of dismissal, my lord. IA 1 of
No, what is the order?
my lord,
Dismissal?
matter was dismissed for non-prosecution since the steps were not taken, my lord. In respect of respondent number 11 and 13,
ಈಗ ತಗೊಂಡಿದ್ದೀರಾ?
recall.
ಈಗ ತಗೊಂಡಿದ್ದೀರಾ?
ತಗೊಂಡಿದ್ದೀನಿ. ಅಂದ್ರೆ ಎಲ್ಲಾರು ಅವರಿಬ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ. ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹಾಕಿದ್ದೀನಿ. IA 1 of 23, 12 of 23, 3 of 23.
R11 and R13.
R11 and 13, please, my lord.
Who represents R11?
My lord, R11 is dead, my lord.
I know, but when he was alive, who represented him?
Earlier, nobody represented, my lord. Since the
I
steps,
can offer R14, my lord.
no, since the steps was not taken, my lord, they were,
Can I not ask them to take notice on view of the applicants?
nobody has appeared, my lord, on earlier.
Notice ಆಗಿದ್ಯಾ?
Notice ಆಗಿತ್ತು, steps ತಗೊಂಡಿಲ್ಲ ಅಂತ
ಈ IAS ಮೇಲೆ ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ ತಾನೆ?
ಇಲ್ಲ ಇಲ್ಲ ಸರ್.
ಅದಕ್ಕೆ ಅವ್ರು ಬಂದ್ರೆ ವಕಾಲತ್ ಆಗ್ತಾರೆ ಅಂತ ಕೇಳ್ಕೊಬರ್ತಾನೆ.
My respectful submission, my lord, IA 1 of 21 and 20, IA of 2 of 23, 21 may recall.
No, all the applications, I'll hear them and then
ಅದೆರಡು ರೀಕಾಲಿಂಗ್ ಇದೆ ಅದಕ್ಕೆ.
you appear for R11,
R14, my lord.
not for R13.
ಅಲ್ಲ ಅವರು ಇನಿಷಿಯಲಿನೇ ಸರ್ವ್ ಆಗಿರ್ಲಿಲ್ಲ.
And since R13 was served and remained unrepresented, you didn't have to file an application. When he was alive, it was served on him.
Please.
If he does not come and appear, you don't have to make an application to bring his LS on record. Now, unnecessarily, I'll have to issue notice to all of them.
No, say briefly.
It is noticed that R13 was served with a copy of the writ petition and yet chose to remain unrepresented. So, since R13 chose to remain unrepresented, on his death, there would be no need to bring his LRs on record. Therefore, the applications filed to bring his LRs on record, that is IA 4 to 6 by 2023, are unnecessary and are dismissed. Issue notice on IA 1, 2, and 3 of 23. The counsel for the deceased R11, Shri Ravindranath, may also accept notice on their behalf if he has instructions. Starting early, for the reasons stated in IA 1 and 2 by 2021, the delay in filing the application for recalling and the application filed for recalling the order are allowed. Petition is restored to Amali the matter. Connected matter ಏನು ಹಾಕಿಲ್ವಾ?
Connected matter ಆಗಿದೆ. ಆಗಿದೆ, recall ಆಗಿದೆ.
ಇಲ್ಲ, connected matter ಎಲ್ಲರೂ application ಬೇಡವಾ?
ಇಲ್ಲ ಅದಿರಲಿಲ್ಲ.
ಅವ್ರ ಪಾರ್ಟಿ ಇರ್ಲಿಲ್ವಾ?
ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಸರ್.
They are not
ಬೇರೆ
parties. They are not parties.
Number 12, Shri Krishna Gowda.
When did R3 die?
Appearing for the petitioner.
When did R3 die?
Hello? I'll have to take steps for R4. Last date I'll ತಗೊಂಡಿದ್ವಿ.
R3 is reported.
And I'll have to file the necessary applications to bring the.
I'll say it's abated. Since R3 was reported to have died on 16/5/21. And steps have not been taken within the prescribed time. The petition as against R3 shall stand abated. Who's R4?
R4 is the. Is the owner of the property or the grantee of the property?
Weak stem is granted. The exception is of R4.
Number 13, P N Harish.
R3B.
I appear for the respondent, my lord.
Don't take notice R3B. Will you take notice for R3B?
Yes, yes. Yes, the RB is died, so the legal heirs of 3B should be. 3B is died, the legal heirs of the 3B should be bought on the.
R3B is also dead.
Yes, yes.
R3B did that.
Huh?
Yaar ella ಸೇರಿದ್ರು ಅವರು. But his only son, Lord Manjunath, has to be brought on record.
He's alive or dead?
Like 3B is died.
3B is died.
If you give the details, he'll do it. Yes, will you take notice for him? No, my lord, let them know. Then I will say that the estate is adequately represented. If one of the LRs is represented, good enough.
Mother is the wife of the grant.
It's your choice. Let, please be. Told Kira. And counsel for R3A submits that he has instructions to accept notice on behalf of the son of R3B, since R3B is no more. Stop. Petitioner. He should formally brought on record. Petitioner is directed to implead R3B, the son of R3B, as the LR of R3B. Cause date will be amended. Stop. In view of the fact that the applications failed to bring the LRs of R3, since since the right to sue survives to the LRs of R3, that is R3A, and the son of R3B, the applications filed to bring them on record, that is IA1, IA3, but 20 is allowed. Cause date to be amended. Give him the details, please, Lord.
Seal number 14.
Kindly pass her, my lord.
Who's R6?
I'm the proxy counsel, my lord. I'm kindly pass her, my lord.
ಅಲ್ಲ ಇದು ಬಂದಿರೋದು ಇದಕ್ಕೆ
ಅದೇ
ಆರ್ಡರ್
ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಹಿಯರಿಂಗ್ ಆಗಿದೆ. My instruction is that, my lord, on last date of hearing, your lordship has heard the matter, my lord.
ಏನ್ ಮೇಡಮ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿತ್ತು
Please, this is purchaser's petition, my lord. AC order has been challenged here.
ಡೈರೆಕ್ಟ್ಲಿ
To MD and field.
ಡಿಸಿ ಹತ್ರ ಹೋಗಿಲ್ವಾ?
ಇಲ್ಲ,
ಸರ್
Seal number 15, Sri Dasappa B.
But in this case, Lord, the time for caveat respondent number 6, that I will undertake to file wakalat for R4 and R5, Lord.
ವಾಟ್ ಅಬೌಟ್ R7 and R8?
The R7 and R8 are the sellers of the property to me. I am the purchaser. The R7 and R8 are they sold the property to me.
ಅವ್ರ ಗ್ರಾಂಟೀಸ್ ಏನು?
ಇಲ್ಲ, the grantees appear. The writ petition is the grantees filed by this grantees. 6 and 7 and 8 are the vendors.
Undertakes to file wakalat on behalf of R4 and R5. It is also stated that R4, R5 and R6 are the purchasers from R7 and R8.
Yes, Lord.
It is therefore clear that R7 and R8 have no subsisting interest.
Yes.
Consequently, notice to R7 and R8 is dispensed with.
It may be posted next week, Lord, because for the original grant is in 1961. After 15 years, that 79, the first sale was taken place.
Amendment ಆಗಿದೆ ಅಂತಾರೆ. ತಿರ್ಗಾ ಮುಂದೆ
ಎಲ್ಲ ಅದು ಇದಾಗಿದೆ ಈಗ ಅದು ಅದ್ರಲ್ಲಿ 15 ವರ್ಷ ಮುಗಿದ ಮೇಲೆನೆ ಕಂಡೀಷನ್ಸ್ ಏನಿದೆ ಅದು ಮುಗಿದ ಮೇಲೆನೆ ಆಗಿರೋದು.
ರಿಯಲಿಸ್ಟ್
15th ಅಲ್ಲ ಮಾತ್ರ ನೆಕ್ಸ್ಟ್
22nd. 22nd. Seal number 16.
In this matter, I appear for the petitioner. Not this sale permission is obtained, not in the.
Then non-completion.
ಅಲ್ಲ ಅದು ಅದಕ್ಕೆ last time not directed the government to not the produce that sale permission later not. That's what happened not in this matter. Not of the respondent.
230.
Seal number 17, Sri Shiva Reddy.
Who's R4?
Weeks time may be granted.
Who's R4?
That's I'm a proxy, my lord, so I don't have any instructions. Weeks.
Weeks time.
Seal number 18.
My lord, I appear for the respondents, my lord.
What is the opposite objection?
My lord, there are too many non-compliances, my lord, as per the scrutiny report which is available online.
Copy
But
to be served. That is the only objection.
So
You
far
have
as,
the copies, you have the copies of the petition, isn't it?
so far as the caveat petitioner is concerned, I have received the copy, my lord.
It is reported by Srimati Vani H that she has received the copy of the petition. The office of petition are therefore complied with. In admission ಆಗಿದೆಯಾ?
Illa, it is coming up only for orders, my lord. My lord, the matter is covered by, my lord, division bench judgment, my lord, in Gauramma's case.
Post work. 18 million. Copies. CGP accepts notice for R1, R2, R3.
And 4.
ಇವೆಲ್ಲರಿಗೂ appear ಆಗ್ತೀರಾ?
No, my lord, from 5 to 22, my lord, notice has to go because they are all the original owners, the legal heirs of the grantee.
Who's the petitioner?
Petitioner claims to be the legal heir, but that has been rejected by the assistant commissioner, saying there is no evidence produced.
Let him come. B group.
Please.
Bill number 19. Fayaz Saab.
This case, my lord, respondent number 5 to 7 are the vendors of this petitioner. The petitioner is the purchaser, my lord. I am filing memo for dispensation because
Requested notice to R5 to R7 is dispensed with.
may be taken up next week, my lord, for argument.
List.
Just there?
15.
Memo to him,
Bill number 20. Malappa.
Needful done. Done. Needful set as well. Needful done.
Still the need has been an office.
Kindly extend the interim order.
Remote continue.
Bill number 21.
This case,
Within Ramesh.
petitioner, this case for the R3 my lord. Kindly permit to take paper publication. my lord. Respondent
R4
number
and
4 and 5.
ಯಾರವರು?
Address ಸರಿ ಇಲ್ಲ ಅಂತ ಬಂದಿದೆ. Respondent number, I apply for petitioner.
Who's R4 and R5?
That is the family members, Your Honor. Brothers of the respondent number 3.
For grantees.
Grantees, sorry. Grantees, Your Honor.
ಏನು who appears for the ಲಕ್ಷ್ಮಯ್ಯ?
Yes, my lord.
ತಗೊಳ್ತೀರಾ ನೀವು? ಒಕ್ಕಲತ್ ಹಾಕ್ತೀರಾ ಅವ್ರಿಗೆ?
ಇದು ಕೇಳ್ಬೇಕು. ಅಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನು ಹೇಳಿಲ್ಲ. Instruction have to take from them.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಒಂದೆಲ್ಲ ಯಾರು ನೆಟ್ಟಿದ್ದಾರೆ?
Before deputy commissioner same advocate ಇಟ್ಕೊಂಡಿದ್ರು ಸ್ವಾಮಿ. ಅವರು I will confirm it. ಬೇರೆ ಕಡೆ ಎಲ್ಲೋ ಕೆಲಸ ಮಾಡ್ತಾ
I
ಇದ್ದಾರೆ.
will direct you to take notice since it is reported that respondents 4, 3, 4 and 5 had engaged the same counsel with the deputy commissioner and only appearance has been made on behalf of R3. The counsel for R3 is also directed to accept notice for R4 and R5. He's granted a week's time to file wakalat.
Kindly extend the interim. My lord, I am opposing it because they have taken the this one orders against the 3, 4 and 5. On the contrary, they have entered into the agreement. The petitioner agreement is still existing and it is going to be sold at any time. Therefore, I pray this honorable court to pause and or let them take an undertaking. They are not going to alienate the property.
How can they sell? They don't have any title now. The lands are now resumed.
But the agreement is there, my lord.
ಕೊಳ್ಳಿ ಬಿಡಿ, ಇನ್ನು ತಗೊಂಡವ್ರು ಅವ್ರಿಗೇನು ಸಿಗಲ್ಲ ಪಾಪ. ಮಾರಕ್ ಹೋಗ್ಬೇಡಿ ಸುಮ್ನೆ ನಿಮ್ಗೆ.
Obliged.
For hearing on A, seal number 22. Manjunatha.
Paper publication. MC case.
Seal number 22, Shri Manjunatha K.
Management ಇದೆಯಾ? ಸರ್ವಿಸ್ ಆಗಿದೆ ಅಂತ ಬರ್ತಾರೆ. This court by an order dated 5/1/2024 permitted the petitioner to take out notice on the respondent through the counsel who represents him before the family court. Learned counsel in compliance with the said order has placed on record a memo dated 6th of February 2024 and is also enclosed the postal receipt and the acknowledgement to indicate that he has served the copy of the petition, to indicate that copies of the petition have been served on the counsel for the respondent. In that view of the matter, notice to the respondent is held sufficient. Consequently, the application filed to take out paper of publication would be unnecessary and the same is dismissed. Wife is before this court seeking for transfer of MC 325/2022, which has been issued by the husband before the 7th Additional Senior Civil Judge at Bangalore and requesting that the same be transferred to the family court at Bidar. She contends that she is residing at Bidar along with her parents and her two unmarried sisters, and it would not be possible for her to travel to Bangalore to defend herself. In the light of this submission, in my view, it would be appropriate to withdraw MC number 325/2022, pending on the file of the 7th Additional Judge Family Court Bangalore Rural, 7th Senior Civil Additional Judge Family Court Bangalore Rural to the Family Court at Bidar. Petitions accordingly allowed.
Till number 23, Sri Raja L.
इसके सत्यत्व पिटिशन ट्रांसफर पिटिशन ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಗೆ ಸರ್ವ್ ಮಾಡಿ 1/6 ಅಲ್ಲಿ ಕೌಂಟರ್ ಹಾಕಿದ್ದೀನಿ ಬಟ್ ನೋಟ್
Paper application ಹಾಕಿ ಹೊರಡ್ತೀರಾ?
ಅದಕ್ಕೆ 3 ಸಲ ಆಲೆ ನೋಟಿಸ್ ತಗೊಂಡಾಗಿದೆ. ಏನು ಅವ್ರ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ರು ಅದನ್ನೇ ಕೊಟ್ಟಿದ್ರು.
On 27/3/2023, the petitioner was permitted to take out notice on the counsel representing the respondent before the trial court. The memo is typed. Acknowledgement is there.
2/6 ಅಲ್ಲಿ ಮಾಡಿ.
Memo is filed stating that the copy was served on Shri Muniraju, the counsel who represent the respondent before the trial court. It is therefore clear that the notice of the petition has been served on the respondent, and yet he has chosen not to enter appearance. So consequently, there is no need to take out notice through paper publication, and IA 1/24 is rejected as being unnecessary. ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ?
ನಾವು ಬೆಂಗಳೂರಿಂದ ಮಂಡ್ಯಕ್ಕೆ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್
ಮಕ್ಕಳಿದಾರಾ?
ಮೈನರ್ ಚಿಲ್ಡ್ರನ್ 3 ವರ್ಷದ ಮಗು.
The wife is before the court seeking for transfer of C 223/23, which has been initiated by the husband for dissolution of the marriage at the principal at the family court Bangalore. So it is a case of the wife that she is a resident of Mandya and she also has a minor son.
Minor 3 years.
It won't be difficult for her to travel to Bangalore to defend herself. In my view, the petition has made out a case for transfer of the petition. Accordingly, petition is allowed and MC 223/23 filed by the respondent husband before the 3rd Additional Principal Judge Family Court Bangalore is withdrawn and is transferred to the Family Court at Mandya. ಒಂದೇ ಕೇಸ್ ಯಾರು?
ಒಂದೇ.
Number 24, Shri O. Shivram Bhatt.
And for the appellant, my lord, some third party filed an application for setting aside the compromise petition entered into between the parties.
Who is the third party?
It appears that he is a relative of the respondent. My lord, suit was filed in the year 1992. Neither in the suit nor in the appeal, nor before this on the court, he was a party.
Now, after the compromise, my lord, 2 years later on or 3 years later on, when survey is being conducted, now he comes up with this.
We'll wait for 1 week because.
Yes.
first, realist.
My lord, his remedy is to file a separate suit, my lord, not this.
Earlier, realist.
15. 15.
16,
16 Sunday, Saturday.
17.
The council has filed the application. That is IA3 and 4/24 is unavailable. Hence, realist finally on.
In the meanwhile, I will file the objection. In fact, copy kuda kottilla namage. ಅವರು
RPD ಅನ್ನ ಮಾಡಿದ್ದಾರೆ.
ಪಾರ್ಟಿಗೆ I will verify.
Serial number 25. Vijay Bhajantri.
Since the right to sue survives on the applicant. In IA 9/23, the delay in filing the elder application and the application to substitute the abatement. And also the application to bring them on record are allowed. First schedule to be amended. ನೀವ್ಯಾರಿಗೆ
Respondent.
ಕಾಸ್ಟ್ ರೇಟ್ ಅಮೆಂಡ್ ಯಾಕೆ ಮಾಡ್ತಾ ಇಲ್ಲ?
Lords,
ಕಾಸ್ಟ್ ರೇಟ್ ಯಾಕೆ ಅಮೆಂಡ್ ಮಾಡಿಲ್ಲ?
I'm sorry, my lord.
ಕಾಸ್ಟ್ ರೇಟ್ is not
Really?
amended.
My lord,
Really? The application is still pending consideration, my lords, in respect
the
of first
earlier-
petitioner.
filed,
About the application now, the earlier application for.
My lord, I'll correct it, my lords.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಅವ್ರ ಲೀಗಲ್ ಎಲ್ಲಾರ್ಸ್ ಅಲ್ಲ ಅಂತ ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೆ.
Or object ಮಾಡಿದ್ದಕ್ಕೆ I was,
ಅಲ್ಲೋ ಆಗಿದೆಯಾ ಆಗಿಲ್ವೋ?
the first in respect of first petitioner is not yet allowed. my lord.
Regarding in respect of first petitioner is concerned, my lord, he filed application for bringing LRs.
So did, you have any objection for that?
Already filed, ಅವರು ಜಿನಾಲಜಿ ಟೀರ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರು, 2-3 ಸರಿ ಟೈಮ್ ತಗೊಂಡ್ರು.
Serious objection, ಇಲ್ಲ ಸುಮ್ಮನೆ ನಿಮ್ಮ objection.
It may be allowed.
No, my lord, please, my lord, I will,
First.
I'll carry out the amendments, my lord. I request my lord to kindly fix a date, because my lord,
ಮಾಡಿ.
ಮಾಡ್ತೀನಿ. Next week ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಕೊಟ್ರೆ, in the meantime I'll do it.
Realist.
ಗ್ರೇಟ್ ಇದರಲ್ಲಿ ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಇದೆ ಸ್ವಾಮಿ ಒಂದು ಐ.
ಯಾವ
It has been already
next week ತಗೊಂಡು.
heard by the coordinate bench already. My lord's votes. 15. Please, grateful. Serial number 26. K. Sridhar.
Appearing for respondent number 12 in this one.
Just received the wakalat, the NOC wakalat from the petitioners. I undertake to file a wakalat, 1 second. I undertake to file a wakalat on behalf of all the petitioner, expect your lordship, the Chikkamuniappa, petitioner number 1 and 3. My learned friend continue the other rest of the other.
A week's time is granted to do the need. ಏನ್ ಮಾಡ್ತಾರೆ ಮಾಡಿ ಅಷ್ಟೇ.
Lordship, one submission. Last date of hearing, the copy was not served to us, so they have directed to serve the copy on respondent.
Petition copy.
Please, you. Respondent.
Survey copy on.
ಇಲ್ಲ sir, ನಮ್ಗೆ ಬಂದಿಲ್ಲ.
For which respondent?
Respondent number 12.
It will be served.
ಇಲ್ಲಾಂದ್ರೆ ಕಾಸ್ಟ್ ಆಗ್ತೀನಿ 5,000 ರೂಪಾಯಿ ನಿಮ್ಮ
ಇಲ್ಲ. Actually, NOC ಕೊಟ್ಟಿದ್ದೇನೆ, I will continue.
ಒಂದು ಕೊಡಿ, ನೀವು ಈಗಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡಿ, ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಸಾಕು.
ಕೊಡ್ತೀನಿ.
Petition council undertakes.
Undertake to file wakalat on behalf of none of the copy.
I've granted a week's time to whatever you want.
All the.
I've granted a week's time, ಏನ್ ಮಾಡ್ತಾರೆ ಮಾಡಿ.
Serial number 27.
In the meanwhile, the director, the government advocate, place all the original documents.
First,
That is
ವಕಾಲತ್
only-
ಹಾಕ್ ಬರ್ಲಿ ನೀವು,
That is the
ಆಮೇಲೆ
only issue is whether the caste certificate, grant certificate is a genuine or
first ನೀವು ವಕಾಲತ್ತಲ್ಲಿ ಹಾಕ್ ಬನ್ನಿ, ಆಮೇಲೆ ಮಾಡಿ.
1 week.
Well, 27, my lord.
Serial number
I
27.
appear for the petitioner. First petitioner, R4 and R8 have died, but I filed the LR application on 13/9/24, my lord.
Who's
Office will be directed to
dead? Who's dead?
petitioner number 1,
Like first.
R4 and R8, my lord.
Like ಇದು, I'll dispose of this memo.
Memo is filed with the respondents, my lord. That memo may be disposed of because I have already filed LR application.
The application filed by the petitioner to treat R5 to R8 as LS of disease R4 is allowed. Necessary note be made in the cost rate. ಇನ್ನೊಂದು ಯಾವ್ದು ಇದು?
LR application post ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ನಾನು.
What is this 28/5/24 memo?
That is filed by, my lord, the respondent regarding reporting death of the 8th respondent and citizen. ನಾನು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅವ್ರು.
ಬೇಟಾಕ್ ಹೋಗಿದ್ದೆ.
ಅದಕ್ಕೆ ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ ನಾನು.
I'll pass it order, you make an application in the lower.
Please, madam.
Memo is filed reporting the death of R8. To the effect that R8 passed away on 14/4/24. The officer has raised objections on the said memo, saying that the signature of the council is not forthcoming. In my view, the objections are unnecessary and hence overruled. It is also noticed that steps have not been taken despite the fact that R8 passed away on 14/4/2024. Consequently, the petition as against R8 shall stand abated.
Lord, on 13/9/2024, I have filed elder application in respect of petition number 1, R4 and R8. Office has not posted
Stated
the
that applications are filed within the laws of the first petitioner on record.
first petitioner R4 and R8.
On
R4 and on 13/9/2024.
the office is there to put up this.
And regarding R4 and R8 also not have filed the other application.
ಮಾಡಿದ್ನಲ್ಲ ಈಗ allow ಮಾಡಿದ್ನ.
Interim order may kindly be extended.
Petition copy.
For further consideration, seal number 28 adjourned, seal number 29.
Interim order may be extended.
Seal number 29, Shri Venkatesh Arapati.
For the petitioner, your lordship. So kindly permit me to take fresh steps.
ಯಾವ್ದ್ರಲ್ಲಿ?
Still number 29, your lordship.
ನೋಡೋಣ next week.
15th. Seal number 30 for reporting complaints. Shri Vasant Kumar HT.
Hearing to the respondent number 2 and 3. Hearing to the respondent number 2 and 3.
What happened?
Need some time.
ಇನ್ನು ಆಗ್ಲಿಲ್ವಾ?
Not take minutes.
What happened?
We need, it is under process, my lords, we need some more time, my lords.
No, I had directed you to allot any of the 3 sites and report the same before.
Yes.
If you have not, I'll issue contempt notice.
No, my lord, 1 week time may be given, we will report it.
See, this has been going on for too long.
Yes, sir.
I'll ask the commissioner to be present. ಮಾಡ್ಲಾ?
1 week time.
I'll pass it over, get instructions.
For admission, seal number 31, Shri Manu BP.
The respondent number 1, ma'am. Objections.
Copy now is.
Filing my objections, ma'am.
Transfer from where to where?
Harapannalle to Chennaraipatnam, my lord, one mistake. Harapannalle to Chennaraipatnam, Assam district, my lord. One mistake I have committed, my lord, on 21/6, my lord, 27/6.
ಏನು OS ಏನಕ್ಕೆ ಹಾಕಿರೋದು?
OS for seeking declaration of death benefit of the disease between the wives relating to the death benefit of the husband, deceased husband, my lord.
ಇಬ್ರು ಹೆಂಡ್ತಿ ಇದ್ರಾ?
Also,
I am the legally wedded wife, my lord.
I am also legally wedded wife.
Petitioner had
One submission, my lord. My lord, while hearing the matter, my lord, this court has raised the objection on previous occasion.
You are the defendant or the plaintiff? You are the
Plaintiff,
defendant.
Plaintiff there, my lord.
I am defendant number 1.
Plaintiff petitioner.
You had filed the suit at
Yes, my lord. Harapannalle.
Harapannalle and now you wanted to be transferred.
Transfer because, my lord, subsequently, there is an harassment between the family, my lord. Now it's residing in my mother's house.
Subsequently?
There are some family disputes have been arranged in the matrimonial home. Now I am residing in my mother home in Chennaraipatnam.
Lord Katti Hanmantappa had married and divorced the petitioner in 2014 only, my lord. I got married to the Katti Hanmantappa in 2019, my lord. So he passed away in
You have filed
2020.
the suit there
Yes, ma'am.
merely because you have some problem and you have moved away from Harapannalle. That can't be a
Now-
ground to transfer.
Now, my lord, there are two children, my lord, school, small children with, it is very highly difficult, my lord, and also there is a medical,
In fact, the kids are staying with the mother.
medical
my lord.
problem, my lord, she have an allergy. My lord, one important, last occasion, my lord, I made one mistake. And this court, while hearing the matter, my lord, raised the objection in the plaint, my lord, that the respondent number was not party in the original plaint, my lord. And how this petition is maintained, this court has raised the objection, for which, my lord,
ಅದಲ್ಲ ಅದು ಬಿಡಿ ಟೆಕ್ನಿಕಲ್. ನಂಗೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ನಂಗೇನು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಕ್ಕೆ ಏನು ಗ್ರೌಂಡ್ ಇಲ್ಲ.
my lord,
ಫೈಲ್ ಸೂಟೆಡ್ ಅರ್ಪನಹಳ್ಳಿ.
yes, my lord.
Now you can't say that I moved, therefore transfer the
My lord,
suit.
it is not, now because subsequent.
ಗಂಡ ಹೆಂಡತಿ ಜಗಳ ಒಂಥರ ಇದು ನೀವು ದಾವ ಹಾಕ್ಬಿಟ್ಟು
ಅವಾಗ ಅಲ್ಲೇ ಇದ್ರು ಸ್ವಾಮಿ ಅವರು. ಈಗ ಮಕ್ಳಿದಾರೆ,
3 ವರ್ಷ ಆದ್ಮೇಲೆ
ಮಕ್ಳು ಇದಾರೆ ಸ್ವಾಮಿ, ಮತ್ತೆ ಅವ್ರ ಜೊತೆ
ಮಕ್ಳಿದ್ರು ತಾನೆ.
ಅಲ್ಲೇ ಅಲ್ಲೇ ಜೊತೆಲಿ ವಾಸ,
ದಾವ ಹಾಕಿದಾಗ ಮಕ್ಳಿದ್ರು ತಾನೆ.
ಅಲ್ಲೇ ವಾಸ ಮಾಡ್ತಿದ್ರು ಸ್ವಾಮಿ ಅವರು. ಇವಾಗ ಇಲ್ಲಿ ಅವ್ರ ತಾಯಿ ಮನೆಯಲ್ಲಿ ಇದಾರೆ ಈಗ ಅವರು.
The
ಅಲ್ಲಿ
kids are with the deceased father.
ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಅಲ್ಲಿ ಶೆಲ್ಟರ್, ಅಲ್ಲಿ ಯಾರ ಎಲ್ಲಿ ಇರೋದಕ್ಕೆ ಅವ್ರಿಗೆ ಜಾಗ ಸಿಕ್ಕಿಲ್ಲ.
Children are not with her.
No, man.
It is my lord, on the petitioner, my lord, it's filed, my lord.
The kids are with the mother. Mother of.
My lord, in the absence of the respondent number 4, my lord, the petition would not be completed, my lord. ಅವರನ್ನು ರಾಯಚೂರಲ್ಲಿ, my lord, they are also not residing in the Harapanhalli, my lord. They are residing in the
Why did you file the suit at Harapanhalli?
Harapanhalli, my lord, at the point of time, we resided there.
And then you can't.
My lord, see, it is very difficult for traveling, my lord. But the respondent number 1 also residing in Raichur, my lord, not in Harapanhalli, my lord. It will not cause any inconvenience for them also, my lord.
For the past 3 years, you have gone on the suit there. Now suddenly there's a need for you to come to.
My lord, that is not intention, my lord. There is it is not possible to leave stay there accordingly, my lord. Our ತಂದೆ ಇಲ್ಲ ಸ್ವಾಮಿ.
And GNWC for custody.
ಚನ್ನರಾಯಪಟ್ಟಣ, my lord.
That has been dismissed.
Dismissed.
Yes. My last annexure in my objections.
I will verify, my lord, please. One submission, my lord. My lord, no, one, my lord, kindly have it.
GNWC petition.
Only Monday have it, my lord. I will verify it. Monday, my lord.
The petition has been filed seeking for transfer of a suit that the petitioner had instituted at Harapanhalli and to be transferred to the civil judge and JMFC Chandrayapatna. Learned counsel for the petitioner contended that at the time of filing of the suit, the petitioner was residing at Harapanhalli and therefore she had instituted the suit there. But subsequently, she has shifted her residence to Chandrayapatna and therefore the suit is required to be transferred. In my view, merely because the petitioner claims that she has shifted her residence to Chandrayapatna, that cannot be a ground to transfer a suit that she has instituted at Harapanhalli. The petition is therefore dismissed.
Number 32. Nandesh Gowda.
My lord, wife petition for transfer.
Whoso the husband?
Rupesh is appearing.
Illinda elige?
Uh,
Rupesh.
Senior civil judge.
Rupesh Abhi.
Senior civil judge Madhugiri to, my lord, the Bangalore, family court, Bangalore.
Madhugiri to Bangalore. ಮಕ್ಳಿದಾರಾ?
ಇಲ್ಲ ಮಕ್ಕಳಿಲ್ಲ.
ಒಂದೇ ಕೇಸ ಇಲ್ಲ ಬೇರೆ ಕೇಸು ಇದೆಯಾ?
Only one case.
The wife is before the court seeking for transfer of the petition that the husband had instituted in MC number 34/2023 before the principal senior judge, civil judge and JMFC Madhugiri to the principal family court at Bangalore. The wife contends that she is residing in Bangalore. She is along with her parents and would not be possible for her to travel to Madhugiri to defend herself. It is noticed that even in the petition that is filed by the husband, the address of the petitioner is shown as being a resident of Bangalore. So in my view, and in regard to the fact that the petitioner is residing in Bangalore, it would be appropriate to withdraw MC 34/23, which is pending on the file of the principal senior civil judge, JMFC Madhugiri, and transfer the same to the principal family court, which Bangalore. Petition accordingly allowed, since the parties are represented by counsel, they are directed the parties are directed to appear before the Principal Judge Family Court to take further instructions.
3rd December. Appearance, 3rd December.
Please inform him.
Please, my lord.
Seal number 33, Chandrakant Targavade.
I appear for petitioner, my lords. The petitioner herein is wife who entered into a marital relationship with the respondent on 17/6/21, my lords. And since some disputes arises, they got separated on 26/9/21, my lords. Meanwhile, the petitioner herein filed a suit for restitution of conjugal right before Chamrajnagar, my lords, Senior Civil Judge Chamrajnagar. Meanwhile, the respondent herein, that is husband, filed a suit for dissolution of marriage before Family Court of Mysore, my lord. So we are seeking a transfer of the case from Family Court of Mysore to Chamrajnagar, my lords. I'm residing in Chamrajnagar, my lords. That is in the village called Jannur Vasur village, my lords.
That's, the respondent is working in Bangalore, my lords. Bangalore, my lords. It would be convenient for.
But then you have filed this petition in Mysore.
That's because it was, their place of residence was Mysore, my lords. As such, it was filed in Mysore. That's the place where they're residing is 40 kilometers from Mysore and 30.
You're not seeking for transfer.
No, my lords.
Then
That's, I mean,
the wife is before the court seeking for transfer of MC number 63/2023, which has been instituted by the husband before the MC 895,
Please, my lords.
895/23, which has been instituted by the husband for dissolution of marriage before the Principal Family Court at Mysore to the Principal Civil Judge and CGM Court, Chamrajnagar. So the wife contends that she has also instituted a petition for restitution of conjugal rights, MC number 63/2023, before the Principal Judge and CGM Court, Chamrajnagar, and therefore it would be appropriate to transfer the petition filed by the husband at Mysore to be heard along with the petition filed by her at Chamrajnagar. In my view, the prayer of the petitioner request be accepted, since it will be difficult for the wife to travel to Mysore to defend herself. That will the matter. The CP is allowed. MC number 895/23, pending on the file of the Principal Family Court at Mysore, is withdrawn and transferred to the Principal Judge and CGM Court, Chamrajnagar, with the direction to the Principal Civil Judge, CGM, Chamrajnagar, to take up MC 895/23 along with MC number 63/2023. Of the court shall ensure that both the cases are posted on the same day, so as to so that the respondent is not put to any inconvenience. Since the parties are represented, it shall appear before the court on
3rd December.
great.
Silver 34, Sri Chandan S. Malapur.
Lord, in this case, I'm seeking transfer from Bengaluru to Hubballi, my lord. When she has a son who is a minor as well, my lord.
Who's the respondent? Notice of it. She notice. The counsel is permitted to take out notice on the respondent through his counsel in the trial court. Interim stay.
Number 35.
Lordships, I'm requesting for stay up. Please, apply.
Number 35, Sri Purushottama.
But for petition, my lord, from Shira to Bangalore, my lord, I'm seeking transfer of proceedings.
Notice. Petition is permitted to take out notice on the respondent through the counsel who represents the trial court. Interim stay.
Stay may be granted.
Seal number 36, Sri Ishwara H.
Appearing for the petitioner, my lords. My lords, the petitioner resides in Mysore with her aged parents. The respondent has filed MC petition 5221 of 24 before additional.
You are 54 years and your husband is 59 years.
Lords,
You are 54 years and your husband is 59 years.
please, my lords.
And you want divorce now. Stay, my lord. She notice.
Seal number 37, Sri Vide Ramchandra.
Seeking transfer of the MC petition from Chitul.
Husband is seeking for transfer.
Husband is seeking transfer. There is a earlier petition filed by the husband under section 13. This is the second petition filed by the wife under section 9, my lord. he is working in, as assistant professor in SJM college.
Then ಅವ್ರಿಗೆ ಹೋಗಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ?
ಇಲ್ಲ, ಇವ್ರದ್ದು petition ಇಲ್ಲಿದೆ. ಇವ್ರದ್ದು petition earlier filed.
Davangere is not too far for
MC,
assistant professor to travel.
MC 28 is there, and there is a, the respondent herein has filed a civil petition before this honorable court. It's also pending.
No, then I'll transfer your case also to Davangere. ನೀವ್ ಹಾಕಿರೋದು ದಾವಣಗೆರೆ ತಾನೆ, ಚಿತ್ರದುರ್ಗ ತಾನೆ?
Chitradurga, I am working in Chitradurga, my lord.
No. Where did you file the petition?
I have filed in Chitradurga.
Then I'll transfer that to Davangere.
No, my lord, because I am working in Chitradurga.
Can the wife come and you can't go?
No, wife is not working.
So?
Wife is not working, and she had given the address of Chitradurga, last resided. Notice, Madi, there's one more matter between the parties, CP number 292.
Post.
Along with that. 292/2024.
ಅದು ನೀವ್ ಹಾಕಿರೋದಾ?
ಅವ್ರು ಹಾಕಿದ್ದು. Wife ಹಾಕಿದ್ದು ಸರ್.
Live it together.
Seal number 38, Kirani.
Stay, my lord, stay off.
Next week ಅದನ್ನು ತಗೊಳ್ತೀನಿ.
For the time being, my lord.
Seal number 38, Kirani.
Udupi to Mangalore, 5 kilometers. Udupi to Mangalore, 5 kilometers.
Seal number 39, Shri Venkatesh.
Petition, wife's petition, your lordship. Transfer from Gubbi to Bhadravati, your lordship. Wife has petition, Gubbi to Bhadravati.
ಮಕ್ಕಳಿದಾರಾ?
ಇಲ್ಲ, ಮಕ್ಕಳಿಲ್ಲ.
Issue notice.
Much.
My lord, one submission, my lord, serial number 38, my lord, due to network issue, I could not connect it, my lord.
ಅಲ್ಲ ಏನು ಉಡುಪಿ ಟು ಮ್ಯಾಂಗ್ಳೂರ್ ದೂರ ಆಗತ್ತಾ?
ಸ್ವಾಮಿ ಅವ್ರಿಗೆ she got some spinal cord issue, my lord. ಅವ್ರು ರೆಸ್ಟ್ ಅಲ್ಲೇ ಇರ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಏನ್ ಪ್ರಾಬ್ಲಮ್?
ಸ್ಪೈನಲ್ ಕಾರ್ಡ್ ಇಶ್ಯೂ ಆಗಿದೆ ಅಂತ ಸ್ವಾಮಿ, ಡಿಸ್ಕ್ ಬಲ್ಜ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ? ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಾ?
ಸ್ವಾಮಿ ಡಾಕ್ಯುಮೆಂಟ್ ವಿಲ್ ಬಿ ಫರ್ನಿಶ್, my lord. ತಗೊಂಡ್ ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಎಲ್ಲಿ ಪಿಟಿಷನ್ ಹೇಳಿದಿರಾ ಆತರ?
Yes, my lord. I have made a submission in respect of the disc bulge issue, my lord.
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
My lord, kindly pass over, my lord. I'll appear in person, my lord.
ಅದನ್ನೇ ಮಾಡಿದ್ದಿದ್ದು ನಾನು.
Much obliged, my lord. It was not connected, so that I didn't hear it, my lord.
Issue notice. Same, madam. Stay. Take out notice on the counsel appearing in the trial court.
My lord, proceedings is set down for evidence, my lord.
Stay ಮಾಡಿದ್ದೀನಿ.
Much obliged, my lord.
VR Balraj.
My request for next week, my lord, some personal inconvenience. So VR Bal.
ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗಿಂತ ಗೊತ್ತಿಲ್ವಾ?
And I'm not sure, my lord. Now he had called.
Issue notice. Counsel is permitted to take out. Tell him notice. Tell him take out notice.
Watch out.
Number 41. Mahesh.
Lords, I appear for the petitioner, my lords. Wife is before the court seeking of a divorce, transfer of divorce proceedings initiated by the husband from Tumkur to Bangalore. Wife is a housewife having a single kid, my lord. They resided in Bangalore itself.
Take out notice on the counsel.
Yes, my lords. Matter is on 16th. The stay may be granted.
Same order.
Much obliged.
Number 42. Mohan Kumar.
Transfer to Pandapur to Bangalore, my lord.
Same.
Stay may be granted.
Number 43.
Much obliged.
Prasanna Shetty.
For the petitioner, my lord. My lords, marriage took place, marriage was taken on 26/1/2020, my lords, in Kundapura, my lord. My lords, marriage was solemnized on 26/1/2020, my lords, at Kundapura, my lords. My lords, husband is residing in Tumakuru, my lords. I was working as a forester in Kundapura, but I was residing in the quarters, my lords. Occasionally, I was visiting at a petitioner's house, my lords. I was visiting husband's house, my lords, and husband was coming to my quarters, my lords. My lords, now, my lords, I was gave birth to a male child on my lords 24/22, my lords. My lords, we have separated on 30/5/22, my lords.
Same.
My lords, there is a stay may be given, my lords.
Yes.
Obliged, my lords.
Seal number 44.
Not appearing for appellant. Not petitioner seeking a transfer the divorce petition, I'm sorry, section 9 petition filed by the husband, my lord, filed at Sindanuru, my lord, seeking transfer to the court of Honnali, my lord. Wherein, my lord, one more petition is pending filed by the present petitioner, my lord. Petitioner is a second wife, my lord. Earlier the petition. Interim.
Seal number 45. Raju, yes. Yes, Raju.
Claim petition dismissed on the ground of employer and employee is not.
On the ground?
On the grounds of employer and employee relationship is not proved on the ground that manner. This is the driver of the car.
Where is the reasoning?
Pardon?
Where is the reasoning? Which paragraph?
Paragraph 21.
The employer appeared?
Yep. The driver of the car, owner of the car is examined before the trial court, my lord. He is giving evidence he is not my driver. Para 20 and 21, my lord.
Well-known friend of her son antara.
Friend of son anta. Friend of ಮಗನ ಫ್ರೆಂಡ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಅಲ್ಲ ಡ್ರೈವಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ, ಪಾಲಿಸಿ ಇದೆ ಸರ್.
ಡ್ರೈವಿಂಗ್ ಮಾಡ್ತಾ ಇದೆ ಸರಿ. But if the employer says that you are not the employee, what can the commissioner do? Is there any document to show that you are paid salary?
ಅದು ಆ ಥರ ಏನಿಲ್ಲ.
ಇನ್ನೇನು MBC ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
ವರ್ಕ್ WC.
ಇಲ್ಲ MBC ಯಾಕೆ ಹಾಕ್ಲಿಲ್ಲ?
MBC ಹಾಕ್ಲಿಲ್ಲ.
ವಿಡ್ರಾ ಮಾಡಿ ಹಾಕೊಳ್ಳಿ ಹಂಗಾರೆ MBC ನ.
ಇಲ್ಲಿ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ.
Number 46. HS Lingaraj.
Lingaraj.
HS Lingaraj.
Mahesh. ಏನ್ ಗ್ರೌಂಡ್?
On the date of accident, may not the.
ಅದೇ 4 ಕೇಸ್. 5 ಕೇಸ್.
5 ಕೇಸ್.
ನಿಮ್ದೆಲ್ಲ ಕ್ಲೈಮೆಂಟ್?
ಹೌದು.
2 ನೀವು ಅವ್ರ 3.
ಹೌದು. ನಂದು ಎನೌನ್ಸ್ಮೆಂಟ್ ಗೆ ಅವ್ರದ್ದು
ಲಯಬಿಲಿಟಿ ಏನ್ ಕ್ವೆಶ್ಚನ್?
ಲಯಬಿಲಿಟಿ may not on the date of accident, no policy of insurance.
Judgment ಅಲ್ಲಿ regarding the liability.
He is representing the owner of the vehicle.
Owner of the vehicle. I am representing owner of the vehicle.
No insurance.
No insurance as on the date.
No insurance.
Insurance ಇದೆ. ಅದನ್ನೇ judgment ಅಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ. Page number 16 in the judgment, my lord.
Paragraph 19 of the judgment.
19 ಅಲ್ಲಿ.
In page 18.
Fourteen 1/2015 ಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಯ್ತು. ವೆರಿ ಸೇಮ್ ಡೇ ಮಾರ್ನಿಂಗ್ ಪ್ರೀಮಿಯಂ ತುಂಬಿತ್ತು. ಅವತ್ತಿನ ದಿವಸನೇ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ.
ಏನೇನು ಚೆಕ್ ಬೌನ್ಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ, ಇಟ್ ಈಸ್ ಅಡ್ಮಿಟೆಡ್.
ಲಿಂಗರಾಜು ಯಾಕೆ ಇಬ್ರು ಯಾಕೆ?
Not
ಇಬ್ರು ಕೌನ್ಸಿಲ್ ಯಾಕೆ? ಮಹೇಶ್ ಅವ್ರು ಹಾಕಿದಾರೆ ಒಂದು.
ಅದು ಸಪರೇಟ್. ಇದು ನಂದ್ರಲ್ಲಿ ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಓಮಹೇಶ್ ನನ್ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. In MEC regarding 923 of 2016, 925 of 2016. ಅದರಲ್ಲಿ ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್. ಇನ್ನೊಂದು
ನೀವೆಲ್ಲರೂ ಪೆಡೆಸ್ಟ್ರಿಯನ್ಸ್ ನೀವು?
ಹೌದು.
ಇಲ್ಲ
ಪಿಲಿಯನ್ ರೈಡರ್ ಆಫ್ ದಿ ಮೋಟರ್ ಸೈಕಲ್ ಅಂಡ್ ಪಿಲಿಯನ್.
ಇಲ್ಲ, ಫಸ್ಟ್ ಒನ್ MFA 3682.
5682 ನಲ್ಲಿ ಅದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಪೀಲ್. 3682 ನಲ್ಲಿ
There it looks like you are pedestrian. ಏನ್ರಲ್ಲಿ ಹೋಗ್ತಿದ್ರಿ?
3682 ನಲ್ಲಿ ಯಾರು? ನಂದ್ರಲ್ಲಿ ರೈಡರ್ ಅಂಡ್ ಪಿಲಿಯನ್ ರೈಡರ್.
ನೀವು ಮೋಟರ್ ಸೈಕಲ್ ನೀವು?
ಹೌದು. ಇಲ್ಲ, ನಂದು ಲಾರಿ.
You are traveling in a motorcycle.
Please. Rider and pillion rider. Motorcycle.
ಮತ್ತೆ ಮಹೇಶ್ ಅವ್ರು ಯಾರಿಗೆ?
Insurance company.
Insurance
company. Insurer of
or in a motorcycle?
Lorry.
ಇವರು ಲಿಂಗರಾಜ್?
ಲಿಂಗರಾಜ್ ಅವ್ರದ್ದು ನನ್ನ ಹತ್ರ ಫೈಲ್ ಇಲ್ಲ. ಅದು ಏನಂತ ಸ್ವಲ್ಪ ವೆರಿಫೈ ಮಾಡಿ. ಅದಲ್ಲ, ಐ ಆಮ್ ನಾಟ್ ರೆಪ್ರೆಸೆಂಟಿಂಗ್ ಅದು ಸಪರೇಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ಅಲ್ಲ, ನನಗೂ ಬರೀ ನೋಟಿಸ್ ಇದನ್ನ ಕಳ್ಸಿರ ಅಷ್ಟೇ. ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನು ಅಪೀಲ್ ಮೆಮೋನು ಅದು ಇದೆಯಾ? ಇಲ್ಲ, ಅಪೀಲ್ ಮೆಮೋನು ಕಳ್ಸಿಲ್ಲ ನಮ್ಗೆ. ನನಗೆ ಅದ್ರಲ್ಲಿ ಅಪೀಲ್ ಮೆಮೋನು ಬಂದಿಲ್ಲ, ಬರೀ ನೋಟಿಸ್.
ಅದ್ಯಾವ್ದು ನೋಡಿ, ರಂಗೇಗೌಡರು ಹಾಕಿರೋದು, ಮಹೇಶ್ ಹಾಕಿರೋದು. ಗಾಡಿ ನಂಬರ್ A16A374. A16A374 3714.
ಹೌದು.
Then
ಕ್ಯಾಂಟರ್ ಲಾರಿ ಬೇರಿಂಗ್ ನಂಬರ್ K16A3714.
ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಲಾ?
ಮಾಡು.
For hearing D group, seal number 47 adjourned. Seal number 48, Shri Prakash T. Abbar.
Purchaser writ petition, my lords. Totally 15 years delay, my lords, from the date of mortgage. Firstly, it was mortgage, my lords. And
Sale has
the
taken place after the act came into force. 1989 was the sale. Without any.
ಫೋಟೋ ಇಲ್ವಾ?
ಇಲ್ಲ, photo permission ಇಲ್ಲ.
but there is a delay, my lords, 15 years delay.
And conditions also violated.
When was the grant?
Grant was in the year
1978, my lords. In a public auction, my lords, ₹95 was paid.
89 was the sale. Application filed 2005. Petition was 15 years.
ಅಲ್ಲ, if it's an auction sale, granted land ಆಗುತ್ತಾ?
Public auction ಅಂತ nowhere it is stated.
ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಯಾಕೆ ಕೊಡ್ತಾರೆ ಮತ್ತೆ? In form number 1.
Yes.
He says in the synopsis, the sale certificate. Is the finding of the assistant commissioner?
Health commissioner Mano.
Where is the order of the assistant commissioner?
Page 12. Page 12, second paragraph. ಅದರಂತೆ ಸದರಿ ಪ್ರಕರಣವನ್ನು ಕಡತಕ್ಕೆ ತೆಗೆದುಕೊಂಡು ಉಭಯತರಿಗೂ ನೋಟಿಸ್ ಹೊರಡಿಸುವ ನಿಗದಿ ವಿಚಾರಣೆ ತೆಗೆದುಕೊಂಡು ತಹಸೀಲ್ದಾರ್ ಮೇಲೆ 4th lane ತಹಸೀಲ್ದಾರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಅವರನ್ನು ಜಮೀನು ಮಂಜೂರು ಕಡತವನ್ನು ಕಳಿಸಲು ಕೊಡಲು ಸೂಚಿಸಲಾಗಿತ್ತು. ಪ್ರತಿವಾದಿಗಳು ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ನೋಟಿಸ್ ಪಡೆದಿರುವುದಿಲ್ಲ. ನಂತರ ರಿಜಿಸ್ಟರ್ ಅಂಚೆ ಮೂಲಕ ಸಹಿಸಲಾಗಿ ಸ್ವೀಕರಿಸದೆ ವಾಪಸ್ಸಾಗಿರುತ್ತದೆ. ವಿವಿಧ ದಿನಾಂಕಗಳಲ್ಲಿ ನಡೆದ ಪ್ರಕರಣಕ್ಕೆ ಗೈರು ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಹೇಳಿಕೆಯನ್ನು ಸಹ
ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ ಮೇಡಮ್ ನೀವು? ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
ಪೇಜ್ 12, ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಪ್ರಿನ್ಸಿಪಲ್
Page 12.
Yes, ma'am.
Page 13.
4th paragraph, ma'am.
Page 13 my lords, ಅದರಂತೆ ಸದರಿ ಪ್ರಕರಣವನ್ನು ಕಡತಕ್ಕೆ ತೆಗೆದುಕೊಂಡು
ಕಡತದಲ್ಲಿ ಮೆಲಾಟ್ ಪ್ರಸ್ತುತ ಜಮೀನು ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಕೆಳಕಂಡಂತೆ ನಿರ್ಣಯಿಸಲಾಗಿದೆ. 3 ಎಕರೆ
Page 13 ಅಲ್ಲ.
ಪ್ಲೀಸ್ ಪೇಜ್ 12 ನಂದ್ರಲ್ಲಿ ಪೇಜ್ 13 DC ಆರ್ಡರ್ ಮೆಲಾಟ್
ಇಲ್ಲ. Annexure A ತಾನೆ.
ಪ್ಲೀಸ್
Annexure A is the Assistant Commissioner's order.
ಎಸ್ ಮೆಲಾಟ್ ಯಾವ ನಿಮಿಷ ಕೊಡಿ ಇವ್ರೆ ನಿಮ್ ಒಂದು ನಿಮಿಷ ಕೊಡಿ ನಾವು tally ಮಾಡ್ತೀವಿ. Right. Correct. Page 12 mine, my lord, is 12:30. Our destination and all.
Now he says it is purchased in a public auction.
My lord, LNDSR 15 ವರ್ಷಗಳ ಕಾಲ ಮಾಡಿರ್ತಾರೆ ವ್ಯವಹಾರ 13
On what basis you say that you purchased in a public auction? Elri the sales advocate.
my lords in page 36 my lords. Page 36 my lords.
This is payment of the upset price.
Upset price.
How do you say it's say an auction sale?
Page 16 ಅಲ್ಲಿ ಆಮೇಲೆ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ಸ್ ಆರ್ಡರ್ ಮೇಲೆ ಪೇಜ್ 16 ಇನ್ ಪೇಜ್ 4 ಮೇಲೆ DC ಆರ್ಡರ್
Annexure B na.
ಎಸ್ ಮೇಲೆ ಎಸ್
Annexure B ಯಾವ್ದು?
ಮೇಲೆ ಪೇಜ್ 16 ಮೇಲೆ ಇನ್ ಪೇಜ್ 4 DC ಆರ್ಡರ್ ಲಭ್ಯವಿರುವ RR ಪ್ರತಿಯಂತೆ ಗಾಟ್ ಇಟ್ ಮೇಲೆ
Page number.
Page 6.
Internal page ಹೇಳಿ.
ಇಂಟರ್ನಲ್ ಪೇಜ್ 4 ಮೇಲೆ
Type copy na ಇಲ್ಲ xerox copy ಇಲ್ಲ certificate copy?
Xerox copy of the Xerox ಮೇಲೆ
ಲಭ್ಯವಿರುವ
ಲಭ್ಯವಿರುವ RR ಪ್ರತಿಯಂತೆ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ನಂದಿ ಹೋಬಳಿ ತಿಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 44 ಪೈಕಿ 3 ಎಕರೆ ಜಮೀನು ತಹಸೀಲ್ದಾರ್ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ತಾಲೂಕು ಅವರ ಆದೇಶದ ಕ್ರಮಾಂಕ LNDSR 242 1972-73 ರಂತೆ 2/9/1978 ರಂದು 15 ವರ್ಷಗಳ ಕಾಲ ಪರಾಭಾರೆ ಮಾಡಬಾರದೆಂಬ ಷರತ್ತಿನ ಮೇಲೆ ರಾಮಪ್ಪ ಮುನಿಶ್ಯಾಮಪ್ಪ ಅವರಿಗೆ ಮಂಜೂರಾಗಿದ್ದು ಅದರಂತೆ 1982-83 ರಂತೆ ಹಕ್ಕು ಬದಲಾವಣೆ ಆದೇಶವಾಗಿರುವುದು ವ್ಯಕ್ತಪಟ್ಟಿರುತ್ತದೆ. ದರಖಾಸ್ತು ಕಡತದ ಆದೇಶದಲ್ಲಿ ಹಾಳೆಯಲ್ಲಿ ವ್ಯಕ್ತಪಡುವಂತೆ ಕ್ರಮಾಂಕ PR ನಂಬರ್ ಸೋನ್ಸೋ ಗುಡಿಬಂಡೆ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಈಡಿಗ ರೆಡ್ಡಿಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 20 12 ಎಕರೆ 34 ಗುಂಟೆ ಜಮೀನು ಹರಾಜು ಮೂಲಕ 10 ಹೆಚ್ಚಿನ ಬಿಡ್ ದಾರದ ಶ್ರೀರಾಮಪ್ಪ ಹೆಸರು ನಮೂದು ಇರುವುದು ವ್ಯಕ್ತಪಡಿರುತ್ತದೆ. ಈಸ್ ಡಿಫರೆಂಟ್ ಗುಡಿಬಂಡೆ ತಾಲೂಕು
ಎರಡು ಯಾವ್ದು?
ಗುಡಿಬಂಡೆ ತಾಲೂಕ್ ಫರ್ದರ್ ಮೇಲೆ
ನಿಮ್ದು ಯಾವ್ದು ಹಳ್ಳಿ? ತಿಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮ. Then why is he referring to this irrigator ಹಳ್ಳಿ?
ತಿಮ್ಮನಹಳ್ಳಿ village.
ಈಡಿಗ ರೆಡ್ಡಿಹಳ್ಳಿ is referring.
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
In fact, my lord, this is survey number is 44. ಇಲ್ಲಿ ಹೇಳೋದು ಸರ್ವೆ ನಂಬರ್ 44 ಪೈಕಿ 3 ಎಕರೆ ಜಮೀನು ತಹಸೀಲ್ದಾರ್ ಆದೇಶ ಕ್ರಮಾಂಕ 15 ವರ್ಷದಲ್ಲಿ ಮಂಜೂರಾಗಿದ್ದು ಹಕ್ಕು ಬದಲಾವಣೆ ಆದೇಶವಾಗುತ್ತದೆ. ದರಖಾಸ್ತು ಹಾಳೆಯಲ್ಲಿ ವ್ಯಕ್ತಪಡುವಂತೆ 50 ಗುಡಿಬಂಡೆ ತಾಲೂಕಿನ ರೆಡ್ಡಿಗಳು 20 that is survey number 20 he says, my lord, he is talking about 20 ಅದ್ಯಾಕೆ ಹರಾಜು ಮೂಲಕ ಅತಿ ಶ್ರೀರಾಮ್ ನಮೂದಿರುವುದು ಗುಡಿಬಂಡೆ ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ 50 ರಂತೆ
ಅರ್ಥನೇ ಆಗಲ್ಲ ಇದು.
Yes, ma'am.
May I request on next week? No, sir. Even I'll
ಗುಡಿಬಂಡೆ
completely
ತಾಲೂಕು
read them.
Mostly cut copy.
Yes, my lord, ಅಲ್ಲೆಲ್ಲ
ಯಾವ್ದೋ ಕೇಸ್ ಎಲ್ಲೋ
Yes, yes. Here only pertaining to survey number 44, my lord. He says in between survey number 20 ಅಂತ ಹೇಳ್ತಾರೆ. That is Idigareddyalli, it is a false. my lord.
Next week, my lord, senior out of.
I'll clarify, my lord. The original order, I'll get it.
2013.
15. Bill number 49, Sri Harike.
I appear for respondent number 1A2G, my lords. It may be taken on next week, my lord.
List 15th. Seal number 50 adjourned. Seal number 51. Visheshgiri Rao.
I pay for petitioner.
Yes.
What's the? There are two people claiming to be Muniga, son of Muniga, my lords. To that effect, affidavit was also, and last date of hearing I had submitted in the connected matter, there is order for dismissal of non-prosecution, none appears in the connected matter. I pay for petition in the main matter. However, my lords indicated it might not give me any benefit. So my what fell from the court was we would rather argue on the merit. My lords, the main contents taken by the state is that my grant records are not available in any of the files.
You are for the grantee.
Please, my lords,
Purchaser.
No, grantee, my lords. It's my request, it may be taken up day after tomorrow. I file an application for direction because their contention was that grant records was not there. Tahsildar has issued an endorsement that is available with him, but he cannot give me a copy because Deputy Commissioner directed him not to disclose any of the documents under 136 proceedings. I'll file an application, my lords, to that effect. DC can actually secure the records, my lords.
I can secure the records, my lord. I'll verify. You can verify. No need to file an application, my lord. I'll secure, my lord.
List. Because the contention is that grants records are not available. Now Tahsildar has issued an
So
endorsement.
whatever available documents, my lord, if it is genuine grant, definitely it will be available. I'll secure, my lord.
Date, my lords.
15.
ಇವತ್ತಲ್ಲಪ್ಪ 50 ಅಲ್ಲ ಇದು? 50, right?
51.
Seal number 52 and 53
51.
adjourned.
What is the
Seal
number?
number 54.
G688.
Anand Ishwar.
2712.
Purchaser's petition, my lord.
For respondent number 3, my lords.
Date of grant, my lord, is 25 to 1944, my lord. So the first sale is 1986. So the purchase of the property in person from my lord, from the first purchaser.
86 is the first alienation.
Please,
86 is the first alienation.
please, 86 is the registration, 86. 44 is the grant, my lord. 86 is the first sale, my lord.
Yes.
Then I have
Three
purchased the
applications.
property in 2003, my lord. Assistant Commissioner has restored the 2003. Then the order has been confirmed by the Deputy Commissioner, my lord. So Lordship may kindly say this orders has been quashed by this honorable court in the same coordinate bench of this honorable court, my lord. And review petition also filed, my lord. Review petition also dismissed. In the
My humble request, my lord,
in the
in
August,
this case,
same
the
orders has been quashed, my lord.
writ appeal is already filed, my lord.
This is the orders. Review petition and the writ petition also.
Against the said order, my lord, writ appeal 1492/24 is pending, my lord.
ಮೂರ್ ಕೇಸ್ ಯಾಕೆ ಹಾಕಿರೋದು?
ಹೌದು, 3 cases. The same order they are applying, my lord.
ಇದನ್ನು ಅಪೀಲ್ ಹಾಕ್ಬಿಡಿ ಹಂಗಾರೆ. ನಾಯಕರೇ ಇದನ್ನು ಅಪೀಲ್ ಹಾಕ್ಬೇಕು ತಾನೆ ಅವಾಗ?
ಇಲ್ಲ, ಒಂದು ಅಪೀಲ್, ಒಂದೇ ಆರ್ಡರ್ ಮೇಲೆ ಅದು ಅಪೀಲ್ ಹೋಗಿದ್ದು ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಡ್ಯೂ ಟು ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಇಟ್ ವಾಸ್ ಪೆಂಡಿಂಗ್. Resumption petition dismissal, immediately I have filed writ appeal, my lord. Writ appeal is pending against that order. In these cases, my lord, what happened 2003, my lord.
Same order, different purchaser.
Same order set aside ಇದ್ರೆ ನಾನೇ ಯಾಕೆ ಇಟ್ಕೋಬೇಕು ಇದನ್ನ?
ಅಲ್ಲ, ತಾವು ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಡಬಲ್ ಬೆಂಚ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಆಗಿದೆ, ಕನ್ಫರ್ಮ್ ಮಾಡಿ ಆಗಿದೆ ಆರ್ಡರ್ನ ಸ್ವಾಮಿ. ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ನ ಅವ್ರು ಅದನ್ನ ಸಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಅದು?
Yes, I have filed along with my objection statement.
Kindly see the review petition.
ಹಾಕಿದೆ ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ, ಇನ್ನೊಂದು ಡಿವಿಷನ್ ಮೆನ್ಷನ್ ಆಗಿದೆ ಅಂತಾರ ಅವರು.
The review petition also dismissed.
ಏನಾಯ್ತಂದ್ರೆ the owner second purchaser filed a writ petition.
ರೆಸಂಪ್ಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ಯಾರೋ ಅವ್ರ ತಾನೇ ನಾಯಕರು ತಾನೇ? ಏನಾಯ್ತು?
Allowed. Deputy Commissioner confirmed the order of the Assistant Commissioner. The purchaser filed writ petition before this honorable court. And he made a statement before this honorable court that he already sold the layouts, he is not having any interest in the writ petition. On that ground only writ petition is dismissed. But surprisingly, my lord, he already submitted to the court, he is not having any interest in the property. Again, he only filed the writ appeal. In the writ appeal also, he made very same submission. That I am already sold the sites and he don't have any interest.
Who are you?
I am the site purchaser from the original owner.
So the order of the deputy commissioner was challenged by the purchaser.
Purchaser.
Who has formed the layout and sold sites to you.
Purchaser, yes, yes.
He has withdrawn that.
No, he contested the matrimonial before the deputy commissioner.
Writ petition, he said he has no substantial interest, but therefore petition was dismissed.
Dismissed.
Therefore, the order of the deputy commissioner stands confirmed.
Confirmed.
Writ appeal is also dismissed.
Dismissed.
That we are the purchasers, my lord. He purchased the, my lord, sites before the initiation of proceeding before the assistant commissioner.
Then what is this order? Of Justice Magdum?
Yes, my lord.
What is this order?
This order, my lord, the challenging very same order passed by the assistant commissioner and
By
deputy.
another site purchaser.
Site purchasers.
And that has been allowed.
Site purchasers never questioned the order, my lord, only in this petition.
ಇವ್ರು ಯಾರು ಮತ್ತೆ?
Site purchasers.
Purchasers.
ಮಗ್ದುಮ್ ಸಾಹೇಬರು
Site purchaser, Swami,
They
site
are
purchaser.
different purchasers.
ಅಲ್ಲ ನಾಯಕರೇ,
Swami,
they claim that they are purchasers of sites.
sites, yes, my lord.
So they also say that the petitions in WP 10360 for 2022.
Yes,
They
ma'am.
are also site purchasers.
Yes, my lord.
And they had challenged the very same order before this court and that has been allowed.
My humble request, my lord, that order is subject matter of writ appeal 1492/24.
Correct. ಅದಕ್ಕೆ ನಾನು ಇದನ್ನು ಅಲೋ ಮಾಡ್ತೀನಿ, ಜೊತೆ ತಗೊಂಡಾಗ ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲ
ಅಲ್ಲ ಮತ್ತೆ ಯಾಕೆ ಸುಮ್ಮನೆ ಮತ್ತೆ ಡಬಲ್ ಬೇಡ. ಡಬಲ್
ಎಕ್ಸ್ಟ್ರಾ 3 ಕೇಸ್ ಬರುತ್ತಲ್ಲ, ನಿಮ್ಗೆ ಯಾಕೆ ಡಬಲ್ ಯಾಕೆ?
ಅಲ್ಲ ಅನೆಕ್ಸರ್ R2 ಹಾಕಿದೀನಿ. ರಿಟ್ ಅಪೀಲ್ ಆಲ್ರೆಡಿ ಕನ್ಫರ್ಮ್ ದ ಆರ್ಡರ್ ಆಫ್ ತಹಸೀಲ್ದಾರ್, ಆರ್ಡರ್ ಆಫ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್.
But the fact remains a coordinate bench of this court has set aside the impugned order.
ಅದನ್ನೇ ಕೋಆರ್ಡಿನೇಟ್, ಅದು ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ರಿಟ್ ಅಪೀಲ್ ಸ್ವಾಮಿ. ಮತ್ತೆ ರಿಟ್ ಅಪೀಲ್ ಯಾಕೆ ಹಾಕೊಳ್ಳೋದು ಅಂತ.
Take up this matter in writ appeal also.
ಅಲ್ಲ ಸುಮ್ನೆ ಯಾಕೆ ಎಲ್ಲ ಮೂರು ಮತ್ತೆ ಸ್ವಾಮಿ ಒಂದ 10 days ಟೈಮ್ ಕೊಡಿ ಸ್ವಾಮಿ, ಅದು ರಿಟ್ ಅಪೀಲ್ ಬರುತ್ತೆ ಕೋರ್ಟಿನ ಮುಂದೆ.
In review also, he has filed a review petition that is.
After dismissal of review petition only I have filed writ appeal.
ಇಲ್ಲ ಎಲ್ಲ ಅಲ್ಲೇ ರಿಟ್ ಅಪೀಲ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ರಿಟ್
ಅಲ್ಲ
ಅಪೀಲ್
ಎಲ್ಲೋ ಬೇಡ ಸ್ವಾಮಿ, ಸುಮ್ನೆ ಮತ್ತೆ ಡಬಲ್ ಆಗೋದು ಬೇಡ.
ಏನಾಗುತ್ತೆ?
ಅಲ್ಲ ಮುಗಿದು ಹೋಗುತ್ತೆ ಆ ರಿಟ್ ಅಪೀಲ್. ಯಾಕಂದ್ರೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಆಲ್ರೆಡಿ ಪಾಸ್ ಕನ್ಫರ್ಮಿಂಗ್ ದ ಆರ್ಡರ್ ಆಫ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್, ಡೆಪ್ಟಿ ಕಮಿಷನರ್.
If I accept your argument, I have to differ with the order of Justice Magdum. ಅಲ್ವಾ?
ಅಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಇವರು ಈಗಲ ಆರ್ಡರ್ ಅದನ್ನ ನಾನು ಅಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದ್ದೆ, ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಲ್ಲ ಅವಾಗ.
ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ಸಬ್ಮಿಷನ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ, ಒಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್ ಇದರಲ್ಲಿ ಈ ಓನ್ಲಿ ಅಪಿಯರ್ಡ್ ಫಾರ್ ದಿ ಪರ್ಚೇಸರ್ಸ್. ನಾನು ಆರ್ಡರ್ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ,
ಅದಲ್ಲೇ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೀವ್ರಿ ಇವ್ರೆ.
ಈ ಓನ್ಲಿ
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ.
purchasers and compromised with the grantees. Now conflicting of interest is now appearing for the grantees.
My humble request, my lord. My humble request, my lord, what happened in these cases? More than 46 site holders, they have come before the court. They have compromised, my lord, along with the grantees.
Page number 58.
Did you purchase for the, did you appear for the purchasers earlier?
Yes, yes.
Yes, earlier I have appeared. They have compromised because they have paid money with the grantees.
In that case, you appeared for the purchaser, now you are appearing for the grantee.
Grantees, yes, yes, ma'am.
ತಪ್ಪಾಗಲ್ವಾ?
ತಪ್ಪಲ್ಲ ಸ್ವಾಮಿ, ತಪ್ಪಿಲ್ಲ. That is compromise. ಅಲ್ಲ, what type of compromise they have took place, my lord? All the 46 members, they want to confirm their right. Therefore, I have advised the grantees and they have received consideration amount and compromise. These 3 persons, my lord, they don't want to compromise. That is the problem.
ಅಪೀಲ್ ಹಾಕಿ ನೀವ್ ಹೆಂಗಿದ್ರು ನೋಡಿ, ನಿಮ್ಗೆ ಮೂರ್ ಕಡೆ ಕೇಸು, ಗ್ರಾಂಟಿ ಕಡೆಯಿಂದ ಕೇಸು, ಪರ್ಚೇಸರ್ ಕಡೆಯಿಂದ ಕೇಸು.
ಅಲ್ಲ, ಗ್ರಾಂಟಿ ಕಡೆಯಲ್ಲಿದ್ದ ಆಗ್ಬೇಕಾದ್ರೆ ಕಾರಣ ಇಷ್ಟೇ. ಯಾಕಂದ್ರೆ ಅದನ್ನ ನಾವು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿದ್ದು ನಾವೇ ಕೂತ್ಕೊಂಡು ನ್ಯಾಯಾಲಯದಲ್ಲೇ ಮಾಡಿದ್ದ, ಅದನ್ನ ನಾವು ಬೇರೆ ಕಡೆ ಮಾಡಿಲ್ಲ. ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಫೈಲ್ಡ್ ಬಿಫೋರ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್.
ಅಪೀಲ್ ಹಾಕಿ.
ಅಲ್ಲ ಇದು ಒಂದು 10 ದಿವಸ ಟೈಮ್ ಕೊಡಿ ಸ್ವಾಮಿ. ಅದು
ಬೇಡ,
ರಿಟ್ ಅಪೀಲ್
appeal
ಏನಾಗತ್ತೆ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ನಾನು ಹೇಳ.
appeal ಹಾಕಿ.
ಅಲ್ಲ, my
What
humble
is the order
request,
that
10
is
days
issued
time
here?
may be granted.
What is the order impugned here? ಇದೇ ಆರ್ಡರ್
Same order, my lord.
29. Next year B na.
Next year B and C.
Date ಅಲ್ಲಿ ಇದೆ 29/2003.
29/2003 and the 12/3/2008 is the DC order, my lord. The B and C. Same.
Make sure B and C.
On 2/9/2003, ಇನ್ನು
Same
ಒಂದು
order, next.
12/3/2008.
This petition is directed against the order of resumption passed by the Assistant Commissioner on 2/9/2003, which has in turn been confirmed with the Deputy Commissioner by an order dated 12/3/2008, regular next year B and C respectively. In it, counsel for the petitioner points out that the very same impugned orders were the subject matter of WP 10360/2022, and this court by an order dated 21st of August 2023 had allowed the writ petitions and had quashed the orders of resumption passed by the Assistant Commissioner and also the order of confirmation passed by the Deputy Commissioner. He also submits that a review petition filed against the said order in RP number 470/2023 was also dismissed. In my view, since the impugned orders have already been quashed by a courted bench of this court, the said orders will have to be also quashed in the petitions filed by the petitioners who claim to be the purchasers of site. Accordingly, writ petition is allowed. The impugned orders are quashed.
My humble request, my lord. One
ಇಲ್ಲಿ
writ
writ appeal
appeal,
ಹಾಕೊಳ್ಳಿ.
writ appeal order kindly may be referred, my lord.
ಬೇಡ ಅಲ್ಲೇ ಹಾಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಇನ್ನೊಂದು ರಿಟ್ ಅಪೀಲ್ ಮೊದಲಾದದ್ದು ಅವೆಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಇದಾವೆ
ಎಲ್ಲ ಅದೆಲ್ಲ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ನಾನು ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಏನ್ ಹೇಳಿದ್ರು ಒಪ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ.
ಅಷ್ಟೇ. ಆಯ್ತು.
3 ಮೀಟ್ರಾ?
Seal number 55, Shri G. B. Nandish Gowda.
My lord, the petitioners, my lord, the legal representative of the original grantee. The respondent number 4 to 6 herein, my lord, they are claiming to be they are also legal representative of the original grantee and initiate the proceedings against the respondent number 7 to 11. At the first instance, my lord, without looking to the records, my lord, Assistant Commissioner ordered for restoration and resumption of the land in favor of respondent number 4 to 6. 7 to 11 preferred an appeal, same has been set aside and remanded before for fresh consideration. After remand also, my lord, though there is a clear recitals in the original Darkhas register is not available. Only on the stray entry during the relevant year in the revenue records RTC. Again, Assistant Commissioner ordered for restoration. 7 to 11 again preferred an appeal, came to be dismissed. In the meantime, my lord, the 4 to 6, they are trying to interfere with my position. I filed suit for the relief of injunction. Suit decreed in favor of the petitioners herein.
You are the grantee.
I am the grantee. I have produced the grant certificate.
Application for resumption has been
filed by the respondent number 4 to 6 who are nowhere concerned with my family.
They claim to be LRs of
LRs of the grantee. Yes.
Resumption application is rejected.
Yes. A resumption application allowed now, and the same has been confirmed by the Deputy Commissioner. The same has.
If you have got a decree in terms of this property, then how are you affected by this order?
What happened, my lord? Without making me as a party.
The order of resumption. The effect of the order of resumption is the alienation is set aside.
Yes.
The matter stands
remitted to the legal heirs of the original grantee. My lord,
in the proceedings for restitution, did you participate?
No, we are not made parties.
What is the order passed by the Assistant Commissioner in the restitution proceedings?
My lord, I would
not be agreed by the order of resumption.
My lord, I agreed, my lord, though the order passed by the Assistant Commissioner.
If I set aside this order, then the land goes to the purchaser.
My lord, there is no alienation. So far as subject matter of the land is concerned, my lord, there is no alienation. At no point of time we are alienated.
If I disturb the order of resumption, then the title which has been set aside will stand restored.
My lord, unless making us a petitioners as a party to the proceedings, my lord.
No, I think it's better that you agitate your rights in the restitution proceedings that the assistant commissioner will take up after this order is passed. If you were to challenge this order and if I set aside this order, the land will go back to the purchasers.
ಇಲ್ಲ ವಾಟ್
It has taken place ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲಿ ಏನಾಗಿದೆ
1966
ಫಾರ್ ಎ ಮೂಮೆಂಟ್ ಮೈ ಲಾರ್ಡ್ ಐ ವುಡ್ ಲೈಕ್ ಟು ಟೇಕ್ ಮೈ ಲಾರ್ಡ್ ಅಟೆನ್ಷನ್ ಟು ದಿ ಆರ್ಡರ್ ಪಾಸ್ಡ್ ಬೈ
He is claiming to be the grantee. I don't know why he should challenge the order of resumption.
Yes.
ಇಲ್ಲ ಒಂದೇ ಒಂದ್ಸಲಿ ಐ ವುಡ್ ಲೈಕ್ ಟು ಟೇಕ್ ಮೈ ಲಾರ್ಡ್ ಅಟೆನ್ಷನ್ ಟು ಇಂಪೇಜ್ ನಂಬರ್ 61 ಆರ್ಡರ್ ಪಾಸ್ಡ್ ಬೈ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್. ಇಲ್ಲಿ 61
This was
Annexure
filed
G.
by Krishnamurthy,
4 to 6
son of Ramaya.
4 to 6 herein. ಇಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಲ್ಲಿ ಈ ಸಂಬಂಧ ಉಭಯ ಪಕ್ಷಕಾರರಿಗೆ ವಿಚಾರಣಾ ನೋಟಿಸ್ ಜಾರಿ
ಯಾವ
ಮಾಡಲಾಗಿದೆ.
second paragraph?
ಇಂಪೇಜ್ ನಂಬರ್ 61 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ.
ಸರಿ.
ಈ ಸಂಬಂಧ ಉಭಯ ಪಕ್ಷಗಾರರಿಗೆ ವಿಚಾರಣಾ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಎದುರುದಾರರು ತಮ್ಮ ವಕೀಲರ ಮೂಲಕ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರಾಗಿ ಲಿಖಿತವಾದ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ತಹಸೀಲ್ದಾರ್ ಮೈಸೂರು ಅವರಿಗೆ ಕರಿಯ ಅಲಿಯಾಸ್ ಕರಿಯ ಮತ್ತು ಗುಂಡ ಮತ್ತು ಇವರಿಗೆ ದರಖಾಸ್ತು ಮೂಲಕ ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತವನ್ನು ಹಾಜರುಪಡಿಸುವಂತೆ ತಿಳಿಸಲಾಗಿದ್ದು, ಈ ಬಗ್ಗೆ ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತವು ಇರುವುದಿಲ್ಲವೆಂದು ಅರೆ ಸರ್ಕಾರಿ ಪತ್ರ ಬರೆದಿರುತ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ವಿಶ್ಲೇಷಣೆ. ಮೈದಾನಹಳ್ಳಿ ಗ್ರಾಮದ ಗೋಮಾಳ ಆಗಿದ್ದು, ಈ ಜಮೀನಿನ ಪೈಕಿ ಕರಿಯ ಅಲಿಯಾಸ್ ಪುಟ್ಟ ಗುಂಡ ದರಖಾಸ್ತು ಮೂಲಕ ಮಂಜೂರಾಗಿರುವ ಜಮೀನಾಗಿರುವುದಾಗಿ ಕೈ ಬರವಣಿಗೆ RTC ಯಲ್ಲಿ ನಮೂದಾಗಿರುತ್ತದೆ. ಶ್ರೇ ಎಂಟ್ರಿ ಇನ್ ದಿ RTC. ಹಾಗೂ ಮೂಲ ಮಂಜೂರಿದಾರರಾದ ಪುಟ್ಟಯ್ಯನ ಮಕ್ಕಳಾದ ಬುಂಡಯ್ಯ ಕರಿಯವರಿಂದ ನೋಂದಣಿ ಸೋ ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುತ್ತಾರೆ. ಈ ಕ್ರಯ ಪತ್ರವನ್ನು ಪುಟ್ಟಯ್ಯ ಮಗ ಗುಂಡಯ್ಯ ಕರಿಯ ಆದಿ ಕರ್ನಾಟಕ ಎಂದು ನಮೂದಾಗಿರುತ್ತದೆ. ಫಸಲು ಪಹಣಿಯಂತೆ ಈ ಜಮೀನು 60ರಲ್ಲಿ ಮಂಜೂರಾತಿ ಆಗಿರುವ ಜಮೀನೆಂದು ಮೇಲ್ನೋಟಕ್ಕೆ ತಿಳಿದು ಬರುತ್ತದೆ. ಆದರೆ ಈ ಬಗ್ಗೆ ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತವು ಕಚೇರಿಯಲ್ಲಿ ಇರುವುದಿಲ್ಲವೆಂದು ತಹಸೀಲ್ದಾರ್ ಮೈಸೂರು ಅವರು ಬರೆದಿರುವ ಮೂಲಕ ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಮೂಲ ಮಂಜೂರುದಾರರು ಪರಿಶಿಷ್ಟ ಜಾತಿಗೆ ಸೇರಿದವರು ಆಗಿದ್ದು ಎಂದರೆ ಸದರಿಯವರಿಗೆ ಪ್ರಶ್ನಿತ ಜಮೀನು ಸಾಲಿನಲ್ಲಿ ಮಂಜೂರಾಗಿರುವ ಜಮೀನು ಆಗಿರುವುದರಿಂದ ಮತ್ತು ಮಂಜೂರಾತಿ ಉಲ್ಲಂಘಿಸಿ 15 ವರ್ಷ ಒಳಗೆ ಪ್ರಶ್ನಿತ ಜಮೀನನ್ನು ತಾವು ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುವುದರೆಂದು ಸಾಬೀತುಪಡಿಸಿ ದಾಖಲಾತಿಯನ್ನು ಎದುರಾದರೂ ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ನೋ ಸಚ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅಲೋಡ್. ಇದನ್ನೇ next, I would like to take my lord attention to next order passed by the deputy commissioner. Annexure H, page number 67.
Yes.
ಇಲ್ಲಿ ವಿಶ್ಲೇಷಣೆ ಪ್ಯಾರಾ 9 ಇನ್ ಪೇಜ್ ನಂಬರ್ 67 ಪ್ಯಾರಾ 9. ಪ್ರಕರಣದ ಸ್ವತ್ತು ಕಾಯ್ದೆಯಲ್ಲಿ ವ್ಯಾಖ್ಯಾನಿಸಿರುವ ರೀತಿಯ ಮಂಜೂರಾತ ಜಮೀನು ಎಂಬುದರ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡಿರುವುದು ಖಚಿತವಾಗಿಲ್ಲವೆಂದು ಮತ್ತು ಸದರಿ ಸ್ವತ್ತಿನ ಪರಬಾರಿಯ 66ನೇ ಸಾಲಿನಲ್ಲಿ ಜರುಗಿದ್ದು, ಮಂಜೂರಾತಿದಾರರು ವಾರಸುದಾರರು ಸುಮಾರು 39 ವರ್ಷಗಳ ತರುವಾಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದು, ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಮಾನ್ಯ ಮಾಡಿರುವುದು ಕಾನೂನುಬದ್ಧವಲ್ಲ ಎಂದು ಮೇಲ್ಮನವಿದಾರರ ವಾದವಾಗಿರುತ್ತದೆ. ಪ್ರಶ್ನಿತ ಉಪವಿಭಾಗ ಆದೇಶ ಗಮನಿಸಲಾಗಿ ಪ್ರಕರಣದ ಸ್ವತ್ತಿನ ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತ ಲಭ್ಯವಿಲ್ಲವೆಂದು ತಹಸೀಲ್ದಾರರು ತಿಳಿಸಿರುತ್ತಾರೆ. ಮಂಜೂರಾತಿ ಖಚಿತಪಡಿಸಿಕೊಳ್ಳಲು ಮತ್ತು ಫಸಲು ಪಹಣಿಯಲ್ಲಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಅವಲಂಬಿಸಿದ್ದು, ಅದರಲ್ಲಿ 1960ರ ಸಾಲಿನಲ್ಲಿ ಪ್ರಕರಣದ ಸ್ವತ್ತು 60ರ ಸಾಲಿನಲ್ಲಿ ಮಂಜೂರಾಗಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ ಎಂದು ಈ ಸ್ವತ್ತು ಮೂಲ ಮಂಜೂರಾತಿ ಆಗಿಲ್ಲದ ಜಮೀನೆಂದು ಈ ಪ್ರಕರಣದ ಮೇಲ್ಮನವಿದಾರರು ರುಜುವಾತು ಪಡಿಸಿಲ್ಲವಾದ್ದರಿಂದ ಮೂಲ ಭೂ ದಾಖಲೆಗಳಲ್ಲಿ ಉಲ್ಲೇಖವಿರುವ ಆಧಾರದ ಮೇಲೆ ಇದು ಮಂಜೂರಾತಿ ಜಮೀನು ಎಂಬ ನಿಲುವಿಗೆ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಬಂದಿರುತ್ತಾರೆ. ಪ್ರಸ್ತುತ ಮೇಲ್ಮನವಿಯಲ್ಲಿಯೂ ಸಹ ಮೇಲ್ಮನವಿದಾರರು ಇದು ಕಾಯ್ದೆಯಲ್ಲಿ ವ್ಯಾಖ್ಯಾನಿಸಿರುವ ಮಂಜೂರಾತಿ ಜಮೀನು ವ್ಯಾಪ್ತಿಗೆ ಪ್ರಕರಣದ ಸ್ವತ್ತು ಒಳಪಡೆಯುವುದಿಲ್ಲ ಎಂಬುದರ ಬಗ್ಗೆ ಸೂಕ್ತ ಸಾಕ್ಷ್ಯಾಧಾರಗಳು ಸಾಬೀತು ಮಾಡಲು ವಿಫಲವಾಗಿರುತ್ತಾರೆ. ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತ ಲಭ್ಯವಿಲ್ಲದೆ ಇದ್ದ ಪಕ್ಷದಲ್ಲಿ ಮಂಜೂರಾತಿಗೆ ಸಂಬಂಧಿಸಿದ ಪರ್ಯಾಯ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುವ ಯಾವುದೇ ಪ್ರಯತ್ನ ಮಾಡಿರುವುದಿಲ್ಲ. When such being the case, my lord, when the original documents itself has proceedings has to be quashed.
And this got right. You are claiming to be the grantee.
My lord, I have produced the grant certificate, index of lands, records of rights.
If there is an alienation made, which has been set aside,
My lord,
that inures to your benefit.
may counsel, survey number 123, Gomala land, it is not in dispute. 41, the same was granted, 4 acres of the land in the year 1941 granted in favor of my grandfather is also not in dispute. If the alienation had taken place with respect to some other land, how it is made applicable to my land, my lord?
Are you concerned about this? The person who has purchased the land, whose land is now lost and is resumed, they have accepted this order. The land goes back to the government.
What happened, my lord? 4 to 6, they have colluded with 7 to 11.
ಒಳ್ಳೆದಿದ್ದಲ್ಲಿ ನಿಮ್ಗೆ now that
Without making us a party to the
And
proceedings.
my lord,
that alienation that was there,
ಹೌದು.
right or wrong, is now set aside.
yes,
So the title of yours becomes clear. Why are you fighting this battle?
and assistant commissioner says ವಿಧಿಬದ್ಧ ಎಲ್ಲ ಮೂಲ ವಾರಸುದಾರರಿಗೆ my lord. whoever legal heirs, my lord, legal,
Shall I get
ಖಾತೆಯನ್ನು
the
ಮೂಲ
instructions?
ಮಂಜೂರುದಾರರು ಎಲ್ಲ
I'll permit
ವಿಧಿಬದ್ಧವಾಗಿ.
you to make a claim.
Yes.
In the event they seek to disturb your possession on the basis of this decree, why do you want to unnecessarily file this petition? You are awakening the purchasers.
With the above observation, my lord, it may be disposed. Anyhow, I had the benefit of injunction also, my lord, the against the 4 to 6.
The petitioner contents. Petitioners content that land bearing cert number 123 mentioning 4 acres situated Maidanalli village, Ilwada Hobli, Mysuru Taluk, Mysuru district was granted in favor of their grandfather, Alva? Sri Mallegoda on 14/7/1940. And his name has been entered in the revenue records ever since. They contend that they have been in possession of the said land and they had in fact filed a suit in OS 407/2023 before the 5th additional civil judge in JMFC at Mysore against
Yes, respondent 4 to 6 herein.
against respondents 4 to 6. And they also had obtained a decree on 10/10/2023. It is therefore their contention that their possession has also been recognized and protected by a decree of the civil court. They contend that notwithstanding the above, respondents 4 to 6 colluded with respondents 7 to 11 and initiated proceedings for resumption, which has ultimately been accepted by the Assistant Commissioner and also confirmed by the Deputy Commissioner. They contend that on the basis of this resumption proceedings, their rights are sought to be interfered with. Next paragraph. It is to be stated here that since the petitioners claim that they are the LRs of the original grantee and are in possession and are also protected by a degree of injunction, any resumption proceedings that have been initiated by respondents 4 to 6 will ultimately inure to the benefit of the petitioners. Full stop. That is because if there has been an alienation in respect of the lands, granted lands, that alienation has been declared to be null and void by the Assistant Commissioner and confirmed with the Deputy Commissioner. If the respondents 4 to 6 seek for restitution on the basis of the said order of resumption, it will be open for the petitioners to put forth their claim on the basis of OS 407/2023 and also on the basis of they being the grandchildren of the original grantee. In my view, the petitioners cannot be said to be aggrieved of the orders of resumption since they are indirectly benefited by the said order of resumption. The writ petition is therefore disposed of subject to the above observation. Please call.
Number 56, GS Srikantegoda.
Mangaudra.
But in this case, the petitioners herein are the purchasers. And the respondents, and the petitioner has purchased this property under the petition.
What is the date of the grant?
Date of the grant 1981,
1981.
sale 2011. After the action.
ಅಲ್ಲ ಅದರಲ್ಲಿ Lash may kindly take sale deed ಮೇಲೆ annexure B. Sale deed annexure B. That is made on 3/3/2011. The petition.
B na ಏನು?
3 B ಹೋಗಿ. Annexure B.
Annexure A ಏನು?
ಏನು ಸೇಲ್ ಡೀಡ್ ಅವ್ರೇನು ಕ್ವಶನ್ ಮಾಡಿಲ್ಲ. ಇವರು 3/3/2011 one Pandurangaya has filed this appeal before the AC. In that, Lash may kindly see the second para. Page number 28, annexure B.
This is by
KC Dodrangaya. ಸಾಕಮ್ಮ ಮತ್ತು
Rangappa is the purchaser.
ಇವರ ಮೈನರ್ ಮಗ ಪಾಂಡ್ರಂಗಯ್ಯ.
Rangappa is the purchaser.
ರಂಗಪ್ಪ is the purchaser.
The sellers are Dodrangaya, his wife Sakamma, and their minor children Pandurangaya.
4 ವರ್ಷ. ಇದು 2011 ಅಲ್ಲಿ ಇವ್ರು 4 ವರ್ಷ ತೋರಿಸಿ ಮಾಡಿದ್ದಾರೆ. Now he filed according to him appeal in 2016 and 17. Ilashma kindly.
Application for resumption.
ಯಾರು ಪಾಂಡ್ರಂಗಯ್ಯ he has filed this application. Kindly see his age, my lord. As in 2016-17 11ರಲ್ಲಿ 4 ವರ್ಷ ಇದ್ದಿದ್ದು 16-17ಕ್ಕೆ 22 ವರ್ಷ ತೋರಿಸಿ ಅಪೀಲ್
ಆಯ್ತಲ್ಲ, ಏನ್ ಪಾಯಿಂಟ್ ಏನು? It is a granted land.
Yes.
ಗ್ರಾಂಟೆಡ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲ, ಅದು ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಆನ್ಸಿಸ್ಟ್ರಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿ ಪ್ರಾಪರ್ಟಿನ.
But what is the finding of the assistant commissioner?
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅವರು ಈ ರೆಕಾರ್ಡ್ಸ್ ಎ ಫೈಂಡಿಂಗ್ ದಟ್ ದಿಸ್ ಇಸ್ ಎ ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟೆಡ್ ಅಂಡರ್ ಬಗರುಕಮ್ ಸಾಲ್.
Yes.
ಬಗರುಕಮ್.
Page 45 ಅಲ್ಲಿ.
45.
Page 45, bottom param. ಸದರಿ ಮಂಜೂರಾತಿ ಆದೇಶ ರೀತ್ಯ ಕಚೇರಿ ಜ್ಞಾಪನ ಪತ್ರ so and so ಇದ್ದು. So
how can this be a granted land?
My lord, for SC, my lord, they have been, my lord, 45 ಅಲ್ಲಿ ಪ್ರಕರಣದ ಕುರಿತು, that is condition is imposed in this, my lord. ಪ್ರಕರಣದ ಕುರಿತು ತಹಸೀಲ್ದಾರ್ ಶಿವರವರಿಂದ ಸ್ವೀಕೃತವಾದ ಮೂಲ ಮಂಜೂರಾತಿ ಕಡತ ಪರಿಶೀಲಿಸಲಾಗಿ ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಕಾಲಂ ST ಎಂದು ಫಾರಂ ನಂಬರ್.
He may be a scheduled caste.
Yes, my lord. Bagarukum.
But if he was an unauthorized cultivation,
Yes.
it is not granted because he belongs to scheduled caste. It is because he was an unauthorized possession that it is regularized. How can you call that as a
ಇಲ್ಲ
granted?
ರೆಗ್ಯುಲರೈಸ್ ಆಗಿದೆಯಾ ಇಲ್ವಾ ಅಂತ ಫರ್ದರ್ ವಿ ನೀಡ್ ಟು ಸಿ, my lord.
This can't be a granted land, Alpha.
ಕಿಮ್ಮತ್ತು ಪೋಡು ಹಾಗೂ ಬಂಧಕರ ವಜಾ ಮಾಡಿರುತ್ತದೆ. ವರ್ಷಕ್ಕೆ 1 ಎಕರೆಗೆ 1 ರು ದಂಡ ವಿಧಿಸಿರುತ್ತದೆ. ಸಾಗುವಳಿ ಚೀಟಿ
That is a penalty for conversion
ಮಂಜೂರಾತಿ
fine ತರ.
Yes, my lord, it is confirmed.
Then how can you see the definition of granted land?
ಸಕ್ರಮಗೊಳಿಸುವ ಬಗ್ಗೆ ಸ್ಥಳ ಇಲ್ಲ, ಬಗರುಕುಂ ಬರೋದಿಲ್ಲ. ಬಟ್ ಸಕ್ರಮಗೊಳಿಸುವ ಬಗ್ಗೆ ಸ್ಥಳ ತನಿಖೆ ಕುರಿತಂತೆ ಉಪ ವಿಭಾಗ ಪತ್ರ ಬರೆದಿರುವುದು ದಿನಾಂಕ 82ರಲ್ಲಿ LND ಸ್ಥಳ ತನಿಖೆ ಬಾಬ್ತು ಮುಂದಿನ ಅಗತ್ಯ ಕ್ರಮಕ್ಕೆ ಕಡತವನ್ನು ಹಿಂತಿರುಗಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. It is regularized, that is not confirmed, my lord. Further, my lord, PTC
ಎಲ್ಲೋ ಓದ್ತಿದಾರೆ ಇವ್ರೆ ಕನ್ಫರ್ಮ್ ಆಗಿಲ್ಲ.
page 45 ಅಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲೇನೆ ಸದರಿ ಮಂಜೂರಾತಿ ಆದೇಶ ಮೇಲೆ
Yes.
ಜ್ಞಾಪನ ಪತ್ರ ದಿನಾಂಕ 7/1981 ಇದ್ದು 14/9/82ರಲ್ಲಿ ಪ್ರಸ್ತಾಪಿತ ಸರ್ವೆ ನಂಬರ್ನಲ್ಲಿ ಬಗರುಕುಂಬಿಂದ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಪರಿಶಿಷ್ಟ ಜಾತಿ, ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಇತರೆಯವರ ಜಮೀನನ್ನು ಸಕ್ರಮಗೊಳಿಸುವ ಬಗ್ಗೆ ಸ್ಥಳ ತನಿಖೆ ಕುರಿತಂತೆ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳಿಗೆ ಪತ್ರ ಬರೆದಿರುವುದು ಮತ್ತು ದಿನಾಂಕ 28/9/82ರಲ್ಲಿ LND SRU 82-83 ರೀತಿಯ ಸ್ಥಳ ತನಿಖೆ ಮಾಡುವ ಬಾಬ್ತು ಮುಂದಿನ ಅಗತ್ಯ ಕ್ರಮಕ್ಕೆ ಕಡತವನ್ನು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಹಿಂದಿರುಗಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಎದುರುದಾರರ ಪರ ವಕೀಲರು PTCL ಕಾಯ್ದೆ 2 ಉಲ್ಲಂಘನೆ ಆಗಿರುವುದಿಲ್ಲವೆಂದು ಪರಿಶಿಷ್ಟ ಪಂಗಡ ನಾಯಕರ ಸಮುದಾಯದವರಿಗೆ ಮಂಜೂರಾಗಿದ್ದು LND SR 82-82ರಲ್ಲಿ ದಿನಾಂಕ 81ರಂದು ಕಚೇರಿ ಟಿಪ್ಪಣಿ ಪರಿಶಿಷ್ಟ ಜಾತಿ, ಪರಿಶಿಷ್ಟ ಪಂಗಡದವರ ಕಿಮ್ಮತ್ತು ಪೋಡು ಬಾಂಧು ಕರ ವಜಾ ಮಾಡಿರುತ್ತಾರೆಂದು ತಿಳಿಸಿರುವುದರಿಂದ ಸದರಿ ಜಮೀನು ಪರಾಭಾರ PTCL ಕಾಯ್ದೆ 42 ಉಲ್ಲಂಘನೆ ಆಗುತ್ತದೆ. ಪರಾಭಾರ ಸಿಲ್ಲವಾದ್ದರಿಂದ PTCL ಉಲ್ಲಂಘನೆ ಆಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಕೆಳಕಂಡಂತೆ ಆದೇಶ ಮಾಡಿದೆ.
How can this be a granted land?
My lord, that's what Mali is not clarity in the SC order, my lord. He says Bagarukum and ಇನ್ನು ಅದು ಸ್ಥಳ
What is the
ಪರಿಶೀಲನೆ
TC say?
DC ಅದನ್ನೇನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ.
and ST ಅಂತ ಹೇಳ್ತಾರಷ್ಟೇ. ಇಲ್ಲಿ ಬಗರುಕುಂಗೆಲ್ಲ
ಫಸ್ಟ್ ಪ್ರಿಯಾಂಬಲ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅದನ್ನ
that's what my lord, condition imposed was 15 years, my lord.
That may be so.
Yes, my lord. Permission is not required. But after the condition is lapsed, my lord, this is a.
No, if it's not a granted land,
Yes, my lord.
then the question was.
Even if it is, no, my lord, even if it is Bagarukum, my lord, Bagarukum, my lord, 15 years condition is imposed here, my lord. Bagarukum under, my lord, it is land if it is confirmed, my lord, 1981. Sale has taken place in the year 2011. lapse of 15 years it is
After
said.
15 years only.
ಇಲ್ಲ ಗ್ರಾಂಟೆಡ್ ಲ್ಯಾಂಡೇ ಬರಲ್ಲ ಅಂತ ನಾನು
ಬರೋದೇ ಇಲ್ಲ, yes, yes.
ಕರೆಕ್ಟಾ?
If it is my lord Bagarukum, my lord, it will not attract PTCL, definitely.
The petitioner is
It can
the
be, my lord.
purchaser. Purchaser who purchased the lands in question under two sale deeds, huh?
Yes, ma'am. Two sale deeds.
V3
Annexure
2000.
A and B. Both are on same date.
The respond number 4 approached the Assistant Commissioner in the year 2016-17, contending that the land in question had been granted to his father, huh?
My lord.
Grandfather.
ಇದರಲ್ಲಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಅಲ್ಲಿ page 7 ಅಲ್ಲಿ ಈ ಸೇಸ್ my lord ಅದು ಏನು ಬಗರುಕುಮಲ್ಲಿ ವಿಲ್ my lord that is ಕಿಮ್ಮತ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ವಿಲ್ collect from the grantees.
You collect a premium.
ಕಿಮ್ಮತ್
yes.
ವಜಾ ಆಗಿರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಅ ಫ್ರೀ ಗ್ರಾಂಟ್ my lord. And ಈ ಸೇಸ್ ತಹಸೀಲ್ದಾರ್ ರೆಕಾರ್ಡ್ಸ್ my lord ಅದು
If a scheduled caste is an unauthorized possession,
ಪ್ಲೀಸ್
the requirement of paying that particular amount is dispensed with.
ಎಸ್ my lord.
How can it become a granted land?
My lord, he says Tahsildar, my lord, the deputy commissioner, when he called for the records, my lord, he says ಮಂಜೂರಾದ ಜಮೀನ್ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. ಯಾವುದೇ ವಿಧದಲ್ಲೂ
Okay, how does it become Manjurati Jamin? I want to know, because it's not a grant, for it to be a granted land.
yes,
We have to make an application seeking for grant.
Yes,
The
ma'am.
land grant rules,
earlier,
certain percentages set apart for grant to SC/ST persons.
yes, my lord,
Only if it's a grant under the land grant rules,
yes, my lord,
can it be considered as a granted land?
yes, my lord. It is under. That is not come under, my lord, it's not come under PTCL, but Bagarukum only, my lord.
Contending that
Divergent findings, my lord, here
The-
Tahsildar says ಕೆಲವು ಕಡೆ ಮಂಜೂರಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ ಡೈವರ್
the land in question had been granted to his
ಬಗರುಕುಮ
grandfather,
ಹೇಳ್ತಾರೆ, ಗ್ರಾಂಟ್ ಅಂತ ಹೇಳ್ತಾರೆ.
and in violation of the terms of the grant, the property had the Assistant Commissioner in his order has recorded a finding in the following terms. Thus, as could be seen from the said order, the land in question was under the unauthorized cultivation of the petitioner's grandfather, and this unauthorized occupation has been regularized. It is therefore clear that the land in question was not a granted land as defined under the PTCL Act. So in order to give the character of a granted land, necessarily under the PTCL Act, necessarily it will have to be established that applications were filed by the grantee seeking for grant on the ground that he or she belongs to scheduled caste and are entitled for grant of the available lands earmarked for scheduled caste and scheduled tribes.
Please.
It is only if the lands are granted provided under the Karnataka land grant rules, and from the lands which are earmarked for scheduled caste and scheduled tribe, can they come within the definition of a granted land? The statutory right of an unauthorized occupant to be regularized of his unauthorized occupation cannot convert the said land to be a granted land as defined under the PTCL Act.
regularizing is pre-existing right.
In view of the fact that the authorities have themselves recorded a finding that the grandfather's unauthorized possession was merely regularized, the very initiation of proceedings under the PTCL Act would be one without jurisdiction. So consequently, the impugned orders are set aside. Writ petition is allowed.
That also may kindly be observed because he's a minor.
ಏನಕ್ಕೆ ಅದ್ಯಾಕ್ ಬೇಕು ನಿಮ್ಗೆ?
ಅಲ್ಲ ಅದನ್ನ ಒಂದ್ ಸ್ವಲ್ಪ ಅಬ್ಸರ್ವ್ ಮಾಡಿ ಇಟ್ಟಿದ್ರೆ ಇಟ್ಸ್ ಬೆಟರ್ ಮಲ್ಲ 2011 ಅಲ್ಲಿ his own
In what way does it make? FCID has no jurisdiction at all.
much
Finally hearing. Seal number 57, Shri C.R. Ravi Shankar, Gopal Krishna N.
57, my lord. 2 weeks.
Relist.
2 weeks.
2 weeks.
26th. 58 urgent, seal number 59. Vivek Anthony Betta.
Petition, my lord. This petition was for grant of probate, my lord. On 8th September, the petitioner had led evidence, my lord. The will was marked, the death certificate was marked. But I had taken citation as per the orders of this honorable court, my lord. Order was passed on 23rd November 2003 for citation. Citation was taken out on 8th of December 2003, my lord, and accepted on 3rd of January 2024. Thereafter, the matter was posted for evidence, my lord. Petitioner came himself and he led his evidence, my lord. The will was marked as well as the death certificate.
Attesting witnesses?
No, the issue was the attesting witnesses have not been traceable, my lord. I've mentioned that in my petition in paragraph 6, my lord. Because of that, the petitioner had come and led evidence, my lord. Even in his affidavit, he has stated that attesting witnesses are not traceable because the will was executed in 2010, my lord. And they were merely workers of the testator. So they were gone back to their hometowns, my lord, which is in the north of the country.
But I think you should take steps in merely saying that they are unavailable.
Lord, I've taken all due process to find them, my lord, but I couldn't.
See the Evidence Act.
Please, my lord, I concede, my lord, the Evidence Act says at least one of the witnesses should be present, my lord. I've stated both in my affidavit and petition, my lord.
No.
That in spite.
You should make an effort to take steps.
Lord, if a court notice may be given, my lord, because I have tried, the petitioner has tried himself, my lord.
I can't issue court notice. Kindly see section 68.
Please, my lord.
You will have to take steps in case you come out with some proof that they're not traceable. Something I can do, take out paper publication against them or do something.
Please, my lord, if I'll take out paper.
See section 68.
Please, my lord. So, just bring the book, my lord. Or may I bring the book?
And
my lord?
subject to the process of the court and capable of giving evidence.
Please, my lord, that.
You'll have to take out process in respect of them in any manner.
At the address that's mentioned in the will, I'll take out that address because that's only known address, my lord.
Make out an application for summoning them or something.
Please.
We will issue. If they don't come, then let us see.
Please, my lord. Or maybe heard on 15th, my lord. I'll file the application by Monday.
Released.
Much obliged.
Seal number 60 urgent, seal number 61.
Sorry for the interruption. That revenue entries may kindly be directed to restore.
As a consequence of the impediment notice being set aside, the revenue entries shall be restored in the name of the petitioners.
Much.
Seal number 61.
I appeal for the petitioner, my lords. My lords, there is a direction to the AGA in respect of an order of this honorable court dated 12th July 2024. My lords, on the last date, they had sought time to seek instructions on letting us know of the legal heirs of respondent number 3, my lords. The petitioner had earlier taken steps to find out the legal heirs, but was unfortunately not able to find such details. So we had issued a letter, my lords.
How will the Tahsildar know?
My lords,
how will the Tahsildar know who are the heirs?
My lords, we had just sought some assistance because, my lords, despite taking steps from our end, my lords, it was.
Who was R3?
My lords, R3 was one Srimati Muniamma, my lords.
He is the daughter of Chikmunaswamy. Who appears for the other respondents?
In Narayanappa M.
They should know.
My lords, we can also take.
Siblings. Narayanappa. He made an application directing Narayanappa's clients to furnish the details. How will the Tahsildar know? Ma'am, in the synopsis, they say in the year 85,
Please,
the
my lord.
Assistant Commissioner passed an order rejecting the claim for resumption.
Yes, my lord.
Then how can a second proceeding lie?
That's the second appeal, yes, my lord. That retrospective.
Where is this order 1985?
1981, my lord. First application was 1981, my lord.
No, the order is 1985 according to synopsis. Where is that order?
My lords, I don't have instructions to make submissions on the merits, my lords.
Testify ಆಗುತ್ತೆ, then
If you had made submissions, probably you would have succeeded now.
My lords, we'll have to seek instructions.
We'll list.
15th.
Grateful.
62 adjourned, seal number 63, Shri Vishwanath Shetty.
Week's stay may be granted, my lord. Our interim order may be extended, earlier granted, my lord.
Appear for the respondent number 3 in connected matter.
ಯಾವುದು?
63.1 mil. 17433 of 15. There are two matters.
Adjournment.
House, 1 week, 1 week's. Like a senior and
The list.
interim order may be extended.
This
Seal number 64, Shri Gopal. Shri H.N. Basuraj for respondent. Seal number 64.
Lord, I am for the respond number 3 to 4 minutes kindly.
ಏನ್ ಬಸವರಾಜ್?
Next week ಮಾಡ್ತೀವಿ. ಬಂದಿರ್ಲಿಲ್ಲ.
Seal number 65, Shri Kempegowda.
I am for respondent number 4, Grantee, my lord. Last 2-3 occasion in the ಬರ್ತಲ್ಲ regular.
95 sale.
80 grant, 95 sale. 95 ನಲ್ಲೇ ಖಾತಾ ಕೊಟ್ಟಾಗಲೇ ಸುಮೋಟೋ ಇನಿಶಿಯೇಟ್ ಮಾಡಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿ ಕಳಿಸ್ತಾರೆ ಸ್ವಾಮಿ. ಅದ್ರ ಮೇಲೆ ತಹಶೀಲ್ದಾರ್ ರಿಪೋರ್ಟ್ ಹಾಕಿ PTCL ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ.
DNP ಮಾಡ್ತೀನಿ ನೋಡೋಣ. DNP ಮಾಡ್ತೀನಿ, ಬರ್ಲಿಲ್ವಲ್ಲ ಅವ್ರು.
ಆಯ್ತು.
There's no appearance today also. On behalf of the petitioner, left with no order, petition is dismissed on prosecution.
Seal number 66, Shri G. Balakrishna Shastri.
Merits, madam.
Yes, my lord. My lord, it's the original grant of the year 1961, my lord.
You are the purchaser or the grantee?
Grantee, my lord.
Grantee.
Yes, my lord. It was first alienated in 1963 and
What is the date of the grant?
1961, 31/11/1961.
31/11.
Yes, my lord. 61.
Alienation?
First alienation was in 1970, my lord.
1970.
Yes, ma'am. Land was restored in 28/2/1972
Restored.
by an order.
Application, my lord, 2012.
2000.
For restoration application filed before the Assistant Commissioner, 2012 and 13, my lord.
1970 is the sale.
Please, ma'am.
Yes, my lord.
1970.
First sale.
First sale, ma'am.
After 9 years.
Yes, ma'am.
What did the Assistant Commissioner do?
He resumed the lands, my lord. ಮೂಲ ಮಂಜೂರುದಾರರಿಗೆ ಖಾತಾ ಮಾಡ್ಲಿಕ್ಕೆ, my lord. Resume lands to the legal heirs of the grantees. my lord.
Then what did the Deputy Commissioner?
Deputy Commissioner, my lord.
After the first sale, my lord, they has restored the land in original grantee. He has knowingly, again he has sold that land in second time,
To whom?
original grantee.
To whom did he sell?
The fifth respondent, my lord.
ನಿಮ್ಗೆ?
ಹೌದು.
ಯಾವಾಗ?
In 1985.
Deputy Commissioner says, my lord, frequent transactions and Supreme Court judgment, my lord, because delay and he allows the applicant. Now grant is before this honorable court. my lord.
After the
Okay,
second,
I have one doubt. Suppose the Assistant Commissioner resumes the land
Yes, ma'am.
and gives it back to them.
Yes, ma'am.
fifth respondent is
What are
challenged.
the terms of the grant now that can be contravened?
Swami, after the second selling,
Suppose there was no resumption
Yes, ma'am.
and the land was granted land from the beginning. Then there's an alienation made after 79, permission photo is required. Suppose you resume the land and give it back to the grantee.
Yes, ma'am.
What is the status of that land? Does it carry any other terms as before? Or does
No,
it
ma'am.
continue to be a granted land forever?
No, my lord.
Will granted land forever, my lord. Once it is resumed to the legal heirs, my lord, it is continued to be granted land, my lord. Please, my lord. Assistant Commissioner resumes to the legal heirs of the grantee, my lord. and-
When the act was enacted in 79,
Yes, my lord.
the only intention was to ensure all the elections made in contravention should go back to the original grantees.
Correct. Yes,
And
I-
if there's any sale made in violation of terms of the grant after that,
Yes,
you will resume.
please.
Now, after you resume and give it back to the grantee, then will it still be a granted land?
No, my lord.
Yes, my lord. It is a granted land, my lord. Please, my lord.
How
It is
many
in
times
violation of
is it
section
granted?
4(1). my
Then
lord.
what are the terms there? Suppose it is resumed, let us say, in 82,
Yes,
and the grant was, let us say, in the year 60.
yes.
Once the land stands resumed, then what is the status of the land again? Does it continue to be a granted land requiring one more permission under 4(2)?
Yes, my lord. It is required, my lord. They can enjoy the property, my lord. Yes, my lord. Permanent, my lord. Permanent non-alienation. Whenever, my lord, after the act, if they want to alienate the property, they need to obtain the permission from the government.
My lord, when Sagwali cheat was issued, it is 15 years non-alienation clause, my lord.
No,
Well, my lord, here in
second, you have sold it for the second time.
second time. After the second time selling, the land is taken to the government, my lord. Then the fifth respondent only challenged this order. The grantee is not challenged the order. The land is taken to the government in 2002. In second,
Later,
ಎರಡನೇ ಸಾರಿ PTCL ಕೇಸ್ CR ನಂಬರ್ 4/2001-2/4ದಾಗ ಸರ್ಕಾರಕ್ಕೆ ವಾಪಸ್ ತಗಂತಾರ ಸ್ವಾಮಿ ಭೂಮಿನ. ಅವಾಗ ಫಿಫ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾತ್ರ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾನೆ. ಈ ಗ್ರಾಂಟಿ ಚಾಲೆಂಜ್ ಕೂಡ ಮಾಡಲ್ಲ ಅದನ್ನ. ಅವಾಗ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಅವರು ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮೇಲೆ ವಜಾ ಮಾಡ್ತಾರೆ. ಆಗ ಈ ಫಿಫ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ WP ಬರ್ತಾನೆ ಇಲ್ಲಿ. WP ನಲ್ಲಿ ರೆಸ್ಟೋರ್ ಮಾಡಿ ರಿಮೈಂಡ್ ಮಾಡ್ತಾರೆ ಕೇಸ್ನ. ರಿಮೈಂಡ್ ಮಾಡಿದಾಗ ಮತ್ತೆ ಅಗೈನ್ ಅವನಿಗೆ ರೆಸ್ಟೋರ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ಮತ್ತೆ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರು ವಜಾ ಮಾಡಿದ್ದಾರೆ. ಮತ್ತೊಂದ್ಸಾರಿ ಆತನಿಗೆ ಗ್ರಾಂಟ್ ಮಾಡಕ್ ಬರಲ್ಲ, ಆಲ್ರೆಡಿ ಸೆಕೆಂಡ್ ಟೈಮ್ ಫಿಫ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಫೇವರ್ ಆಗಿ ಆರ್ಡರ್ ಬರ್ತಿದ್ದಾರೆ.
The conduct, my lord, legal is the grantee's conduct, my lord. Deputy Commissioner says, my lord, it is inordinate delay and frequently they keep selling the landed lands and everything is given with time. In 82, it was restored and all the revenue records, my lord, stands in the name of the legal heirs of the grantee, my lord. If legal heirs of the grantee's name stands, my lord, they have to take the permission, my lord. If it is in a subsequent purchaser's name, they need not to take permission.
Land restore. See.
2001 ಮೇಡಮ್ PTCL CR 4/2001-2 ಸರ್ಕಾರಕ್ಕೆ ರೆಸ್ಟೋರ್ ಮಾಡ್ಕೊಳ್ತಾರೆ ಲ್ಯಾಂಡ್ ನ. ಸೆಕೆಂಡ್ ಟೈಮ್ ಸೇಲ್ ಆಗಿದೆ ಅಂತ ಸರ್ಕಾರಕ್ಕೆ ರೆಸ್ಟೋರ್ ಮಾಡ್ಕೊಳ್ಳೋದನ್ನ ಫಿಫ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡೋದು. ಗ್ರಾಂಟಿ ಚಾಲೆಂಜ್ ಕೂಡ ಮಾಡಲ್ಲ ಅದನ್ನ.
Madam, section 6 ಗೆ ಬನ್ನಿ ಒಂದು ನಿಮಿಷ.
Yes. Prohibition of registration, transfer of granted lands, my lord. Notwithstanding anything in the registration act 1908 and after the commencement of this act, no registering officer shall accept for registering the complete of the transfer of or to this creation of any interest in any granted land included in the list of granted lands furnished to the registering officer except where such transfer is and in accordance with this act or in terms of the grant of such land or the law providing as such grant.
So there is no bar if the transfer is in terms of the grant of such land. So if that period, assuming it was a granted land, and the period is over, then there is no bar for them to sell.
No, my lord, even after my lord, section 4.
This is not a fresh grant. The moment the land is resumed,
Yes,
Resumed.
it goes to the grantee
legal heirs of the grant.
and they are bound by the original terms of the grant. The original terms of the grant was from 61, let us say 20 years.
Yes,
So after 81, they can sell. Section 6 permits of registration of a document if it is in accordance with the terms of the grant.
my lord, terms of the grant, we have to calculate from the fresh grant, my lord,
No,
re-grant.
no, how can it be a fresh grant?
Yes. Once
How?
it is resumed to the legal heirs of the grant, my lord.
It is resumed because there was a contradiction of terms of the grant. Now, if the term of the grant permits the sale,
Yes,
Then
sale
why-
permits only prior to act, my lord. If at all, my lord, 1979 sales.
section
taken
6 talks about only of transfer after the commencement of the act.
place, my lord, after the commencement of the act.
So after the commencement of the act, what is barred is, suppose you have given the list of lands which you have granted, you cannot register. Or the second one is, or if it's in accordance with the terms of the grant, you may grant permission under 4(2), that also can register. Or in terms of the grant, or the law relating to the grant. If it permits sale, why should it not be sold?
Terms of the grant, my lord, at the, my lord, legal aids of the grant, again, they have said, my lord, 15 ವರ್ಷಗಳವರೆಗೂ ಮಾರಾಟ ಮಾಡುವಂತಿಲ್ಲ, my lord.
ಯಾರು?
My lord, legal aids transferred, my lord, daily, page 20 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
Yeah, page 20.
Page 20 of the deputy commissioner order, my lord.
Now, how can that be done? You tell me. You are resuming the grant.
Yes,
So if I accept your argument, then even though the period of transfer of, let's say, 20 years or 30 years prior to 79 is over,
yes.
you are
Even-
now,
Even after completion of term.
so therefore, basically you are saying that once a land is granted,
Yes,
after the act came into force,
please,
notwithstanding the fact that the term of 15 years is over,
yes.
forever you have to take permission,
Yes, that is the condition, 4(2), my lord.
then how do you explain section 6? Section 4(2) can be only in respect of the period where the period of non-election is still subsisting. Suppose a grant is, let us say, made in 80. They want to sell it before the expiry, that is, let's say 1990.
Yes,
Then 4(2) is required.
here it is.
Then section 6, what is the meaning of section 6? What is the meaning of this? Or the terms of the grant of such land, or the law providing for such grant.
Documents relating to the transfer of or the creation of any interest in granted land, included in the list of grant lands furnished to the registering officer except where such transfer in accordance with this act. Accordance with this act means, my lord, section 4(2).
4(2), correct.
Yes, sir.
So fundamentally,
Yes,
you will have to give them the list of all the lands
yes,
which they shall not register.
yes,
The exception is except where such transfer is in accordance with this act, 4(2),
yes.
or
Or the
the
terms.
terms of grant of such land, or the law providing for such grant. Suppose the term of the grant only says don't sell it for 15 years. The term is over. Then why can't they sell it? The act does not say that I am extending the period of non-alienation forever.
Yes, my lord. My lord, here section 4(2), my lord, it is very clear. My lord, even after completion of the terms, my lord, conditions.
No, that is not what 4(2) says. 4(2) says no person shall after the commencement of this act transfer or acquire by transfer any granted land without the previous permission of the government. This is in contravention of the terms of the grant. Then you require permission. Suppose the rule only says, don't sell it for 10 years and they intend to sell it after 40 years. Why should they come back to you and again seek for permission? The moment that period is over, the grant becomes an absolute grant. Then where is the question of you granting permission once again?
For the new amendment act, my lord, no, forever they cannot sell.
So Yoshim Madi, because
Correct, my lord, I agree, my lord.
1940, 1950, a grant is made for 20, 30 years. Now that period is over. Do they still have to hold on to the land forever?
Yes, my lord, that is the, my lord, each and every, my lord, now, even 2002, after 1940 grants, my lord, 2002 say a transaction, sales transaction taken place.
I
Now
think that
again
is-
resume, my lord, without prior permission.
Then I think that is wrong because section 6,
Yes. Never. This.
strictly speaking, the bar is only if you have given a list of granted lands. Only those you cannot register. Suppose you have not given him the list, that means you can register.
My
Alva?
lordship, this is the first time, my lord, this, notice,
Examine it, please,
I'll examine.
the list. Because I think once the land is resumed
Please,
and restitution is ordered, I think there must be a change in the character of that land. It's not that you're making a fresh grant, you're only resuming the land and restitution is being made.
that time, my lord. they
So you
will
go
show-
back to the original position where it is a granted land.
my lord, when
But by
res-
that time, if the period of alienation is over,
Yes.
then they should be at liberty to sell without coming to you.
When resuming the land, my lord, again they'll impose some conditions, my lord, further 15 years.
Where, under which rule can they impose?
That is the, many cases, my lord.
Under which rule?
Sometimes, my lord, they'll impose or directly, my lord, they say,
ಇಲ್ಲ, the rule should permit, isn't it?
yes.
ನಿಮ್ಮ against argument ಹೇಳ್ತಿದ್ರು.
Lord, I'll examine, my lord, detailedly, I will submit, my lord. Contravention of the grant shall be liable to cancel resume government deed. Provided before cancellation of the grant, grantees is afforded with an opportunity of being heard, provided purpose there is. Restore the grant from the purpose, they cannot
There is nothing in the act which says after resumption, you can impose any condition.
The object of the, my lord, resume the, my lord, again, legal heirs of the grant to utilize that, my lord. Immediately after resumption, my lord, they keep selling, my lord. That's the reason the 4-2 is here. Got into, my lord, and,
No, if the act was designed
yes, ma'am.
to ensure that the grantees who have sold the land in contravention of terms of the grant only, the very purpose of the act was only that, isn't it? They wanted to give back the land to the persons who are being granted because they sold the lands under duress or due to their poverty.
Right.
That is all. It can't be like as if the land grant rules cannot be indirectly amended by this act to say that there is a rule which permanently bars them from alienation.
Now, new act, my lord, it is permanently, my lord, even after the amendment. There is no time limitation also, my lord.
No, as on the date of the grant, whatever is the period, suppose in the year 2010, when you grant the land, you impose a condition, forever you will not sell.
Yes, that is
Then-
agreeable.
Then 4-2 will come in.
Correct.
But suppose in the year 1990, you granted land and the rule said 15 years.
15 years.
Then after 2015, why can't they sell it? It is not in contravention of the terms of the grant. Your right over that particular land is only till 2015.
15 years.
15.
After that,
After 15, it becomes an absolute grant, isn't it? You can't impose any conditions forever.
I'll examine.
ಗೌರ್ಮೆಂಟಿಗೆ ಸೇರ್ಸ್ಕೊತಾರೆ ಮೇಡಮ್ ಲ್ಯಾಂಡ್ ಅದನ್ನ
ಎಸ್
ಗೌರ್ಮೆಂಟ್ ಸೇರ್ಸ್ಕೊಂಡಾಗ ಫಿಫ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾನೆ ಒಂದು ಗ್ರಾಂಟಿ ಚಾಲೆಂಜ್ ಕೂಡ ಮಾಡಲ್ಲ ಗೌರ್ಮೆಂಟ್ ಸೇರ್ಸ್ಕೊಂಡ್ರೆ
Seal number 14. Which catch?
Last time your lordship heard me. This is a matter where the assistant commissioner, acting upon the Lokayukta direction, my lord, passes the second order, my lord, once the order is resumpted. My learned friend said he wants to go through that. AC passed the first order, my lord, resuming the land in favor of the grantee. That order has not questioned by the aggrieved party, my lord. That order attained finality in the year 2007 itself. 2015, my lord, one third party files a complaint before the Lokayukta, stating that, my lord, some fake documents are produced until some third party approaches the Lokayukta office. Lokayukta did not conduct an inquiry. Lokayukta writes a letter to the assistant commissioner, look into the matter and take action against the erring officials. Acting upon that direction, my lord, the assistant commissioner once again opens the file, my lord, and when he passes the order, my lord, by setting aside the old sale deeds of the 1962 and 74, my lord. Sanction is obtained after resumption of the land, my lord. The grantee obtains the sanction order from the government. So your lordship, they said that once the sanction is obtained from the government, what is the can a prejudice be caused to the subsequent purchaser? He cannot annul and invalidate the sale deed after lapse of 40 years. Covered by the judgments also.
It is a AC order being challenged alva.
The AC earlier order 2007 order ಅದು challenge ಮಾಡಿದ್ರು.
DC
He is saying that
Yes,
the assistant commissioner rejected the application resumption first.
yes, ma'am.
That has become final.
Yes, ma'am.
How can a second proceeding be initiated for resumption?
Second,
ಅದೇ ಅಲ್ವಾ argument? ಹೌದು, ಆ order is without jurisdiction and is a null, it cannot be
the
invalid.
second application never, ಇಲ್ಲಿ produce ಮಾಡಿಲ್ಲ ಅಲ್ಲ sir, second.
They are at liberty to challenge the earlier order, 2007. They did not do so. They take the backdoor method, my lord, by instigating some third party to approach the office of the Lokayukta. One Manjunath and Theodore file ಮಾಡ್ತಾರೆ. I have produced the document. At the instance of Manjunath, my lord, the AC, my lord, acting upon the Lokayukta letter, my lord, the AC opens the gate. And AC also brings to the notice of the deputy commissioner. I have already passed an order. I cannot assume jurisdiction to pass subsequent. ಅದನ್ನು ಹೇಳ್ತಾರೆ, AC letter ಬರೀತಾರೆ DC ಗೆ. Kindly look at that letter, my lord. ನಾನು ಈ ತರ ಆರ್ಡರ್ ಮಾಡಿ ಆಗಿದೆ, ನನ್ಗೆ ಇನ್ನೊಂದ್ಸಲ ಮಾಡಕ್ ಬರುದಿಲ್ಲ.
ಹೌದು, ಅದನ್ನ ಹೇಳಿದ್ದಾರೆ.
Your lordship, kindly say annexure J. He brings to the notice of the deputy commissioner. Madam, he says in the synopsis that there's a permission granted on 14/7/2011.
That has been cancelled ಅಂತ ಹೇಳ್ತಾರೆ. Permission is,
ಹೆಂಗೆ?
sale permission is cancelled ಅಂತ.
ಯಾವಾಗ? After cancelling, after obtaining the sanction only, it is done, my lord. Annexure J is the order. Where is the cancellation? No, it is a stress.
I apply for the response. Kindly have it on Monday, madam. Today I am not feeling well.
Monday.
Sale permission cancel ಆಗಿದೆ.
Just have it on Wednesday.
Yes, ma'am.
ತಂದಿದ್ದೀರಾ? ನಮಗೆ ಕೊಟ್ಟಿಲ್ಲ. ಯಾವಾಗ ಕೊಟ್ರಿ? ಅದನ್ನು ಒಂದು ಕಾಪಿ ಕೊಡಿ ಮೇಡಮ್.
As per the direction of the parties visited to the office. Party is also present.
ಏನಾಯ್ತು?
ಅಲ್ಲ ಅವ್ರು ಕರೆಸ್ಲಿ ಸ್ವಾಮಿ, ಬಿಕಾಸ್ ಐ ಹ್ಯಾವ್ ಇನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ದೆಮ್, ಐ ಸೆಂಟ್ ಎ ಮೇಲ್ ಆಲ್ಸೋ. ಆದ್ರೂ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಸಾರಿ, ಐ ಹ್ಯಾವ್ ಟು ಕಟ್ ಎ ಸಾರಿ ಫಿಗರ್ ಬಿಫೋರ್ ಮೈ ಲಾರ್ಡ್.
ಅವ್ರ ಮಗಳದ್ ಮದುವೆ ಇದೆ ಸ್ವಾಮಿ, ಮೊನ್ನೆ ಹೋಗಿದ್ದಾರೆ.
ಏನಾಯ್ತು ಹೇಳಿ ಫಸ್ಟ್.
ಏನೂ ಮಾಡ್ಲಿಲ್ಲ, ಮಾಡ್ತೀವಿ ನಾವು ಕಮಿಟಿಗೆ ಇರ್ತೀವಿ ಹೋಗಮ್ಮ ಅಂತ ಕಳಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ.
On 25/10/2024. This court passed a specific order directing the BDA to allot any of the three sites mentioned in the order. This court passed a said order in the background of the fact that on 18/7/2024, the court had directed the BDA to state the availability of site numbers 3085 and 2789 and for allotment, and this was because the BDA had utilized 5 guntas of the petitioner land without following the due process of law. The question of allotting sites to the petitioners came about because the BDA had unauthorizedly used the land belonging to the petitioner. Despite granting time from July 2024, and despite a specific order passed in this regard, no action has been taken by the concerned. ಯಾರು ಬರಕ್ಕೆ ಹೇಳಿ?
ಇವ್ರು ಗೊತ್ತಿಲ್ಲ.
DS2 entries on site number.
ನಮ್ಗೆ ಏನು ಗೊತ್ತಾಗಲ್ಲ, ಅವ್ರಿಗೆ ಬೆಟರ್ ಗೊತ್ತಾಗಲ್ಲ.
ಯಾರು which
Commissioner, let him come before the court.
Commissioner will, that's the officer, Deputy Secretary 3.
He is the supreme of the authorities, let him come before the
Who do
court.
you want me to call?
Deputy Secretary 3 will be fine, my lord, because it will actually settle the matter. Unnecessary precipitate agad beda.
If you want me to call Commissioner, I'll call. If they are interested in coming to the court unnecessarily, why should I stop them?
Probably the lower rank officials idirbodu, so I don't think the Deputy Secretary 3 is a person who will come.
The Deputy Secretary 3, na?
3 and 2.
Who is in charge of the matter?
3 and
Should be
2,
personally present before this court.
3 and 2, ibru idive. One is allotment and acquisition, ibru.
Deputy Secretary 2 and 3.
2 and Deputy Secretary 3.
Regarding the measuring 20th to 30 is concerned, Deputy Secretary 2. 30-40 is concerned, Deputy Secretary 3. Adal ಎರಡು ಇದೆ.
To state as to why the orders passed on 18/7/2024 and 25/10/2024 are not complied with. Relist on
15th.
Much.
45.
Forty-five.
Your lordship's leave, I will appear for
PB Raja.
claim was filed under Employees Compensation Act. The reason is the driver who was driving the car at the time of accident was charge sheeted for his own negligence, his death. So the parents filed the claim under EC Act because they could not have filed a claim under ME Act for the deceased the negligence. So the EC Act case was filed. The owner as well as the insurance company resisted the claim. The contention of the owner is also that he is not an employee. The insurance company also shares with the same. To succeed a claim, an employee relationship is a must. So since the owner gave an evidence in the trial court, examined as RW1, RW1. Sorry, RW2. Sorry, I stand corrected. She was examined as RW2. She stated that I have not employed the deceased. She was cross-examined by the insurance company and also by the deceased claimant. In the examination chief, in paragraph 4, she has stated like this, madam. I respectfully submit, from the evidence of the owner, I am trying to make out a case that the deceased was an employee of probably the borrower. If it is a borrowed case, then also we are covered. That I will demonstrate.
You set up the specific case that you're an employee.
Yes.
If you don't prove an employee, you are out of the EC Act.
Yes. That is why I am trying to say that the vehicle was borrowed is from the evidence of the owner. Paragraph 4, she says, I respectfully submit that I have not engaged the deceased Vinay Kumar as a paid driver. I was not
pay any amount or salary to the deceased as one of the and one of the known friend of my son, one Arun Ganesh, as on the date of accident, alleges in my absence, deceased and that Ganesh took ಅಂತೇಳಿ ಅವರು evidence ನಲ್ಲಿ ಹೇಳ್ತಾಳೆ. If Ganesh took the vehicle that is borrowed, then probably he becomes ostensible owner. That ostensible owner.
Principal owner ಹೆಂಗಾಗ್ತಾನ?
ಅಲ್ಲ ನಾನು liability ಬಗ್ಗೆ ಆಮೇಲೆ ಬರ್ತೇನೆ. He had the right to engage a driver. See, it appears he took the assistance of the deceased as a driver.
Did you make that person as a party?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
Then
ಅಲ್ಲ ಎಂಪ್ಲಾಯರ್ ರಿಲೇಶನ್ಶಿಪ್ ನಮಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ. ಬಟ್ ಎವಿಡೆನ್ಸ್ ಶೋಸ್ ದಟ್
MBC ಹಾಕೊಳ್ಳೋದು ಒಂದು ಚಾನ್ಸ್ ಬೆಟರ್ ಅಂತ ಕಾಣಿಸುತ್ತೆ.
MBC ಚಾರ್ಜ್ ಶೀಟ್ ಇವ್ರ ಮೇಲೆ ಇದೆ.
ಏನಂತ?
ಇವ್ರ ಮೇಲೆ ಇದ್ರೆ
you can establish that he was not negligent. Charge sheet is not final.
ಮರದ ಮೇಲೆ ರೋಡ್ ಮೇಲೆ ಬಿದ್ದೋಗಿದ್ದಲ್ಲ ಇದು ಅಲ್ಲ
ಅಕ್ವಿಟಲ್ ಆಗಿದ್ರೆ ಅವಾಗ ಕೇಸ್ ಹಾಕ್ಬೋದಲ್ಲ.
ನಾನು ಒಂಚೂರು ಚಾರ್ಜ್ ಶೀಟ್ ಮಟೀರಿಯಲ್ ಎವಿಡೆನ್ಸ್ ನೋಡ್ಕೊಂಡು ಮಂಡೇ ಹೇಳ್ಬೇಕು.
ನೀವ್ ಏನ್ ಮಾಡಿದ್ರು
ಅಲ್ಲ ಚಾನ್ಸ್ ಇದ್ರೆ ನಾನು ಹೇಳ್ತೇನೆ. If he is able to succeed, I'm sure your lordship will grant permission now.
Since the employer says that I have never employed you and she has come before the court given evidence, it is fundamentally a finding of fact. I cannot change the finding of fact in an appeal under section 30.
But the finding whether he was an employee or employee.
You want, I'll permit you to withdraw the appeal in the light of the defense taken by the employer.
Monday.
Let them go and try their luck in the
Mangalwara.
46.
Lingraj ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ.
Today I don't think he'll come today and tomorrow.
ಮಹೇಶ್ ಅವರು ಇಲ್ವಾ? ಲಿಸ್ಟ್ ಬರ್ಲಿ ಅವರು.
ಮಂಡೇ ಅಥವಾ ಟ್ಯೂಸ್ಡೇ? ಟ್ಯೂಸ್ಡೇ.
ಧಾರವಾಡ ಕಲಬುರಗಿ ಅದೊಂದು ಧಾರವಾಡ ಕಲಬುರಗಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ನನ್ನ ಅಭ್ಯರ್ಥಿ ಮಾಡಿ ಕೇಳಿ.
Sir, audio on ಮಾಡಿ ನೀವು. Start sir.
ಬೇಡ ಬೇಡ ಬಂತು ಅದು ಅತನ ಇಲ್ಲೇ ಕರ್ಕೊಂಡ್ಬರೋ
ಇದೆ ನೀವು ಜಸ್ಟ್ ಜಸ್ಟ್ ಕ್ಲಿಪ್ ಫುಲ್
ಆಡಿಯೋ ಆನ್ ಆಡಿಯೋ ಆನ್ ಮಾಡ್ತೀವಿ ಫ್ಯಾನ್ ಐತಾ
ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೇಳಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್. ಹಲೋ ರೀ.
ಹೇಳಿ ಹೇಳಿ.
ಹಾ ಅದೇ ನೀವ ಅದಿರಾ? ನೀವ ಇದ್ರ ಆಯ್ತು ಬಿಡ್ರಿ, ನಮ್ಮ ಹೆಸರು ನೋಟಿರ್ತದೆ. ಆಯ್ತಾಯ್ತು, ಓಕೆ ತಗೋರಿ.
ನಾನು ಅವ್ರು ಕಂಪ್ಲೀಟ್ ಮಾಡ್ತೀನಿ ಅದನ್ನ ಅಲ್ಲಿ
Court officer.
ಸರ್ ನಿಮ್ ಮ್ಯಾಟರ್ ಅಜ್ಜನ್ ಆಯ್ತು ಸರ್.
46.
ಅಜ್ಜನ್ ಆಯ್ತು.
ಹೌದಾ?
ಸರಿ, 12ಗೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಒಂದ್ರಲ್ಲಿ ಇದೆ. ಸರ್ ಅವ್ನು ಎತ್ಕೊಡು ಅಷ್ಟು ನಿಮ್ಗೆ ಇಷ್ಟೇನು ನಾನು ಕೇಳದೆ ಎಲ್ಲ ಕೇಳದಲ್ಲ. ಎಸ್ ನೆಕ್ಸ್ಟ್ ಅಂತಾರ ಅವ್ರು. ಫೋಟೋ ಕಾಣ್ತಾರೆ. ನಮ್ ಕೇಳಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀನಿ ಸರ್. ಸೈಡ್ ಫೋಟೋ ಸಾಯ್ತೆ ಏನಾದ್ರೆ ಅದು ಇದು ಕನೆಕ್ಟ್ ಆಗೋಕೆ ಇದಾದ್ಮೇಲೆ ಏನೋ ಮಾಡಕ್ ಅಂತ ಅದು ಏನಾಗ್ತದೆ ಮತ್ತೆ ಏನಾದ್ರೂ ಕೇಳ್ತಾರೆ. ಅದಕ್ಕೆ ರಚನೆ ಆಗೈತೆ ಅಂತ ಸರ್ಕಾರ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಸರ್ಕಾರದ ಮತ್ತೆ ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ಕೇಳಾರ ಮೊನ್ನೆ ಕೊಡ್ರಿ ಕೊಟ್ಟಿದ್ವಿ. ಈಗ PTCL ಜಾಯಿಂಟ್ ಇದು ಮಾಡಂತ ಹೇಳಿ ಮಾಡಕತ್ತೀವಿ ಅಂತ ಕೊಟ್ಟಿದ್ವಿ. ಅದ ಸರ್ಕಾರ ಕೊಟ್ಟಿದ್ದು ಅದು ಫಸ್ಟ್ ಲೆಟರ್. ಅದು ಮತ್ತೆ ಮೊನ್ನೆ ಸೆಪ್ಟೆಂಬರ್ನ ಕಳ್ಸ್ಯಾರ. ಈಗ ಅದಕ್ಕೆ ನಾವು ಅವ್ರಿಗೆ ಲ್ಯಾಂಡ್ ಕಳ್ಸೋರಿಗೆ ಕೊಟ್ಟಿದ್ವಿ ಮಾಡಿಕೊಡ್ರಿ ಅಂತ ಜಾಯಿಂಟ್ ಸರ್ವೆ ಅದು ಹೋಗಿ ಏನಾಯ್ತು ಫಸ್ಟ್ ಈ ಮಾಡ್ತಾ ಇಲ್ಲ ಜೂನ್ ಕೊಟ್ಟಿದ್ವಿ. ಈ ಮಂತ್ ಜೂನ್ ಕೊಟ್ರ ಈ ಮಂತ್ ಸೆಪ್ಟೆಂಬರ್ನಾಗ ಬೇಕಂತ ಕೇಳಿದ್ವಿ. ಅದು 50-50 ಇತ್ತಲ್ಲ, 50-50 ಹೋಯ್ತು. ಅದಕ್ಕೆ ಈಗ ಮತ್ತೆ ಫುಲ್ ಅಕ್ವಿಸಿಷನ್ಗೆ ನೀವು ಅಲ್ಲ ವರ್ಕೊಂಡ್ ಮಾಡೋಲ್ರಿ. ಈ 4 ತಿಂಗಳು ಇಟ್ಕೊಂಡು ಈಗ ಬರೋದಲ್ಲ ಈಗಾದ್ರೆ ಇರೋದು ಸ್ಟಾಫ್ ಇಬ್ಬರದ್ರಲ್ಲಿ ಕಮಿಷನರ್ ಅವನು ಎಲ್ಲಿಯರ್ ಕಮಿಷನರ್ ಟ್ರ್ಯಾಪ್ ಆಗಿ ಹಾಕೋದ. ಈಗ ಎಲ್ಲಿ ಬರೋಲ್ಲ ಇನ್ಚಾರ್ಜ್ ಕಮಿಷನರ್ ಮಾಡ್ತಾರೆ. ಮುಗಿಸ್ಬೇಕಲ್ಲ ಇದೆ
Serial number 65 minute. Serial number 65 minute. The matter was dismissed for non-prosecution minute. The arguing counsel is no more minute. This arguing counsel relative is no more minute. He went to native place minute. Serial number 65 minute. CM Kempegowda.
ಹೋದ್ಸಲನು ಬರ್ಲಿಲ್ಲ, ಅದ್ರ ಹೋದ್ಸಲನು ಬರ್ಲಿಲ್ಲ.
I intimate, my lord, the arguing counsel relative is no more, but he went to native place. That is, my lord, one, any next week, my lord,
15th.
please, I intimate. Great.
Bangalore bench matter, passed over matter, serial number 16.
Not execute the records, my lord, but then it is permission, my lord, you have given the permission, there is no doubt in it. And the petitioner contention is, my lord, 20th order is seeking, my lord, that is from DC office, I should get it, my lord. After the permission from the principal secretary, my lord, deputy commissioner issues him an order, my lord. That
Yes.
permission is, it is genuine, my lord. We have given the permission.
Lord, they are not producing that document before the court. Lord, my grievance. ಇಲ್ಲ ತೋರ್ಸು.
ಅಲ್ಲ ಅವ್ರು ನೀವು DC ಅವ್ರು ಕೊಡೋದು ಅಂತ ಹೇಳ್ತಾರೆ, my lord. Once principal secretary is given.
ಗವರ್ಮೆಂಟ್ ಇದೆ ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ ತಾನೆ.
ಹೌದು.
Principal not a prior permission he has granted. But subsequently not a DC has to issue not the.
Definitely, my lord.
Yes, ma'am. That is the
procedure we follow, my lord.
Under the rules of business, government means the principal secretary or the minister concerned.
Not he has.
If there is an order, that is the end of the matter.
Not there is an order for the not prior not the permission. Not for not the sale permission. Sale permission has to be issued by the DC only. Here,
Show me the rules which says.
may I take note of annexure A, my lord, kindly.
Show me the rules.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕೆ ರೆಡಿ ಇಲ್ಲ ಅವರು. Even we have applied also, my lord, they are not.
Deputy commissioner subordinate to the principal secretary.
Yes, my lord.
The principal secretary has passed an order, whether the DC passes an order or not.
Since sale permission is challenged by this petitioner, not of the office has raised the objection that not we have to produce that document. Since not we have applied before the not DC as well as principal secretary, not they have failed to not the.
What are the facts of your case?
Facts is this, not the.
You are the grantee.
I am the grantee, not my family is the not granted the not the 2 acres of land. Not 2 acres of land, not situated at.
Was the land granted?
1961, not 7/7/1961 to 1 D Kamala Mama.
7/7/61.
Yes, ma'am. Not after her death, not.
What was the alienation period?
Alienation 15 years, ma'am.
That was over in 1976.
Yes, ma'am.
When was the sale permission sought for?
Not 2012, ma'am. 2010 itself, not her husband D Ganga Narsaya died. That could be seen from.
Who's the grantee?
Grantee is the Lord Kamlama, Lord who died subsequently.
Kamlama.
Lord who died on 10/11/1998. 10/11/1998.
Yes.
Thereafter, Lord, the records were not entered into her husband's name, D Ganga Narsaya. D Ganga Narsaya.
Yes.
Lord, all the revenue records were standing in his name. On 33/2010, Lord, he died. Ganga Narsaya died. 33/2010.
33?
33/2010. Yes, 2010.
Yes.
Sale permission was granted on principal secretary by the principal secretary on.
Whose request? On whose request?
In the death person's name. Ganga Narsaya.
He had made the application or the LRs made the application?
Lord, some power of attorney holder had made the application, not my Ganga Narsaya.
Ganga Narsaya only sought for permission.
Yes, Lord. He was not alive at that time. That is why I had produced the death certificate, his death certificate. Lord, 2010, Lord, he died.
Madam, where is the request?
Application, I should get that. Kindly, my lord, if I want to produce application, my lord, the sale permission on 21st, my lord, DC is available. All taluk office, I need to check that document, my lord. Once it is done, 2012 document, my lord. They have to raise the document.
Where did you raise the contention that you have not sought for permission?
Lord,
For which authority did you raise a contention?
Lord, this petitioner only came to know on Lord in the.
Who are you?
I am the Lord, the son of D Ganga Narsaya. He filed a lot of restoration application before the lot of the
Should
assistant.
have you said that in
My lord,
the-
no, sorry, come. I had my lord filed an application, restoration application before the my lord of the assistant commissioner, wherein that my lord he came to know that my lord of the this land has been ordered for sale permission also.
let us see your application.
My lord, may I request my lord page number,
Annexure L.
page number, my lord, Annexure M, page number 72, my lord.
Page number?
Annexure M, page number 72, 72, my lord. He filed my lord of the restoration of the land.
72 is the order sheet of the.
Yes, order sheet of the my lord of the assistant commissioner.
Where's your application for resumption?
Resumption, my lord.
Where's your application that you filed for resumption?
He
In
files
that-
an
What do you say in that?
In that only my lord the AC has passed the order.
He files an appeal, notes. He files an appeal before the assistant commissioner, notes.
For
Annexure
resumption.
L. And the order sheet is pertaining to this lot's appeal.
My application is not the Annexure L. M ಅಲ್ಲಿ ಮಾಡೋದು page number 74 ಅಲ್ಲಿ ಮಾಡೋದು last paragraph ಮಾಡೋದು they observe. Since ಮಾಡೋದು the DC has granted the ಮಾಡೋದು the sale permission, I have to approach the ಮಾಡೋದು this honorable to challenge that sale permission.
Please read para 8, page 67.
67. It is submitted that Gangan Rasai had applied for the sale permission and the said application is abated after the death of.
You admit Gangan said applied for the sale permission.
Lords, yes, Lords.
You have applied.
Yes, Lords.
The government won't know whether Gangan is alive or dead.
Yes, Lords.
They act upon this application and grant permission.
Correct, Lords.
Then
But
where is the
Lords,
question?
while
Abate it.
granting the Lords the sale permission also, Lords, they have to verify that Lords whether that person is alive. Lords, the sale permission is Lords.
Is a different ground. If Gangan had applied for permission, that means he intended to sell. He wanted the permission of the government. If the government has granted permission, even after his death, for the purpose of the PTCL Act, there is no violation. Because Ganga's intention was to sell after permission. If permission is granted, there ends the matter.
He might be.
You can't come and say, no, my father could not have applied or my father's application should abate it. You are bound by the request made by your father.
Yes.
Then the violation is valid.
The fact is this, Lords. He Lord died in the year 2010. Lord, the sale permission was granted in the year 2012. Lords, based on that sale permission, Lord, this respondent number 5.
If you have not executed a GPA,
yes,
it's open for you to go to the civil court and do whatever you want. But for the purpose of the PTCL Act, you can't say that there is a sale in contravention of section 4.2. If it's your case that the father died, the GPA did not entitle them to sell or that you had not executed the GPA.
Yes.
That's a different argument. That is before the civil court, not before the AC or DC. AC and DC will only say whether permission was there for sale or not. The permission is there, matter ends.
But even lot of the sale permission should be given in the name of the dead person also.
That is of no consequence. Government is the owner of the land. This is to grant permission to the person who had made the application. If he had died in the meantime, our permission won't get abated. It is not like a decree passing as a dead person. It's a decree in favor of the dead person. And it endures to his benefit. If all of you have rightly or wrongly executed the sale deed, you suffer the consequence. or if you say that no sale deed was executed, go to the civil court.
But on this ground, my lords,
You should
because-
not enlarge the scope of this PTCL as it is. AC DC ಏನೋ ಮಾಡ್ತಾರೆ ನೀವು ಇದ್ರಲ್ಲಿ ಈ ತರ ಕೊಟ್ಟರೆ ಅವ್ರಿಗೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಇಂದ ಜಾಸ್ತಿ ಪವರ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ನೀವು ಅವ್ರು.
my lords, my lords, I request my lords one day. My lords, meantime, my lords, I will also my lords verify this on this aspect, because my lords, my instruction was that my lords, the GPA holder had applied the my lords, the sale permission, and my lords, the
This is your appeal application.
yes, my lords. One
I can't
opportunity,
go beyond this.
yes, my lords, one opportunity may be given, my lords, meantime, my lords.
Adabidi close ಮಾಡ್ತಿದ್ರೆ
ಅಲ್ಲ.
ಇನ್ನೇನು opportunity. How can you can't change this, I can't change this. This is on record.
Next 18 months.
Petitioner himself not executes the GPA notes, annexure R2, along with his brother's plots.
That he is denying it, let him go to the civil courts. I'm only concerned with PTCL proceedings. I don't think ಸುಮ್ಮನೆ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಅಲ್ಲಿ ಹೋಗಿ ನೀವು ಗ್ರಾಂಟ್ ಲಿಬರ್ಟಿ ಗೋ ಫೈಲ್ ಸಿವಿಲ್ ಸೂಟ್ ನೀವು ಹೆಂಗಿದ್ರು ಕಲೆಕ್ಷನ್ ತಾನೇ ಅದು
Restoration.
ಕಾಸು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ತಾನೆ
ಅಷ್ಟೇ.
ಕೊಡಂಗಿರಿ ಈಗಲೇ ಕೊಡಂಗಿರಿ ಈಸ್ಕೊಂಡು ಮುಗಿಸ್ಕೊಡಿ, ಇಲ್ಲ ಇನ್ನೊಂದು 10 ವರ್ಷ ವ್ಯಾಜ್ಯ ಮಾಡಿ.
My lords, I will sit with him, my lords,
ಏನ್ ಮಾಡ್ತಾರ ಮಂಡೇ ಅಷ್ಟೊತ್ತು ಮಾಡಿ.
Monday ನಾನು ಇರಲ್ಲ. ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದು
ನಾನು ಎಲ್ಲ ಮರ್ತ್ಬಿಡ್ತೀನಿ ತಿರ್ಗಾ.
ಇಲ್ಲ ಇದು my lords,
ಮಂಡೇ
my lords, at least Tuesday or Wednesday.
ಟ್ಯೂಸ್ಡೇ.
Forward bench matters. Serial number 1, Shri SL Matti. Forward bench matters.
ಏನಾಯ್ತು ಅಂತ
Lords, I have requested the commissioner to be present online. Is a new person who has come, my lords, I am not sure.
Here, my lord, after my lord submission of the my lord permission for acquisition and approval of the scheme, my lord, government on 25th September, my lord, sought for some more clarification, my lord, regarding the joint survey map and my lord, no objection certificate from the my lord irrigation department. Since my lord in the proposed land, my lord, water canal is my lord passing through. Therefore, my lord, on 25th of the 24, my lord, they have sought for my lord further no objection certificate and joint PT sheet, my lord. We have applied the same, my lord. After obtaining the same, my lord, you will submit to the my lord government for further action.
ಇಲ್ಲ ನೀವು ಸುಮ್ಮನೆ ಆಟ ಆಡ್ತಾ ಇದ್ರೆ ಇದರಲ್ಲಿ.
I have filed the memo, my lord, in that effect, my lord, on 25th September, my lord.
Memo reads like this, my lords. ಪ್ರಸ್ತಾಪಿತ ಜಮೀನಿನಲ್ಲಿ ಕಾಲುವೆ ಹಾದು ಹೋಗುತ್ತಿರುವುದರಿಂದ ನೀರಾವರಿ ಇಲಾಖೆಯಿಂದ ನಿರೀಕ್ಷೇಪಣಾ ಪತ್ರ ಪಡೆದು ಅಭಿವೃದ್ಧಿ ಯೋಜನೆ ನಕ್ಷೆಗೆ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನಾ ನಿರ್ದೇಶಕರ ತಾಂತ್ರಿಕವಾಗಿ ಪರಿಶೀಲಿಸಿದ ನಂತರ ವಿನ್ಯಾಸ ನಕ್ಷೆಯನ್ನು ಪಡೆದು ನಿಯಮಾನುಸಾರ ಕಾಯ್ದೆಯ ಕಲಂ 18(3) ಅಡಿ ಸರ್ಕಾರ ಆಡಳಿತಾತ್ಮಕ ಅನುಮೋದನೆ ಪಡೆಯುವುದು.
How long does it take for them to grant NOC?
It should not take more than 4 weeks, my lords.
4 weeks.
ಅಲ್ಲ, they have to first find out whether what is the nala, whether it is a natural course which the water takes when there is rains or otherwise.
Can't you see that it is done? It's your
ಯಾರ ಹೊಸದ ಕಮಿಷನರ್ ಬಂದಿದ್ದಾರೆ, he is also, I am unable to get through to him at 1:28. I got through him. I requested him to be present online on Podar ಅಂತ.
ಕಮಿಷನರ್ ಎಲ್ಲೇ?
ಅಲ್ಲ, in fact, my lord, in fact, my lord, earlier, my lord, on 25th, my lord.
Where is he?
My lord, he is not, my lord, present today, my lord.
And I'll issue a bailable warrant.
ರಜಾ ಇದ್ರು ಅಂದ್ರು ನಾನು ಮನೆಗೆ ಫೋನ್ ಮಾಡಿ ಇರ್ಲೇಬೇಕು ಅಂತ sent him the coordinates to come online.
I will keep him present, my lord, next date of the hearing, my lord.
The lords may have it on Monday itself so that at least some progress.
Monday ಇರ್ಸಿ ಅವ್ರನ್ನ.
Please, my lord, please.
Monday 2:30.
I will advise him to, my lord, appear before you.
Please.
For admission, serial number 2, Shri Raja Raghavendra.
Your lordship directed me to, Lord,
appearing for the petitioner, my lord.
Lord, on the last occasion, your lordship directed me to produce them, Lord, requisition for correction of the name in the FIR. But I have filed it along with the memo, Lord. 611, Lord, it is filed.
ಇಲ್ವಲ್ಲ?
Counter I filed ಮಾಡಿ. I have filed it in a counter.
ಎಲ್ಲಿ ಧಾರವಾಡಲ್ಲ?
ಹಾ, ಧಾರವಾಡ.
ಯಾವಾಗ?
611.
ನೆನ್ನೆನಾ?
ಇಲ್ಲ, ಮೊನ್ನೆ 611.
You stated that a memo.
Only one page, my lord, is the creation letter, one day page is this one, one day para is because I read the my lord the para to the my lord the conclusion.
ಹೇಳಿ.
My lord, ಈ ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಈ ಮೂಲಕ ನಿವೇದಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ಮೇಲ್ಕಂಡ ಉಲ್ಲೇಖದಲ್ಲಿರುವ ಪ್ರಕರಣದಲ್ಲಿ 3/6/2023 ಪ್ರಕರಣವು ಫಿರ್ಯಾದಿದಾರನು ದೂರು ನೀಡುವ ಕಾಲದಲ್ಲಿ ಅಪರಾಧಿತ 2 ಅವರ ಹೆಸರು ಶ್ರೀ ಅಂಬರೀಶ್ CPC 709 ಸಿರುಗುಪ್ಪ ಪೊಲೀಸ್ ಠಾಣೆ ಎಂದು ನೀಡುವುದರ ಬದಲಾಗಿ ತಪ್ಪು ತಿಳುವಳಿಕೆ ತಪ್ಪು ಗ್ರಹಿಕೆಯಿಂದ ಕಾಶಿನಾಥ್ ಪೊಲೀಸ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಸಿರುಗುಪ್ಪ ಪೊಲೀಸ್ ಠಾಣೆ ಬಳ್ಳಾರಿ ಎಂದು ನೀಡಿದ್ದು ಈ ಕುರಿತು ಫಿರ್ಯಾದಿಗೆ ತಾನು ದೂರು ನೀಡುವ ಕಾಲಕ್ಕೆ ನೀಡಿದ ಫಿರ್ಯಾದಿಯ 2 ಅವರ ಹೆಸರು ತಪ್ಪಾಗಿ ನೀಡಿರುವುದಾಗಿ 9/6/2023 ಎರಡನೆಯ ಹಣ ವಹಿಸಿಕೊಡುವ ಪಂಚನಾಮೆ ಕಾಲಕ್ಕೆ ತನಿಖಾಧಿಕಾರಿಗೆ ತಿಳಿಸಿರುವುದರಿಂದ ಈ ಕುರಿತು ತನಿಖಾಧಿಕಾರಿಗಳು 9/6/2023 ಎರಡನೆಯ ಹಣ ವಹಿಸಿಕೊಡುವ ಪಂಚನಾಮೆಯಲ್ಲಿ ನಮೂದಿಸಿ ಮಾನ್ಯ ಘನ ನ್ಯಾಯಾಲಯವು 12/6/2023 ಸಲ್ಲಿಸಿಕೊಂಡಿದ್ದು ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಮಾನ್ಯ ಘನ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಈಗಾಗಲೇ ಸಲ್ಲಿಸಿದ ಪ್ರಥಮ ವರ್ಧಮಾನದ ವರದಿ 4/2023 ಅಪಾದಿತ 2ರ ಹೆಸರನ್ನು ಅಂಬರೀಶ್ ಪೊಲೀಸ್ ಕಾನ್ಸ್ಟೇಬಲ್ 709 ಸಿರುಗುಪ್ಪ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಎಂದು ಸೇರಿಸಿಕೊಳ್ಳಲು ಮಾನ್ಯ ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮನವಿ.
Who informed them then? Who informed them?
Is the the complainant is the informed them ಅಂತ ಹೇಳ್ತಾರೆ ಸುಮ್ಮ ಅವರು. ಫಸ್ಟ್ ಗೆ FIR ನಲ್ಲಿ melody the name is the ಕಾಶಿನಾಥ್ ನಾವು. First trap ನಲ್ಲಿ melody is the ಕಾಶಿನಾಥ್ ನಾವು.
No, along with
the phone conversation melody as the by the complainant melody by the accused number 2 by mobile number is the mentioned. Thereafter he has the melody is the second melody the trap is the 9/6/2023. ಅವಾಗ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ.
Along with this application, I have produced the call records also. That mobile number, what he was talking.
No, my lord, even those my lord has for the first
complaint. It stands in the name of accused number 2.
Shown the mobile number, my lord.
Memo.
My lord, is the second, first trap, my lord, is conducted by the investigation authority. At the time, my lord, is the mobile number was not mentioned. My lord, yes, the complainant is the called on my lord the 7/6/2023. On that day, my lord, called by the petitioner. At the time, my lord, nothing to any demand, my lord. ಅವಾಗ ಹೇಳ್ತಾರೆ 9/6/2023 ಸೆಕೆಂಡ್ ಟ್ರಾಪ್ ನಲ್ಲಿ ಮೇಲೋಡಿದ ನೇಮ್ ಯಾವ್ದಕ್ಕೆ ಎಂಟರ್ ಬೈ ದಿ ಪೆಟಿಷನರ್ ಇಸ್ ದಿ ಅಂಬರೀಶ್ ಅಂತ.
He is the first person to not demand.
ಕನ್ವರ್ಸೇಷನ್ ಗೆ ಕೇಳ್ತಾರೆ ಸ್ವಾಮಿ 12/7/2023 ಆಫ್ಟರ್ ದಿ 1 month ಆದ್ಮೇಲೆ. Even though he has per the complainant background, my lord, he has the habitual offender. EC ನಲ್ಲಿ ನಂಬರ್ ಆಫ್ ಕೇಸಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಅವನ ಹತ್ರ.
Might be, my lord, that is not a ground to my lord seek quashing of the FIR.
My lord, as per the
Panchanama.
My lordship is the previous writ petition, my lord, is the page number 160 is the para number 25, my lord, 162, my lord. My lordship has the clearly observed that, my lord. My lord, I read the my lord the para number 25.
ನಿಮಿಷ.
Please, my lord.
Srinivas, the complaint categorically states he met Kashinath twice.
No, no, that is why the application was moved before the trial court to rectify
the complaint that he has filed. Read para 18.
No, in the complaint, it is mentioned as Kasinath only, but
No, no.
Lord, it was,
He positively identifies the inspector talking to that Kashinath. Kashinath thereafter coming and asking him about the money. And thereafter he went and gave 500
that is
rupees
why.
or something again to
No,
Kashinath.
no, in fact, what happened is, he was, Lord, the complainant was misrepresented. And Lord, the mobile number, what he was speaking,
No, there's no
in fact,
reference to the mobile number in the complaint.
No,
Please-
there is no reference in the, Lord, in the complaint, there is no reference.
Please read para 18. Does it give an indication that he did not whom he was talking to?
No, in the complaint, Lord, he says that it was Kashinath, but.
No, he positively states, there's no doubt in his mind. Then how can he thereafter say that I was under
No, in fact,
mistaken
Lord,
impression?
it is part of, that is why, Lord, the application was moved. Thereafter, what happened is, no.
So tomorrow he makes one more application. I was under misapprehension. It
No,
was
no.
not Amrutesh, but somebody else.
No, it is
So you'll again
immediately.
change it.
Lord, what happened is, in the complaint, Lord, he might have stated that, Lord, wrong name. But immediately, Lord, when the trap was to be laid, Lord, there was an entrustment Panchanama. In the entrustment Panchanama may kindly be seen, Lord. Here, there is a specifically, Lord, he says that, Lord, it is not the Kashinath and it is the, Lord, accused present petitioner. And thereafter, Lord,
This complaint was dated 3/6.
yes,
My lord, the
When was
already
the first
existed
trap
is the-
laid?
Lord, 9/6, Lord.
No, my lord, the 4/6 is the first trap, my lord.
No. Where is the trap? There was an attempt, Lord.
The first trap, my lord, is the page number 92.
No, they
my
went
lord.
to the trap since, Lord, accused number 4 was not there in the police station.
Page number
Lord,
92,
they came
my lord.
back. Trap
One
was
of
on
you-
9/6, Lord.
After the complaint was done on 3/6.
Yes.
Wasn't a trap laid on the following day?
No.
4/6.
What happened is, they went to the police station. They, after the, Lord, entrustment Panchanama, Lord, they went to the, Lord, police station. Since accused number 4 was not there, Lord, there was a talk between this petitioner and, Lord, the complainant. He sends back him stating that, Lord, that accused number 4 was not there. He was out of station.
Who's accused
There-
number 4?
Lord, he is a police constable, Lord, who was in possession of the mobile phone.
What's his name?
Lord, his name is
P. Venkatesh, my lord.
P. Venkatesh, Lord.
The FIR name in this FIR as well as, my lord, the complaint, there is the name was not shown, my lord. Case number 4.
He is not, Lord, mentioned in the FIR. His name is not mentioned in the.
Then how can the trap not be unsuccessful or not carried out
No, it
because
is
of
not
his
that.
absence?
It is not that, Lord. Your Lordship, kindly see, there are two, Lord, instances. One is that, Lord, bike and mobile phones were, Lord, seized of, Lord, bike pertaining to, Lord, complainant and the mobile phone. Bike was, Lord, subsequently, Lord, after 4-6 negotiations, the bike was released. That is what transferring from, Lord, call records. Your Lordship, kindly see them, Lord, the call record things at, Lord, page 63.
Yes.
This is, Lord, on 1/6. This, Lord, entire call conference, Lord, is
No,
between.
this is 28/5.
No, page 63.
63 is 28/5 and 1/6.
1/6. 1/6 is, Lord, there were three people were, Lord, talking. That is accused number 1, accused number 2, and the complainant in the call conference. There is clear demand by the accused number 2.
No, on this page 62 is dated what?
Not page 62, Lord, is dated 21/6/2023.
21/6.
Yes.
What is page 62?
This is Lord, samples of, Lord, voice samples, Panchanama, wherein it is extracted about the, Lord, the conversation.
And when was this change of name done?
Change of name was done on, Lord, application was filed
12/7,
on
my lord. 12/7.
11/7.
When this was done on 21/6.
Please, man. After 1 month.
Accused number 2 was that gentleman, Amrutesh Iyer. Isn't it?
What?
On 21/6/2023.
Yes.
When this was done, page
Yes,
number
ma'am.
62.
Yes, my lord.
Panchnama.
Yes, ma'am.
On record. Who
Yes,
was
ma'am.
A2?
A2 was the present petitioner.
No.
No. Apadita
ಫಿರ್ಯಾದಿ
2.
ಮತ್ತು ಅಪಾದಿತ 3 ಸರ್.
ಆಪಾದಿತ ಎರಡೊಂದು ಇದು ಇದೆ, ವಾಯ್ಸ್ ಪಂಚನಾಮ ಇದೆ. That is at page 29. Page 29 may kindly be seen.
When this Panchnama was recorded, on record, as per the FIR, A2 was not the petitioner.
No. Not
It was
there.
Kashinath.
What happened is on the date of trap, there was an entrustment Panchanama 9/6.
No, you're again going away from. FIR was registered on 1/6 alva, yavattu.
My lord, the 3/6/2023.
3/6.
3/6.
My lord, the
On-
original incident is the 15/3/2023. My lord, later on, my lord, the 3 months admelene, he had filed a complaint, my lord, the 3/6/2023. Phone conversation ಅನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿರೋದು ಸ್ವಾಮಿ 15/3/2023.
3/6 is the date of
FIR.
the FIR, isn't it?
FIR.
Date of the complaint.
Howdo.
Then when was the trap?
No, immediately they proceed.
The 4/6 ಗೆ first trap
After
ಮಾಡ್ತಾರೆ.
Lord, first trap is on 4/6. They go to the Lord police station to Lord trap Lord to conduct a trap. There Lord there was a conversation between accused number 2, the present petitioner, and the complainant, stating Lord to give back the mobile phone. Since Lord A2 Lord says that it was with the Lord A4, A4 is not in the station. Therefore, the trap was not conducted. Lord, the investigation officer along with the complete.
Even on 1/4/6.
Yes.
When this discussion took place.
Yes.
As per your records and as per the understanding of the complainant, it was Kashinath, not Amrutesh, correct?
No, it is not Kashinath. It was petitioner only, Lord.
See, this is the problem. In the complaint is categorical. That
No,
he
in the-
talked to Kashinath.
That is why, Lord, after 4, what happens is the next trap is on 9/6. 9/6, Lord, before in the entrustment Panchanama, that is what Lord he says. Kindly see, Lord, page 114.
Yes.
114. E Dinanka 9/6, your Lordship got it?
So from 3/6 to 9/6.
Yes.
He did not tell you that the person who demanded it was Amrutesh and not Kashinath. All along he was under the impression it was Kashinath only.
No. In fact, Lord, when the 4/6, Lord, they go. Trap
The
was.
first time the complainant says.
Yes.
A2 is not Kashinath, but Amrutesh is on 9th
Yes.
of June.
Yes.
Until then, everybody proceeds on the footing that it was Kashinath only.
No, yes, Lord, that is borne out.
And on 21/6, when the this Panchanama was drawn, when you refer to A2,
Yes.
the FIR was not changed till then.
No, it is first, Lord.
So that was only on 12/7. Therefore, until the FIR name was changed, as per the record, it was always considered as Kashinath.
No. That is what, Lord. It is first, Lord. Lord, the investigation, Lord. The investigation officer was told about the Lord change in the name at the first instance was on 9/6. 9/6 date on trap.
Then why did he not take immediate steps to change the name?
No, in fact, they proceeded to the trap, and Lord, trap was conducted on Lord accused number 4 on that day only.
I'll accept that also.
Yes.
Then why did he wait till 12/7 to make the application?
No,
see,
because
you are laying a trap against known people, against named people.
Yes.
How can you say that I did not know the name and
No,
amend by
because
whatever
see, your Lordship, kindly
complainant
please.
said?
No, trap was led on A4. He was not named in the FIR. He was not named in the FIR.
You are also a part of the police. If you don't even know against whom the complaint is lodged, you blindly say that it is Kashinath, and thereafter change it to Amrutesh.
No, before
it's not like as if you were shocked by this. A complaint is lodged, a particular person is named. Would you not make some inquiry to find out as to whether it is Kashinath or Amrutesh?
No, that is what Lord, part of investigation is. That is what the Lord we have done throughout the investigation. We have collected the Lord mobile number. Mobile number stands in the name of this present petitioner. I have produced along with a memo, Lord, that Lord.
So because the mobile number stands in the name
No,
of
no.
Amrutesh, accused number 2 now change is now is now
there
changed.
might be Lord some Lord wrong mentioning of
you
Lord
are
in the FIR or complaint.
You are the Lokayukta. If you don't even know against whom you are proceeding,
no,
how can I accept this argument?
The circumstances, Lord, may vary. Your Lordship may kindly see, Lord, while conducting a trial, Lord, it may be on Lord the person Lord named in the FIR or not named in the FIR.
I'm not opposing that stand at all.
Yes,
you could have simply said that you don't know. The complaint says it is Kashinath. You proceed in the footing, it is Kashinath
No, it
till
is-
9th of June. Then the complainant says that no, it is not Kashinath, it is Amrutesh. What kind of a trap did you lay?
No,
If you don't even know who that person is.
No, trap, first, no, trap, successful trap was only on 9/6. And
How
this
was
was,
it- You know, this is kind of extremely strange, Srinivas, that you don't even know against whom you are laying a trap. How can the Lokayuಕ್ತ say this? ನಾನು ಯಾರ ಮೇಲೆ ಹೋಗ್ತೀನಿ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಅವ್ನ್ ಕಂಪ್ಲೇಂಟ್ ಹಂಗಾರೆ ನಾಳೆ ರಾಜೀವ್ ಗಾಂಧಿ ಹಾಕ್ಬಿಡ್ತೀರಾ ಅಲ್ಲಿ ಹೆಸರು? Would you not make a cursory check as to who that person is?
no, because this is all done confidentially. There is no lot, in fact, lot, when the FIR is.
A police station contains 3 or 4 people. In this complaint, he specifically is ನಮ್ಮ 3 ಜನ ಹುಡುಗರು ನೋಡ್ಕೊ ಅಂತ ಅಂತಾನೆ. So you know that who the 3 people are.
No, complainant, Lord, that is what the application says, that Lord, he wrongly mentions the name.
Even those, my lord, has per the background of the complaint, my lord, he has taken number of cases
feeling, Srinivas, that this is done deliberately to let go of everybody. No, I have to let go of this gentleman. Now Kashinath also goes because of this discrepancy.
No, Kashinath
Now
is
Kashinath will say, no, even according to the prosecution does not mean it was Amrutesh.
No, in fact, my submission would be, Lord, this is not the stage at Lord where Lord whether Lord we could not go into all this material that Lord he is not the person, Lord, it is somebody else and somebody.
You have virtually exonerated
No,
Kashinath.
in fact, Lord, it is part of investigation. We are Lord conducting the investigation. Investigation.
You have exonerated Kashinath. Now Kashinath is out of the picture.
Kashinath, Lord, it is all Lord part of investigation.
That is because of your application to change name, isn't it? So Kashinath is out. You can't go against him now.
No. Kashinath was never there.
So you treat so casually that you include the name of Kashinath whenever you want, change it whenever you want.
Kashinath was never there from day one. It was only Lord a wrong mentioning of Lord name in the Lord FIR.
ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಏನಾರು ಹೇಳ್ಕೊಂಡು ಒಪ್ಕೊಳ್ತೀನಿ. ನೀವು ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸರು ಅವನ ಹೆಸರು ಗೊತ್ತಿಲ್ಲ ಅಂತಂದ್ರೆ
ಅಲ್ಲ ನಮ್ಗೆ ಗೊತ್ತಿರಲ್ಲ ಯಾರು ಇದಾರೆ ಅಂತ ಹೇಳಿ. ಓನ್ಲಿ ಆಫ್ಟರ್ ಲೇಯಿಂಗ್ ಆಫ್ ದ ಟ್ರ್ಯಾಪ್ ಗೊತ್ತಾಗುತ್ತೆ ನಮ್ಗೆ. ಯಾಕಂತಂದ್ರೆ ಇಟ್ ಈಸ್ ಆಲ್ ಕೆಪ್ಟ್ ಕಾನ್ಫಿಡೆನ್ಷಿಯಲ್. Now, so we don't know that even
the complaint names a particular constable as Kashinath.
Complaint, Lord, in complaint, in complaint, Lord, he may state Lord so many things, but it is only on the Lord date of trap and Lord after the complaint, Lord, a trap is conducted, Lord, we will be Lord coming to knowing Lord who is who. Yakantantandre, even the panchas don't know Lord where they are heading and Lord how that.
At the time, my lord, is the raid was the conducted. At the time, my lord, is the complainant also present in before the my lord is the raid, my lord. Without my lord identification, how can my lord is the raid was the conducted, my lord? ಇವ್ರು ಹೇಳ್ತಾರೆ ಅಲ್ಲಿ ಇರೋದಿಲ್ಲ ಅಂತ. ಕಂಪ್ಲೇಂಟ್ ಪ್ರೆಸೆಂಟ್ ಇದ್ದಾಗ ಇವ್ರು ರೇಟ್ ಕಂಡಕ್ಟ್ ಮಾಡ್ತಾರೆ.
ಕಂಪ್ಲೇಂಟ್ ಪ್ರೆಸೆಂಟ್ ಇರ್ತಾರೆ.
ಐಡೆಂಟಿಫಿಕೇಶನ್ ನಾವು ಮಾಡೋದಿಲ್ಲ ಅಂತಂದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ ಸರ್? ಆಲ್ರೆಡಿ ದ ಒನ್ ಆಫ್ ದಿ ಪರ್ಸನ್ಸ್ ಇಸ್ ದಿ ನೇಮ್ ಇಸ್ ದಿ ಶೋನ್ ಇನ್ ದಿ ಕಾಶಿನಾಥ್. Subsequent is the changes in the Amresh.
Pre-planned conspiracy. Everybody. Now inspector is out. This guy is out. Kashinath is out.
Kashinath.
This petition is filed by Amrutesh.
Amresh, my lord.
By Amresh. ಅಲ್ಲರಿ ನೀವು ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅಮರೇಶ್ ಅಲಿಯಾಸ್ ಕಾಶಿನಾಥ್ ಅಂತ ನೀವೇ ಬರ್ಕೊಳ್ತೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ಏಟು ಅಂತ ತಾವು ಮಾಡಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ತೆಗಿತಾರೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನಾವು ಬರ್ಕೊಂಡಿದ್ವಿ. ಈ ಕಾಶಿನಾಥ್ ಅನ್ನೋರು ಇದಾರೆ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಾರೆ.
ಅಟ್ಲೀಸ್ಟ್ ನೋಟ್ ಹಾಕ್ಬೇಕು ತಾನೆ. ರಾಂಗ್ಲಿ
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ನಮ್ ಕೊಲ್ಲಿಗ್ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ, ಅವ್ರು ಗೊತ್ತಿಲ್ಲ. ಸಾರಿ ಮ್ಯಾಮ್.
ಅಲ್ಲಿ ನಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಆತರ ಇಲ್ಲ, ಬರೀ ಅಮರೇಶ್ ಅಂತ ಅಷ್ಟೇ ಇದೆ.
ನನ್ನ ಒರಿಜಿನಲ್ ಪಿಟಿಷನ್ ಹಂಗೆ ಇದೆ ಸ್ವಾಮಿ, ಅಮರೇಶ್ ಅಂತ ಮಾಡಿದೀನಿ, ಅಲಿಯಾಸ್ ಅಂತ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ನಾನು ಆಫೀಸ್ ನೋಟ್ ಅಲ್ಲಿ ಮೇಲೆ ಅದರಲ್ಲಿ ತೆಗೆದಿದ್ದಾರೆ.
ನನ್ ಮುಂದೆ ಇರೋದ್ರಲ್ಲಿ ಕೈಯಲ್ಲಿ ಬರೆದಿರೋ ಅಲಿಯಾಸ್ ಕಾಶಿನಾಥ್ ಅಂತ.
ಅದ್ರಲ್ಲಿ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ, ಮಾಡಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ.
So you are admitting that you are also called Kashinath now?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಒರಿಜಿನಲ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಸ್ವಾಮಿ.
The comedy of errors country.
Sorry, man.
The Amresh has preferred this criminal petition seeking for quashing of the crime registered by the Lokayuಕ್ತ for offences under section 7A of the PC Act in crime number 4/2023. Amresh contends that he has wrongly been arraigned as accused number 2. He states that even according to the complaint, the transaction of the demand of illegal gratification was by Kashinath. He contends that the complaint categorically recorded the fact that Kashinath was summoned by the inspector and asked to release the motorcycle, alva?
Motorcycle, mobile man.
Motorcycle and mobile.
He points out that Kashinath had demanded he states that in the complaint, it is clearly stated that Kashinath had demanded rupees 300 as an illegal gratification and a fine of rupees 500. He therefore contends that when the complainant alleged the illegal act to have been committed by Kashinath, the arraignment of Amresh as the second accused was illegal, and therefore the proceedings as against him are liable to be quashed. Shri Srinivas Naik, appearing for the Lokayukta, contends that no doubt the complaint was containing an allegation against Kashinath when it was made on 3/6/2023, but subsequently, at the time of recording of the Panchnama on 9th
Entrustment Panchanama on 9/6.
9th June.
First Panchanama conducted the 4/6/2023 malo. 4/6 ಇದೆ sir. First Panchanama. Second Panchanama malo is the conducted on malo the 9/6.
Where is that page number?
Page number 92 malo. The first Panchanama was the conducted by the investigation. 92.
Page 62 ಅಲ್ವಾ ನೀವು ಹೇಳಿದ್ದು ಶ್ರೀನಿವಾಸ್?
ಹೌದು, ಅದು 9/6 ಪಂಚನಾಮ ಅಲ್ಲ, ಅದು
21/6. Where is it that he said he had wrongly mentioned it as
114.
114 malo second trap.
114 ಇದು this is second ಪಂಚನಾಮ, second entrustment ಪಂಚನಾಮ.
When the second Panchnama was prepared on 9/6/2023, that is at the time of conducting the trap, the complainant had stated that the second accused was not Kashinath but Amresh. He submits that only during the course of conducting the trap, the police became aware that it was Amresh who was involved in the illegal transaction and not Kashinath. He also points out that subsequently, an application was made on 12/7/2023.
It was made on 11/7. Order was passed on 12/7.
11/7/2023, requesting the magistrate to correct the name in the FIR as Amresh instead of Kashinath. And therefore, there is no merit in the contention of the petitioner that he has been wrongly implicated.
And the mobile number stands in the name of present petitioner.
He also contends that the mobile number in which the conversation, he also submits that the conversation that has been recorded relating to the mobile number was standing in the name of Amresh, and therefore it is clear that it was Amresh who was involved in the illegal transaction. In the complaint, it is averred as follows, page 18, first paragraph. This complaint is dated 3/6/2024, 2023. A reading of this complaint clearly indicates that the complainant had no doubt in his mind at all that the police sub-inspector had conversed with Kashinath. So assuming that the complainant had any doubts about the identity of the said person who talked with the police sub-inspector, he would not have further gone on to state that he thereafter had a further conversation with Kashinath regarding the payment of the illegal gratification. It is to be noticed here that on the basis of the complaint that is lodged, the Lokayuktha police would have definitely made at least a verification as to who were the persons mentioned in the complaint. The argument that they would become aware of the actual persons involved in the offense only during the course of laying the trap cannot be accepted when the complainant had positively identified Kashinath as the person who had made a demand for payment of the illegal gratification. In fact, in the second Panchnama, it is merely stated as follows, page 114. As could be seen from the above, the complainant does not even state that he was under a mistaken impression when he gave the complaint, and subsequently he came to know that the person that he referred to in the complaint was not Kashinath but Amresh. There is absolutely nothing on record to indicate as to how the complainant was under the impression that the person who made the demand was Amresh and not Kashinath. In my view, since the complaint categorically alleged wrongdoing on the part of Kashinath, merely because the complainant had thereafter stated that the second accused in his complaint was not Kashinath but Amresh, the proceedings could not have been initiated against the petitioner. Next paragraph. The argument that the mobile number relating to the transaction was owned by the petitioner Amresh, and therefore there was credence in the statement of the complainant cannot also be accepted. As stated above, the complainant had no doubt in his mind that the person who made the demand was Kashinath and not Amresh. The police, the Lokayuktha police could not have approached the magistrate nearly a month after the trap and could have sought for substitution of the name of Kashinath with that of the Amresh. In my view, the substitution of the name of the petitioner Amresh in the FIR and the intended prosecution against the petitioner Amresh cannot therefore be sustained. The proceedings as against the petitioner Amresh is therefore quashed.
You have one more contention may be recorded. That, my lord, I have filed it, my lord, in my statement of objection. That, my lord, the voice samples were collected. That voice samples, my lord, was sent for FSL. There is a positive report, my lord, of the FSL. Potential.
Another argument is advanced that the voice samples were analyzed and this voice sample revealed that it was relatable to Amresh cannot also be accepted. in the light of the positive assertion by the complainant that it was Kashinath who made the demand and not Amresh, as stated above, at no point of time did the complainant state that he was under a mistaken impression that it was Amresh who had made the demand and not Kashinath. As also observed above, there's nothing on record to indicate as to what made the complainant change his mind or in what manner he discovered that the person who made the demand was Amresh and not Kashinath.
Please, ma'am.
Seal number 3, Sri T. Anumareddy.
My lords, appear for the petitioner. Petitioner is accused number 3, my lords.
In this, I appear for respondent, lords.
Yes.
Thus, I am seeking for short accommodation for next week, lords. Except FIR and complaint, there is no trap Panchanama produced, my lords. I'll check your instructions and make my submissions, my lords, for the next week, lords.
Release.
For further hearing, seal number 4, Sri Harsh Nilapal.
Appear for the petitioner, my lord.
In Madle.
My lords, I have filing, my lords, the affidavit. I've mentioned various dates on which, my lord, they give an undertaking that they'll produce, then they seek time, then they again seek time. Now, my lords, they say that all that we can pay is, my lords, only the principal amount. But since there's no interim order, I spent a huge amount of money and I already filed a section 5(2) petition before the special court. And I'm going to understand, my lords, that if really pushed to the wall, they are ready to pay at least 8 to 10% of interest.
In our Sri Harshana is taking a risk.
Yes, my lord.
Yeah, this is the prerogative. This is prerogative. We'll go before special court, my lords. Let all the points be agitated. Now, disputed questions of fact are involved.
Lord, they are ready to pay the principal amount, my lord, because it is a sale agreement without possession, my lord. And they have mentioned in the agreement saying that in case of non-payment, they will file a suit for specific performance. It is a specific clause.
May I make one humble submission, my lord?
My anxiety is that at least something comes back.
How, my lord? But my difficulty is this, my lord. I understand, my lords, the contention of the petitioner. But my lords will also spare a
I'm
thought.
not interested in his contention. I'm interested in seeing that some amount is recovered.
Yes, it will be recovered. Well, for this reason, my lord, that the lands are indeed valuable, my lords, and I have intelligence report.
How can you go against an agreement in which only agreement of?
Well, there are judgments. Videocon judgment is there, my lord. Videocon judgment is there, my lord. Lord, kindly appreciate this. I'll pursue your lordships on the merits. Now, the petitioners are sitting with 4 crore rupees for the past 7 to 8 years. They've had the benefit, my lords, of the lands also. Well, and kindly spare
the
thought,
agreement
my lord,
of sale
for thousands of depositors.
The amount
Kindly
is by
spare thought.
way of cash.
Yes, sir, one nimsha. One submission, my lord. Section 5(2) petition is already filed. Notice, my lords, has been issued to the parties. But if they can contest the matter, my lords, all disputed questions of fact, propositions of law, because there's a statutory remedy available to them, my lords.
My lord, may I read, my lord, the recent decision of this honorable court, my lord? It's clearly on the points. Clearly on the.
Now, what is the prayer in the petition? What is the next ref?
Next ref is the order of attachment, my lord, not to alienate the property has been.
Act today Karnataka production of page.
Next, Sheriff, my lord, page number 139, my lord. It is totally silent as to the agreement of sale, my lord.
This is an order passed, not to alienate, huh?
Yes, my lord. ಲಾಸ್ಟ್ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಎಲ್ಲಾ ಆಸ್ತಿಗಳ ಪಹಣಿ ಪತ್ರಿಕೆ ಅಂಕಣ 11 ರಲ್ಲಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣವು ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿ ಬಾಕಿ ಇರುವುದರಿಂದ ಯಾವುದೇ ಪರಭಾರೆ ಮಾಡಲು ನಿರ್ಬಂಧವಿದೆ ಎಂದು ನಮೂದಿಸಲು ಕಳಿಸಲಾಗಿದೆ.
And what is wrong with this order?
Lord, this my lord, I have produced the my lord entire my lord the financial institutions report, my lord, saying that this property is not at all in surcharge proceedings. I have produced, my lord.
Either way, you have now gone to the, you're before the special court decision under section 5(2).
No, my lord, not at my lord. They say that now they have issued notice.
So you can raise all this contention there. I'll close this proceeding.
Lord, because only one submission is, my lord, an agreement holder, my lord. This honorable court had an occasion to consider similar point, my lord, in WP 100-120/2023, my lord. Based on the decision of this honorable court in ILR 2010, my lord, saying that this KPID Act is not applicable for initiating proceedings against the agreement holders.
No, you can raise all this there. Why should I entertain this petition?
The writ has been entertained by this honorable court, my lord. It is decided on 6/2/2023, my lord. Similar, same points, my lord.
You have the act with you?
What's the act? I need a soft copy, my lord. My lord, one submission. Now that my learned friend is on the merits of the case. But what is challenged before your lordships in this writ petition is not as much the section 3(2) petition, is only a subsequent administrative order that is passed in pursuance of the original order. Your lordships have taken a view, the Supreme Court has taken a view that if the substantive original order, which is a cause to a subsequent order itself, is not in challenge, without challenging 3(2), in fact, the annexure E that my learned friend is referring to does mention section 3(2).
We have filed the application for amendment after during pendency, they have issued the notification. Before section 3(2), my lord, this order has been passed.
Please, in which case, my lord? In which case, my lord? Section 5(2), once, my lord, section 3(2) notification is, my lord, issued by the government of Karnataka. It's only an ad interim attachment where none of the rights, quite the liabilities are determined. I have to file, my lords, a 5(2) petition. And in the 5(2) petition, my lords, the field is kept wide open for my learned friend to raise all objections available to him.
Section 3 itself is not applicable, my lord. Then section 5 has no, my lord, application. Section 3 says, may I read, my lord, with lordship's permission?
Book bandila iru nimsha.
Please.
Section 3(2) would be relevant, my lord. I make one humble submission, my lord. If my learned brother, my lords, wants to address the argument on merits, then, my lords, I will address that. Because first of all, my lord, whether a petitioner who gives an undertaking before the court and does not comply the said undertaking would have the benefit, my lords, of an audience. My lord, the Supreme Court has taken a view that having enjoyed the interim order, now not complying, and now, my lord, seeking a right of audience. So my learned friend would not have a right of audience at all in my first submission.
My lord, my undertaking was without admitting the fact that this money relating to the financial institution, I have filed an undertaking. My learned friend, my lord.
But irrespective of the cause and the reason.
You are the agreement holders, huh?
Yes, my lord. Registered agreement along with the GPA, my lord, which creates interest.
Without possession, my lord.
Without possession.
And only 13 members are, my lord, who have entered into the agreement, my lord, not in respect of all the petitioners. They say that they are, according to their convenience, they are saying it is a benami.
President of the society has executed an agreement with them.
My lord,
The president of the society or the family members have.
my lord, the president of the financial establishment, the member of the financial establishment has entered into an agreement with, please, my lord, and has paid the entire sale consideration. There's not even a rupee which is yet to be paid. Entire sale consideration has been paid. My lord, I'll be able, once my learned friend argues, I'll be able to establish the conspiracy that has been hatched. Here is, my lords, the financial establishment takes the money from the depositors, gives 100% of the agreed amount, but does not take the possession of the lands in question.
No, all of these are vendors.
Please, my lord. Who have the benefit
Not
of,
all,
my
my
lords, the 100% of the agreed amount and also the land in question.
Please, my lord.
My
lord, in the agreement, my lord, they have stated that the hence no separate after receipt of entire security in future sellers in case of non execution of the regular sale deed, they are entitled to file the suit. And there is a clause, my lord. So they cannot be termed as, my lord, in any way relating to the financial institution as, my lord, described under section 3. And this honorable court has clearly held, my lord.
Where is the order of attachment made?
My lords.
Where is the order of attachment made under section 3? Attachment ಆಗಿದೆಯಾ?
3 to ಆಗಿದ್ದು 3 to ಆಗ್ಬಿಟ್ಟು 5 to ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ.
Date.
My lords, I'll mention, my lords. But 27/6/2019, my lord. It's published in the official gazette, my lords, on 20. In fact, page number 139 itself would say that. The impugned order itself would spell that.
Date could have.
Well, 20, my lord, page number 139, if I can trouble your lordships, my lord, 139, my lords. There's an impugned order, my lord. Unnumbered paragraph number 2, my lords. ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಓದಲಾಗಿದೆ. ಸೊ ದಿನಾಂಕ 25/6/2019 ಪ್ರಕಾರ ಆನಂದ್ ಸೊ ಕ್ರಾಂತಿ ಸಂಗೊಳ್ಳಿ ರಾಯಣ್ಣ ಇವರ ಹೆಸರಿನಲ್ಲಿರುವ ಆಸ್ತಿಗಳನ್ನು ದಿನಾಂಕ 27/6/2019 ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪತ್ರದಲ್ಲಿ ಪ್ರಕಟಿಸಲಾಯಿತು. ಸೊ 27/6/2019, my lords, section 3(2) notification.
That is challenged by virtue of amendment.
Total is 332 acres plus 400 acre, 430, 450 ಅಷ್ಟೇನಾ?
Please.
But ಇವ್ರೇನು 800 acres ಅಂತ ಹಾಕಿದ್ದಾರೆ?
ಎಲ್ಲರೂ ಸೇರಿ 800 acres. 800 acres.
But this page 113 only deals with 139 acres.
But they're only with a few lands perhaps, my lord. And this is an order. Because once, in fact, my lords, once 3-2 notification is issued, my lords, in terms of section 3, clause 4 of the act, but the land stands vested with, my lords, the competent authority.
ಎಲ್ಲ ಲ್ಯಾಂಡ್ ಇದೆಯಾ ಅಗ್ರಿಮೆಂಟ್ ಇರೋದು ಅಲ್ಲ ಬರೀ ಕೆಲವು
ಎಲ್ಲ ಲ್ಯಾಂಡ್ ಇದೆ. ಎಲ್ಲ
ಇಲ್ಲ
ಲ್ಯಾಂಡ್
ಇಲ್ಲ
ಇದೆ.
ಎಲ್ಲ ಇಲ್ಲ ಅವ್ರದ್ದೇ affidavit ಇದೆ.
If my learned
ಅವ್ರದ್ದೇ
friend,
affidavit ಇದೆ.
my learned friend does not even whisper of the agreement to sell and the power of attorney executed, which is registered in the entire petition. When I submit before this honorable court that their agreements, the same is disputed. But if my learned friend now to dispute that there are any agreements or the power of attorney.
The prayer in the writ petition is to challenge Annexure F.
Annexure F, please, my lord.
Suppose I grant that prayer. The NOC will be granted only in respect of these particular lands, nothing more.
Please, my lord. First, I'll have to take instructions as to.
Because it says in this writ petition, total measuring 883 acres.
2020, 750 acres of land, my lords.
What?
750 acres of land.
Your page 113 is reflected.
My lords, there is, my lord, subsequent 2023, section 3-2 notification I'm given to understand, my lords. This is only a, my lords, I'll produce the annexure, which my learned friend says he has challenged now, the section 3-2 notification. Now, I'm under instructions that 2023, my lords, is the notification, 3-2 notification, and that covers, my lords, 750 acres of land, which is subject matter of agreement to sell and power of attorney.
Where is that 3-2 order?
My lords, I submit. Today, my lords, I was thinking that my learned friend will either, my lords, would pay the money or not. So I'm not fully prepared on the merits.
Told him I'll dismiss it because I had given him sufficient time.
How, 5-2 petition, we have spent about 40,000 rupees to file the section 5-2 petition.
Give me that order, that 3-2 order. ನಿಮ್ಮ ಹತ್ರ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ 3-2 order na?
I have produced along with IFR amendment dated 25/1/2024.
I have the proposal that was sent to the government, my lords, but I'm not immediately having the copy of 3-2 notification, my lord.
Next, okay. Abstract ilva ಎಷ್ಟಿದೆ ಒಟ್ಟು ಅಂತ?
In fact, my lords, I have sent a proposal to the government of Karnataka, my lords, giving the details, my lords, of the land, my lords, and also the money that has been received, which is, my lords, the precursor for section 3-2 notification. My lords, may kindly, I'll file it.
Use this 3-2 order dated 22/12/2023.
23, please.
There are only about 66 items of the property, 67, I think. Isn't there an abstract as the total extent of land?
Please note, whatever is my lord, section 3-2, 66 items, my lord, but the lands would be, some would be having more than 1 acre or 2 acres.
How made a petitioner to 5-2 for making this absolute?
Please, my lord. Where it is open for my learned friend to take all contentions available, including that, my lords, of a preposition of law.
Near idea?
Is Lord, now, no, Lord, because they are, my lord, what they are saying is in case if they deposit the principal amount, if they, my lord, again, my lord, demand interest, my lord, on the, they are saying SR value plus 2%, my lord.
I'll leave it to your lordships, my lord. That is the case. I'll leave it to your lords. We are in the holy hands of your lords, my lord. Whatever percentage your lords would, my lords.
ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ನ್ಯಾಯವಾಗಿ ಮಾತಾಡಿದ್ರೆ ಏನಾದ್ರು ಆಗುತ್ತೆ. ನೀವು if you're trying to
ಇಲ್ಲ, we are not, my lord, we are not SR plus 2% value, it comes to 8 crores, my lord. The principal amount is 4 crores.
So what is the interest that you are prepared to grant? You are give?
Lord, I will seek instruction, my lord. Last chance, I will seek instruction, otherwise your lord, my next date of hearing.
Or else I'll dismiss the petition. You can go there and raise whatever contention you want.
I will ask one chance may be given, my lord.
And suppose I dismiss the petition with some observation, the possibility of you getting an order before the special court may not be very easy.
Please. Please.
Alva?
Yes, my lord. We'll seek instruction, my lord.
Nodi, ಯೋಚನೆ ಮಾಡಿ ಆಮೇಲೆ don't invite an order.
Yes, yes, my lord.
Golden opportunity is knock only once, please, my lord. But for him, it's knocking the second time.
More than him, I'm worried about the depositors.
Please, my lord. Please, my
Get
lord.
back something is all that I'm thinking.
Please, my lord. I am so grateful, please, my lord.
Because ultimately the victims are.
My lord. It's sad, my lords. People who are just getting about 5,000, 10,000 per month. Well, for a greed, not that, my lords, I am really feeling bad for a greed, my lord. But however, my lords, they have been cheated
Lord,
by.
though there is an agreement of sale, my lord, in fact, no consideration is paid, my lord. Though they say that there is an agreement of sale.
ಅಲ್ಲ ನಮ್ಗೇನ್ ಜಾಸ್ತಿ ಗೊತ್ತಾಗಲ್ಲ, but we can find out that there is a kind of a scam that is being hatched by.
I am, my lords, off the record, I am under instructions that a very big steel giant, my lords, is in talks with them.
ಯಾರು ಇದ್ಕೊಳ್ಳಿ ನಮ್ ಡಿಪಾಸಿಟ್ ಕಾಸು ಕೊಡ್ಲಿ ವಾಪಸ್.
Please, my lord.
ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ ಅವ್ರು ಕಾಸಿರೋರು.
Please.
Please, my lord.
Monday 2:30, may I pray for, please, my lord?
Come at 4:30 better.
My lord.
4:30.
Please, 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 my lord. Please, my lord.
Oblige, my lord.
Number 5.
This matter, my lords. My lords,
ಸಿಗ್ತಾ ಅದು?
ಎಲ್ಲ ಸಿಕ್ಕಿದೆ ಸ್ವಾಮಿ. I am going to understand, sir. In fact, my lords, for ready reference of my lords, I had prepared a questionnaire, my lords, and had sent to them. And my lords, the answers, my lords, if my lords, so I'll file that in the form of an affidavit, my lord. At page number 1, if my lords were to kindly take, my lord. I have raised the question, my lords, and the answer also is as follows, my lord, and the supporting documents also, my lords, are enclosed, my lord.
So if there are no rules framed, there is no question of sanction post argument.
My lords, similar, my lords, to the bylaws of what, my lords?
There was rules for group B, C, and D for nurses. If there are no rules at all.
But there are only
requirement of issuing a paper publication.
And it's also quite similar, my lords, to the rules that my lords, bylaws that my lords have kindly been pleased to observe. There is a bit of similarity, my lords, that there also, my lord, the governing council had the discretion of appointing permanent and temporary, my lords. A similar provision also is here. But though, my lords, my contention would be that if a government has taken a decision, a conscious decision, my lords, to outsource the employment or the engagement, that would be my arguments, my lord. But however, on the facts of the case, my lord, there also is a provision, if my lords were to kindly permit me to only take, my lords, relevant portions, which are in a way similar, my lords, to Jayadeva, my lords. My lords, may kindly take my page number 45, my lords.
Yes.
Lords, point number 16, my lord. Absorption of staff in the institute shall be regulated as under. The institute shall obtain option from the existing staff. The institute shall have the power to retain staff till such time as it may consider necessary in spite of representations to the contra. The institute shall have.
The option is from people who are deputed or?
But this, my lords, because my lords, I'm going to understand, my lords, that how BIMS or GIMS or BIMS was born was earlier, my lord, used to be called as the district hospitals in each district, my lords. Later on, my lords, I'm going to understand that they, my lords, were nourished as, my lords, Institute of Medical Sciences. They were, my lords, the medical colleges attached to the existing hospital. That's how, my lords, I'm going to understand that in each district, every district, preferably a district headquarter, has, like Hubli has, my lords, Karnataka Institute of Medical Sciences, Belgaum has Belgaum Institute, Gulbarga has so-and-so, Karwar has KIMS, my lord, Karwar Institute of Medical Sciences, Raichur, my lords, I'm going to understand, has Raichur Institute. So this is how, my lords, I'm going to understand that these IMS were born, my lord. And para 19, page number 46, my lord. which speak of appointment of medical, paramedical and administrative staff, my lord. And the service conditions also, my lords, are mentioned. My lords,
ಹಾಕಿದಾರಂತ ಜಯದೇವ ಮೇಲೆ appeal ಹಾಕಿದ್ದಾರೆ.
my lords, I am not aware, my lords. In fact, my lords have taken a view in the Dharwad bench, my lord. Even though an order passed, and the Supreme Court also says, my lord, even though an order passed by a particular court has been stayed by the superior court, but for the purposes of a preposition of law that will continue to bind, in as much as, my lord, the interim order only would operate as in personam, not in rem, my lord. That's what the court has taken a view, my lords. But nevertheless, my lord, I understand, my lords, the
It is only for paramedical staff.
paramedicals, my lord. Page number 52, my lords, may kindly take, my lord. It speaks of permanent and temporary post, my lord. Page number 52, my lords. This is, my lords, bylaws, my lord. Page number 52, foot of the page, 0.5, my lord. Permanent and temporary posts.
According to these were temporary posts, huh?
Temporary, my lord, temporary. They're not even a post, my lord, but for the purposes, my lords, we could.
It's through an outsourcing agency, it will be the same, isn't it?
Please, my lord.
It will only be.
But 56, my lords, may kindly take, my lord. Just because, my lords have observed there that whether the selection committee or the authority who appointed had the power to do so. My lords, page number 56, para 11, my lords. The post may be filled up by invitation, direct recruitment, promotion, or deputation of the state government. The selection committee shall verify the credentials of all the persons. The committee shall prepare the panel of names and recommend the names for selection in the order of merit when a vacancy arises. My lords, 67, my lords, may kindly take, my lord. Permanent and temporary posts, my lords. The posts created by the governing council in accordance with rules and regulations may be either permanent or temporary as the governing council may specify from time to time. And 2 and 3, my lords.
It's virtually identical.
Plus, I'm going to understand, my lord, that all over the state, my lords, all these Institute of Medical Sciences, my lord.
I think Jayadeva was the
flagship Indian Institute of Medical Sciences could
they
be.
followed everything from Jayadeva's.
My lord. In fact, my lord, as far as BIMS is concerned, my lord, some other, my lords, similarly situated people, my lord, had filed a petition, which came to be allowed, my lords, by saying that they should be regularized and should be paid, my lords, the salary from their first day of appointment. Plus, having been challenged, my lord, in the intra-court writ appeal, their lordships have taken a view, my lord, that there cannot be any appointment, permanent appointment without them. That is, my lords, the division bench has taken a view that there cannot be a substitution of one temporary with another temporary or an ad hoc basis, my lords.
They all these people have worked for how many years?
Of course, depending upon, my lords, about 10 to 12 years, but now, my lords, for the past 2 years, it's only when, my lords, they were not continued by the outsourced agency that they approached this honorable court, my lord. So I do not really have, my lords, any dual relationship of an employer and an employee, my lords, with them. In fact, my lord, the difference between the regularization before, my lords, the constitutional court.
How many posts are there?
But there's no such post, my lord, but
a year.
I'm going to understand about 13
There
to
are
14.
84 posts, my lord. Total 84 posts. Out of that, only 34 posts have been filled, my lord.
Filled by others.
Yes, my lord. And as far as 50 posts are concerned, they are still vacant, my lord.
How many petitions are here?
41, my lord.
Correct, other 51 vacancies.
I'm not aware as to how many vacancies
Because I don't want any order that I pass, resulting in displacing somebody.
I've taken instructions on that regard also, my lords. I'm given to understand that the contract of the present year, my lords, would be there for the next month or so, my lords. Then thereafter, my lords, I'm given to understand that fresh tenders, depending upon the orders, if your lordships, my lords, are going to be passed.
My lord, in the year 2012,
but as on date, my lords, none of
posts.
them are working with the BIMS, my lord.
Only those 34 are working.
Illa, the tender korbitu, my lord, we
34 regular appoint ಮಾಡ್ಕೊಂಡಿದಾರಲ್ಲ.
ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ. ಇಲ್ಲ, because, my lords, once the government passed the order to take them on outsourced basis, my lord, as and when there was a need, they used to call for tenders, my lord, and they used to take, my lords, on the contract basis, my lord.
So as of now, all these posts are vacant, like
no, on contract.
nobody is discharging their work.
my lords, the contract, my lords, because the manpower consulting agency or my lords, manpower my lords supplies, they are my lords, as many number of people as we want for a particular post, my lords, or a particular job, but we are taking them on contract. But on outsourcing basis, my lord, we call for tender amongst the my lords, eligible manpower supplying agencies, my lord. And based on the tender, my lord, they give to us as many number of people as we want, my lord. But there's one question that my lords may have to be considered. Lords, if at all it's a D post or my lords, a D category, my lords, whether an industrial labor act would apply or my lords, because it may not be per se a post under 310 and 311. So my lords, it may be a case, my lords, where my lords, they may agitate, my lords, that it may be unfair, my lords, labor practice, my lord, but
all this is an attempt only to push them again to one more round of litigation.
I'll assist the court, my lords, because
My lord, one submission, my lord.
Yes.
The documents which Viresh has produced today, my lord, in the statement which he says that was a questionnaire which was given by him to the institute, my lord. In at serial number 4 of that questionnaire, my lord.
Yes.
Whether the order dated 2/7/2012 by virtue of which the petitioners were appointed on contract basis for a period of 11 months preceded by the government order. So he says that they were appointed on contract basis, my lord, for 11 months. Thereafter, they have outsourced, the agency has been appointed, my lord. So for that answer, my lord, on the basis of the letter dated 29/6/2012 issued by Principal Secretary Health and Family Welfare Services, the order dated 2/7/2012 was published to continue the services of existing 154 Group C and D outsourced employees on consolidated salary till further orders for a period of 11 months and renew their services for the further period on the consolidated salary. So, my lord, I have produced annexure A and B, wherein these persons were employed on contract basis for 11 months, my lord, on 2/7/2012. And subsequently, my lord, the same work has been outsourced to an agency, and the agencies have changed, but the same employees have continued, my lord.
In fact, my lords, my learned friend, my lords, page number 4. Why, my lords, a letter? In fact, there being no selection committee, my lord, there being no paper advertisement, there being no notifications, my lord, certain people were taken. And why, my lords, it's at page number 4, my lords, it's based on the letter dated 29/5/2012. Based on their own representation, my lords, that such an order has come to be passed. Page number 4, my lords, may kindly take, my lord. Of my compilation that I gave today, please, my lord. ಬೆಳಗಾವಿ ವೈದ್ಯಕೀಯ ವಿಜ್ಞಾನಿಗಳ ಸಂಸ್ಥೆ ವರ್ಷಗಳಿಂದ ಬೇರೆ ಬೇರೆ ಹುದ್ದೆಗಳಲ್ಲಿ ಹೊರಗುತ್ತಿಗೆ ಆಧಾರದ ಮೇಲೆ ಅತ್ಯಲ್ಪ ವೇತನ ಶ್ರೇಣಿಯೊಂದಿಗೆ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿದ್ದು ಇಂದು ಪ್ರತಿನಿತ್ಯ ಉಪಯೋಗಿಸಲಾಗಿರುವ ಪದಾರ್ಥಗಳ ಬೆಲೆಗಳ ಗಗನಕ್ಕೆ ಏರಿ ಜೀವನ ತಾವು 4.5 ವರ್ಷಗಳಿಂದ ಸತತವಾಗಿ ಸಂಸ್ಥೆಯ ಆಸ್ಪತ್ರೆಗಳಿಗೆ ಶ್ರಮಿಸುತ್ತಿದ್ದು ಹುದ್ದೆ ಮಂಜೂರಾತಿಯೊಂದಾಗಿ ಸಂಸ್ಥೆಯಿಂದಲೇ ನೇರವಾಗಿ ಸಂಚಿತ ವೇತನ ಪಾವತಿಸುವಂತೆ ಹೊರಗುತ್ತಿಗೆ ಆಧಾರಿತ ಸಿಬ್ಬಂದಿಗಳು ಕೋರಿರುತ್ತಾರೆ. So and so is ಲಗತ್ತಿಸುತ್ತದೆ. So at their own, my lords, request, and that till when, my lords, the next paragraph would say so, my lords. So that, and even the agreement says that is only for a period of 11 months, and thereafter, my lord, the government has taken a decision that you should be on outsourced basis. So unless my learned friend were to challenge that very order, by virtue of which,
but if you have continued them on the same basis through a mediator, like an intermediate, that remains that all of them have continued. So why should they come to the court? As it is, they are on the footpath. You want them to come and argue on legal principles?
I have my own limitations to argue this matter, please, my lord.
My lord, for this, my lord, I have just relied on one judgment of the apex court, my lord, of the year 2011. I have given a memo in the case of Bhilwara Doodh Utpadak Sahakari, my lord, unnumbered para number 2, my lord. May I read, my lord?
Yes.
In order to avoid their liability under various labor statutes, employers are very often resorting to subterfuge by trying to show that their employees are in fact the employees of a contractor. It is high time that this must come to an end. The labor statutes were meant to protect the employees, workmen, because it was realized that the employers and the employees are not on an equal bargaining position. Hence, protection of employees was required so that they may not be exploited. However, this new technique of subterfuge has been adopted by some employers in recent years in order to deny the rights of the workman under various labor statutes by showing that the concerned workmen are not their employees, but are the employees workmen of a contractor, or that they are merely daily wage or short-term or casual employees, when in fact they are doing the work of regular employees. This court cannot countenance such practice anymore. Globalization, liberalization in the name of growth cannot be at the human cost of exploitation.
The question, my lords, that would go to the root of it, my lords, whether the policy of the government of Karnataka, my lords, is similar to very many other governments of having, my lords, outsourced employment itself can be held to be unconstitutional or illegal or arbitrary. Because various courts have taken a view, my lord, that it is the government which knows its muscles and its pains. So it is the government which will have to take a decision.
Concerned with the government. This is an institute and it's not the state.
I'm not-
This is a society.
Please,
So,
please, my
the government may say so many things. It's not really binding on them. If the bylaws permit them to recruit, they ought to recruit.
please, my lord. But my lord, it is under the directions, my lord, of the order passed by the government of Karnataka that they should be on the outside.
Which bylaw says that the order of the government?
Ultimately, my lord, as I said, my lord, I'm a poor son of a rich father, or now, my lord, a poor father also, because every appointment shall have to be approved, my lord. The money that I
Where?
But
Under,
it's-
you are a society.
society, please, my lord.
Now, which bylaw says you are bound by the directions given by the state?
Because my appointment shall have to be approved, my lord, by the.
Illi there.
I'll point out that, my lord. I'll point that.
I was not able to find out even that Jaideva's case. I understand that the government is the authority, it's got the purse strings with it. But the society is gone by its bylaws. You may raise money from any source that you want. And there may be conditions imposed for you to borrow. But once you recruit, once you pay the salary,
Please.
certain rights are created vis-a-vis you and your employee.
But only, my lord, I'll, if at all I'm able to get that, my lord, I'll flag it and I'll place it with the lower court officer tomorrow, please, my lord. Only as far as that aspect is concerned, my lord. Whether the government is the financing agency or, my lord, it's the fully autonomous in terms of both power and finance, my lord, I'll place it on.
The bylaw obviously can't say anything like that, saying that the government, because the governing council is by the Minister of Education and others.
Please, my lord.
It's virtually the government which is controlling the institution. But unless the bylaw specifically says that you are bound by this, then even if it says, I think as far as the fact that the employees are concerned, C and D, they are regular employees. You may choose any method or any modus operandi, but the fact remains is that they are your employees.
Please.
What is the financial implications?
Lords, it will be, my lord, it will be huge, please, my lord. For this reason, my lord, that if your lordships were to
Say from the date on which they came to the court, or because in that case, I said from the date they came to the court.
Please, my lord, I'll leave it to the lordship's discretion, my lords.
Because or else I should say on the expiry of 10 years.
Since your lordships have taken a view, my lords, in the other matter, my lords. Please. In fact, the difficulty, my lords, I have made a compilation of about 80 judgments, my lord. Equivalent benches of both the Supreme Court and of various other high courts, my lord. I have.
Viresh, I did not go through all the
I
citations.
think that's the reason I didn't want to trouble your lordships with those judgments, my lord.
So I went by the bylaws. I
Please.
know going under the citations,
Please, my lord.
there are 3 judgments for, 4 against, again 3 against.
Please, my lord.
Seal number 6.
Would this be reserved for orders, please, my lords? Please, please. No, only in case I'm able to find that, my lords, I'll place it with the learned court officer. Deeply obliged, my lord.
Seal number 6.
Please, my lord.
I appear for the respondent. ಚೆನ್ನಾಗಿದೆ ಇವತ್ತು.
ಗುಲ್ಬರ್ಗಾಗೂ ಬಂದಿದ್ದೆ ತಾವು ಜುಡಿಷಿಯಲ್ ಅಕಾಡೆಮಿ ಭೋಪಾಲ್ಗೆ ಹೋಗಿದ್ರು ಅಂತ ಗೊತ್ತಾಯ್ತು. Please, my lord.
My lord, one submission, your lordship. Appear for respond number 3, your lordship.
Yes.
Request the next week, any date, your lordship.
ಮೇಡಮ್ ಯದ್ರಾಮಿ ಅವ್ರು ಬಂದಿರೋದೇ ಕಷ್ಟ. ನೀವು ಅದ್ರ ತಿರ್ಗಾ ಟೈಮ್ ತಗೋಬೇಡಿ ನೀವು.
Last time also your lordship has clearly informed them to be ready. So, my lord, in the review petition that has been filed, I want to.
Which do you want me to take up first?
My lord, review petition to begin with. Because the main issue involved is 100,005. Yes. So, my lord, one Sundar Rajan is the whole cause for this whole episode. He files a petition under section 20 of the Mental Health Act 1987. Page 17, may kindly be seen, my lord, the review petition. So the matter was taken by lordships in a writ petition only to the extent that the patient's custody be given to her daughter was the order which was challenged before lordship in WP number 100270.
Daughter is before the court now.
My lord,
The daughter is before the court now. In review.
please.
The daughter is now before the court.
No,
Who has filed the review?
it is Sundar Rajan again.
No.
No, my lord,
Review petition is filed by Krishna.
Krishna, yes.
Is the
She's-
daughter.
By his GPA holder Sundar Rajan. We don't know, we have never seen where she is there or not. It is the Sundar Rajan who claims to have taken GPA.
Who appears for the petitioner?
My lord, Arvind Kulkarni.
Arvind Kulkarni. Madam, do you appear for the petitioner here? In the review?
I appear for the respondent number 3, Your Lordship.
This one. Your lordships, by the order dated 25 to 2021, had issued notice, and registries directed issue notice to on Srinivas Koski Medical Superintendent demands who submitted the report to this court on so and so the date. And pursuant to this, my lord, my colleague on record has filed a wakalat, but cause list last time our sister torchidru, ee sala torchilla.
GPA ನಂಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ. GPA is
Yeah, my lord, he is the man who played mischief and taken a sane person to be declared as insane and having retained in the hospital for 1.5 years, contrary to the very provisions of this Mental Health Act of 2017. For a minute, I want to take your lordships to analyze your lordships the provisions. The whole proceedings have become vitiated. And even before your lordship, while arguing the case, my lord, this particular point was not brought to the notice of this honorable court. So I'm on only 2 points, my lord. One is the review petition doesn't survive for consideration. It's one thing. Second, my lord, in the other writ petition,
Why does it not survive? Why does it not survive?
because my lord, the proceedings were submitted before lordships under the provisions of old act, the act of 1987. My lord, 26 of the Mental Health Act 2017 for a minute. Your lordship is pleased to.
No, this writ petition was in relation to the order passed by the trial court.
Yes, the order passed by the trial court, my lord, may I take your lordships to directly starts from my lord page 43.
You are supporting the order. You are supporting the order.
I am definitely supporting the order.
Let Kulkarni come. Let him come without his.
Other problem will, my lord, there is an interim order of stay, however, his promotion is held up. The man.
Your writ petition number.
My lord, my writ petition is 105607, challenging the impugned charge sheet because by the law laid down by this honorable court.
Next re.
Promotion held up because of this.
Why should I quash the charge sheet?
Because, my lord, one thing by virtue of the
charge sheet.
Lord, charge sheet is at annexer C7 and C2. Page 30 to 37.
The page 41 of the concept.
Yes.
Read. What's your name?
Srinivas Koski.
Yes.
Dr. Srinivas Koski, ಸಹ ಪ್ರಾಧ್ಯಾಪಕರು ಪ್ರಭಾವ ವೈದ್ಯಕೀಯ ಅಧಿಕಾರಿಯಾಗಿರುವ ನೀವು ಸಂಸ್ಥೆಯ ನಿರ್ದೇಶಕರ ಏಕಪಕ್ಷೀಯ ಡಾಕ್ಟರ್ ರಮೇಶ್ ಬಾಬು ಪ್ರಾಧ್ಯಾಪಕರು ಸೈಕ್ಯಾಟ್ರಿ ಸಲ್ಲಿಸಿದ ಹಾಜರಾತಿಯನ್ನು ಮಾನ ಮಾಡಿ ಅವರ ಹೆಸರನ್ನು ಹಾಜರಾತಿ ಪುಸ್ತಕ ನಮೂದಿಸಿ ಅವರ ರುಜು ಪಡೆದಿರುವಿರಿ. ಅವರು ಹಾಜರಾದ ಬಗ್ಗೆ ಸಂಸ್ಥೆಯ ಮುಖ್ಯಸ್ಥ ಗಮನಕ್ಕೆ ತರದೆ ನೇರವಾಗಿ ಸರ್ಕಾರ ಹಾಗೂ ರಿಮ್ಸ್ ರಾಯಚೂರು ಪ್ರಾಧಿಕಾರ ಮಾಹಿತಿಯನ್ನು ಸಲ್ಲಿಸಿರುವಿರಿ. ಅಲ್ಲದೆ ಆಡಳಿತಾತ್ಮಕ ವಿಷಯವಾದ ಅವರ ಸೇವಾ ಪುಸ್ತಕವನ್ನು ಸಹ ನೀವೇ ಸ್ವೀಕೃತಿ ಮಾಡಿಕೊಂಡಿರುವಿರಿ. ಈ ಬಗ್ಗೆ 20/12/19 ಡಾಕ್ಟರ್ ರಮೇಶ್ ಬಾಬು ಪ್ರಾಧ್ಯಾಪಕರು ಸೈಕಿಯಾಟ್ರಿ ವಿಭಾಗ ಇವರ ಹಾಜರಾತಿ ಕುರಿತು ತಕ್ಷಣ ವರದಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿತ್ತು. ಆದರೆ ಸದರ ಜ್ಞಾಪನ ಪ್ರಕರಣವನ್ನು ಸ್ವೀಕರಿಸಲು ನಿರಾಕರಿಸಿತ್ತು. ನಂತರ ದಿನಾಂಕ 22/12/2019 31/19 ಪತ್ರದ ಮೂಲಕ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ಜಾರಿಗೊಳಿಸಿ ಸಮಜಾಯಿಸಿ ಉತ್ತರವನ್ನು 3 ದಿನಗಳಲ್ಲಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿತ್ತು. ನೀವು ಸಮಜಾಯಿಸಿ ಉತ್ತರವನ್ನು ನಿಗದಿಯವರೆಗೆ ಸಲ್ಲಿಸಲಿಲ್ಲ. ನೀವು ಕ್ರಮದಿಂದ ಸಂಸ್ಥೆಗೆ ಅನಾವಶ್ಯಕ ಸಮಸ್ಯೆ ಪ್ರಕೋಪಕ್ಕೆ 32,24,000 ಆರ್ಥಿಕ ಹೊರೆಯಾಗಿರುತ್ತದೆ. ನೀವು ಸರ್ಕಾರಿ ನೌಕರರಲ್ಲಿ ತಕ್ಕದಲ್ಲಿ ನಡತೆಯನ್ನು ತೋರಿ ಬೇಜವಾಬ್ದಾರಿಯಿಂದ ವರ್ತಿಸಿ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮ 3 ಉಪನಿಯಮ 1 ಉಲ್ಲಂಘಿಸಿ ಶಿಸ್ತು ಕ್ರಮಕ್ಕೆ ಗುರಿಯಾಗಿರುವಿರಿ. ನೀವು ಸಂಸ್ಥೆಯ ಗಮನಕ್ಕೆ ತರದೆ ನ್ಯಾಯವಾದ ಸೇವತಿಯ ನಡೆಯುವರು ಸರ್ಕಾರಕ್ಕೆ ಸಂಸ್ಥೆ ಸಂಬಂಧಪಟ್ಟಂತ ತಪ್ಪು ಮಾಹಿತಿಯನ್ನು ಸಲ್ಲಿಸುವ ಸಂಸ್ಥೆ ಗಮನಕ್ಕೆ ತಂದು ಈ ಕುರಿತು ತಮ್ಮ ಮೇಲೆ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಿರುವ ತಪ್ಪು ಮಾಹಿತಿಯನ್ನು ಕೊಟ್ಟಿರುವ ಪ್ರಯುಕ್ತ ಸಂಸ್ಥೆ ಕೆಟ್ಟ ಅಭಿಪ್ರಾಯ ಬರುವಂತಾಗಿದೆ. ನಿಮ್ಮ ಈ ನಡೆದಿಂದ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಡತೆ ನಿಯಮಗಳು 66 ನಿಯಮ 1, 2, 3 ಉಲ್ಲಂಘಿಸಿರುವಿರಿ. ಸಹಪ್ರಾಧ್ಯಾಪಕ ಪ್ರಭಾವ ಆಗಿರುವ ನೀವು
what is the ground? On what ground you want to say the charge sheet is bad?
My lord, the law laid down by this court because your lordship may kindly see this is signed by the in-charge director. In-charge director, my lord, there are 3 judgments of this honorable court. One M. Marideva and then Dotrad.
Judgment really, according to you.
Because I have not committed any mistake. Only to.
What does your rule say as to who should initiate a proceeding against you?
My lord, they say that I have wrongly certified a patient to be mentally ill.
What is the legal? Your only legal ground is that the person who issued the charge sheet is incompetent.
Incomplete is one thing.
You tell me how is incompetent, which rule, who's the competent authority to issue a charge sheet?
My lord,
point, isn't it?
I take your notice, annexer C for a minute. Page 31.
Rules stores in first.
1 second. I forgot the book.
The institute. In institute rules is separate.
My lord, that has been produced.
Who's the competent authority? This person cannot.
Lord, they start from page 76.
Yes. These are by
controlling authority means in relation to A and B, the governing body, and relation to post C and D, the director. It is the
disciplinary authority.
Yes.
This is the rule.
My lord, controlling authority itself is the authority.
Yeah.
Page 76 may kindly be seen for a minute. My lord,
bylaw 21.
please,
Says it is the CCA rules.
please.
Show me from the CCA rules.
The service conditions regarding salary, age of supervision, conduct of district proceedings, and other issues shall have to be governed by the bylaws are framed and given effect to the existing provisions of KCSR rules shall continue to be applicable to mutatis mutandis as in this case of government servants.
ತೋರಿಸಿ ನಿಮ್ ಪ್ರಕಾರ ಯಾರು ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ ಅದರಲ್ಲಿ ಯಾರು ಮಾಡಬೇಕು ಅಂತ.
My lord, as I have submitted your lordships, it is the controlling authority.
What is your designation?
My lord, I am a medical superintendent, grade A post.
Medical?
Superintendent of the demands. To bring to your kind lordship's kind attention, the person who was an in-charge director for 7 long years wanted nobody to come to his chair. And when this particular petitioner was proposed to be promoted to the post, the next week he issues this show cause notice. Not until then. Adi ibbaru naduvin jagala. One. Insofar as Kalai Selvi is concerned, my lord, the whole proceedings are initiated. Even his opinion as to her fitness, my lord, this new act stipulates many conditions. New act stipulates constitution of a board headed by the learned district judge and the deputy commissioner and 2 other psychiatrists, etc.
Mr. Yadram, I only have to look at the competence of the person who issues the charge sheet, nothing more.
Yes.
Adana ತೋರಿಸಿ ಸಾಕು ನೀವು ನನಗೆ.
My lord, once again, I bring to your lordship's kind condition.
Page 19, page 119.
Please.
You are a group A post alone.
Yes.
So the appointing authority is a selection committee. The authority competent to impose penalty is the director. So if the
yes,
charge sheet is issued by the director.
In-charge director.
What difference it make?
In-charge director is only a temporary arrangement as per the law laid down by this honorable
Suppose
court.
there is no director according to you.
No, my lord. No. The law laid down on the point, my lord, is it is only a temporary arrangement and he can perform day-to-day functions and not statutory functions is the law. A judgment, my lord, for your lordship's kind consideration.
Judgment please listen to my question.
Please.
Suppose there is no director for 1 year or for 2 years.
Please.
So nobody can take the functions of the director?
No.
Nobody can issue a charge?
No. Because they don't have powers. They can run the institution on day-to-day basis. The man who comes as in charge.
Show me from the bylaws that the in-charge director cannot do the regular duties of a director.
No, that is the law laid down by the court.
You show me from this.
Bylaw nalli ಆ ಥರ ಏನೂ ಇಲ್ಲ.
Then he has the power. There is no bar under the bylaws or under the recruitment rules which say that in-charge director cannot do anything. You are governed by the rules. Rule says the director can impose penalties against you. There is no director, so therefore in charge director has been appointed, will issue a charge sheet. How can you say that it is?
1 minute. The charges are so hoax and bald.
That is not a matter for examination under 226.
Correct, my lord. See, when he approaches this honorable court, his replies on the point also have not been considered, and inquiry is ordered to be held is ordered already, and that is stayed by this honorable court. You know the judgments of this honorable court. May I request to have it on 22nd.
I
will get back to your lordships.
You can't get a stay of this.
I'll come back with the clarifications on the bylaws of the society. Since both these matters are connected with each other, for an opportunity to come back thoroughly. Second.
ಏನಿಲ್ಲ ನನ್ನ ಪ್ರಕಾರ.
ಇಲ್ಲ ಹೇಳ್ತೀನಿ 22nd. ಎರಡು ಹೇಳ್ತೀನಿ.
Sir, request on 20th, your lordship.
Madam, you'll have to make yourself convenient on the date that it is posted. Last time itself, we had told you that you should be ready.
Last time also we have told the lordship that today we have some inconvenience, your lordship.
20th,
22nd. Friday.
20th.
20th.
Grateful, your lordship.
Kalburgi bench matter. Bill number 1, Shri S.J. Mat.
In this matter, my lord, your lordship is directed to file the affidavit of the district officers, my lord. 2 districts information is received. So far as Raichur district is concerned, my lord, not received the information, my lord. Short accommodation may be given, my lord. We will file it that one also, my lord. That is the instruction by my colleague, my lord.
ಸಂಬಳ ಕೊಡ್ತೇನೆ ಅದನ್ನ.
Yes.
You are asked to file an affidavit alva?
Affidavit, my lord.
Once again, a request is made for grant of time to comply with the orders dated 21/9/2024 and 25/9/2024. As a last chance, time is granted till to comply with the orders and filing of necessary affidavits.
15. Seal number 2, Shri Jagash Shetty. Council.
My lord, in this, my lord, the other day, my lord, they have given the vacancy position. We also agree, my lord, one associate professor and ಎರಡು assistant professor ಅಂತ ಎರಡಿದೆ. That I think will suffice the whole.
Who is opposing you?
My lord, council ಅವರು, I think is a Gulbarga Hibishin for
Serial number 2, Kalburgi bench matter.
In fact, ತಮ್ದು BJ Rani case, my lord, where Rangna Joyce argued, according to me, covers the whole issue. Rani ತಮ್ಮ matter heavy ಮಾಡಿ last put recollect, my lord. ಅದೇ 2 decades they had worked, my lord, the Kims ಇದ್ರದ್ದು. You can see that, of course. Yeah, I have read that, my lord. It is no more, everything, my lord, is covered in that.
Sudarshan.
Communication ಅದೇ ಇದು.
Kalburgi bench matter, Shri Sudarshan M, serial number 2.
Please, my lord.
ಏನಾಯ್ತು? ರೆಡಿನಾ?
My lord, government has filed, my lord, detailed, my lord, as advised by my lord. My lord, regarding, my lord, sanction post and, my lord, vacant post.
That is serial
The
number
memo,
3.
my lord,
Serial number
1410,
2.
it appears, my lord, that, my lord, principal secretary is
ಮೆಮೋ ಹಾಕ್ತಿದಾರಲ್ವಾ?
16/10/2024.
1410, my lord, I'm sorry. A memo may be, my lord, some other date, but the letter which has been, my lord, addressed to, my lord, government advocate, it appears 1410, my lord.
ಏನ್ ರೆಡಿ ನಾವೀಗ?
My lord, other side, if, my lord, ready, my lord, then,
you are ready.
yes.
Almost ಎಲ್ಲ ಈಗ ಪ್ಲೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಯ್ತು their own saying as per their own saying.
Ready na?
But I have
Vacancy
not, just
question.
only information your lordship is directed us to furnish, my lord. That information is submitted to for lordship, my lord. What is the vacant post and sanction post?
No, are you ready
Chart
or
of-
not?
Pardon,
Are you ready for the final disposal or not?
and my colleague is appearing, my lord. Today, my lord, she is inconvenient, my lord, she is not appear before lordship, my lord, for that is reason. Lordship at 15th, my
Yes,
lord.
my lord. Srimati Aarti Patil appearing. Ma'am. She is throughout, my lord, this matter. She has, my lord, knowledge about this matter.
ಇನ್ ಬರ್ತಾರ ಬರಲ್ಲ ಅವರು?
ಇಲ್ಲ appear ಆಗ್ತಾರೆ.
ಮಂಡೇ ಇಲ್ಲ
ಅಲ್ಲ ಮಂಡೇ ಆಗಲ್ಲ. 15th your lords, another matter is there, my lord.
15th ನನಗೆ 15th I am at Dharwad in
You choose a date. If you are convinced.
after 19th any day.
22nd.
After 19th any date.
22nd.
22nd I will.
Published.
And my lord,
Please.
in the meanwhile, my lord, I shall give all dates, because everything is over. Your lordship had asked them, my lord, regarding vacancy position, they have already supplied. We are satisfied with that, my lord, and it is a clear case for 2 decades, more than 2 decades work. Rani case, if your lordship permits me, I will make it part of the record, I will give it copies. Court of Rani case. This exactly covers the issue. Your lordship statement. Illunu more than 2 decades, they Kimsu, the lordship would recollect, my lord. Rangana Joyce had argued and very hotly contested, but ultimately lordship said, 20 ವರ್ಷ ಆದ್ಮೇಲೆ ನೀ ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅಂತ ಹೇಳಿ lordship said.
ಅಪೀಲ್ ಹಾಕಿರಲ್ಲ ಗೊತ್ತಾಗ್ಲಿಲ್ವಲ್ಲ ಅಂತ.
ವಿಜಯ ರಾಣಿ ಅಂತ. Very good.
Bill number 3. Ganesh.
Published. Much up.
Appearing for petitioner, my lord, IA for amendment. Seeking amendment in writ petition is filed on 14th October, that is not put up.
State that an application amendment is filed. Office.
My lord, may I make one request, my lord? Interim order, whatever is there, has to be continued.
ಇದೆಯಾ?
Ittu ಅದಕ್ಕೆ it was very much there.
Okay, what if I need to continue?
Grateful.
Bill number 4. Mahantesh Patil.
Much obliged.
Number 4. Mantesh Patil.
Silver further hearing, silver 5. Harshvardhan.
Appear for the appellant.
Yes, sir. Sure.
Lord, yes, my lord. This was an issue, my lord, regarding, my lord, the check which was issued for payment of premium had bounced, my lord. They issued, my lord, they claim that
This
they
matter,
have
my lord,
intimated.
Advocate appearing for R1 is no more, my lord. Rajshekar, Rajkumar
Yes.
Parwar.
Korbar,
He's
my
passed
lord,
away, my lord.
appearing for the owner.
Recently, 15 days back, my lord,
20 days back.
due to cancer.
Court notice ಆಗ್ಬೇಕಂಗಾರೆ?
My lord, I am seeking that, my lord, this liability should go on the insurance. My lord, if that is the case, my lord, there might not be a necessity. Lord, I based my, Lord, arguments on one of the judgments, Lord, which says that insofar as the check bounce is concerned or non-payment of premium is concerned, Lord, I relied on, Lord, Oriental Insurance versus Inderjeet Kaur Supreme Court judgment, which says that, Lord, the third parties will not be affected.
ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ನೀವು ಹೇಳಿದ್ದು? Oriental.
Oriental Insurance versus Inderjeet Kaur, my lord. This is holding the field, my lord, as on today.
ಏನ್ ಸುಭಾಷ್? ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Unmute ಮಾಡ್ಕೊಳ್ಳಿ.
Malapur sir, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಅನ್ಮ್ಯೂಟ್ ಅವರು.
ಸರ್ ಸುಭಾಷ್ ಮಲ್ಲಾಪುರ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಸುಭಾಷ್ ಅವರೇ, you are muted. You'll have to unmute yourself. ಇದೇನ್ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ವಾ ಹರ್ಷ?
Sir, mic button you may have to press, sir. Malapur sir. Audio mic ante ಲೆಫ್ಟ್ ಸೈಡ್ ಬಾಟಮ್ ಅಲ್ಲಿ. left side bottom.
Next week ಹಾಕೊಳ್ತೀನಿ ಅವ್ರಿಗೆ ಹೇಳಿ ಹಂಗಾರೆ.
ಆಯ್ತು ಸ್ವಾಮಿ.
15th.
We'll sit together and argue, my lord. Pleasure.
With my lordships kindly,
Yes.
serial number 1, my lordship, authorized.
Serial number?
1, my lordship, Kalburgi list. Serial.
15th.
Please.
ಇಲ್ಲ ಇರ್ಲಿಲ್ಲ ಅವ್ರ ಹೆಸರು ಅಂತ ಇರ್ಲಿಲ್ಲ.
ನಾನೇ ಪ್ರಶ್ನೆಗೆ ಅಪೇರ್ ಆಗಿದೆ.
ಚೆಕ್ ಮಾಡಲ್ಲ ಬ್ರಾಂಚ್ ಅವರು. ಇವಾಗ ಅದೊಂದು ತರಿಸಿದೆ ಅವರು ಇದು ಮಾಡಿಸಿ ಬಂದಿಲ್ಲ. ಪೋಸ್ಟ್ ಮಾಡಕ್ಕೆ ಒಂದ್ಸತಿ ಚೆಕ್ ಮಾಡ್ಬೇಕು. ಎ ಫಾರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೊಡ್ತೀನಿ 10 ಅಂತ ಆಗಿದೆ. ಆಫೀಸ್ದು ಆಫೀಸ್ ಕೋರ್ಟಲ್ಲಿ ಆಕ್ಟ್ಗಳೇ ಇಲ್ಲಪ್ಪ ಸರಿಯಾಗಿ. ಜರ ಆಗ್ಬಿಡ್ತದೆ ಆಕ್ಟ್ಗಳಿಲ್ಲ ಅಂತ. ಕ್ವೆಶ್ಚನ್ ಕಳಿಸಿ ಹಾಕಿದಾರ ಕಾರ್ಡ್ ಅಲ್ಲಿ. ಹಾ 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 ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಹೋಗಿ ಲೈವ್ ಲೊಕೇಶನ್ ಕಳ್ಸಿ ಅಂದೆ. ಇದ್ರೆ ಅದು ಆರಾಮಾಗಿ ಹೋಗ್ಬಿಡ್ಬೋದು. ಅಂದ್ರೆ ಅದೆಲ್ಲ ಸಣ್ಣ ಸಣ್ಣ ರೋಡ್ಗಳು. ಅವಾಗ ಒಂದ್ಸತಿ ಹೋಗಿರೋದು 2 ಸತಿ ಆ ಕಡೆ ಎಲ್ಲ ಗೊತ್ತಾಗಲ್ಲ ನಮ್ಗೆ. ಒಂದ್ಸರಿ ಅಭಿಷೇಕ್ ಕೊಟ್ಟಿದ್ದೀನಿ.